Hello.
ರಾಬರ್ಟ್ ಹೆಂಗ್ ಕಳಿಸ್ತಾ ಇದ್ದೀರಾ ಈಗ?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್,
ಹೇಳಿ ಸರ್.
ಆಡಿಬಲ್ ಇದೀನೋ ಇಲ್ವೋ ಅಂತ ಚೆಕ್ ಮಾಡಿದೆ ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು. ಆಡಿಬಲ್ ಇದೀನೋ ಇಲ್ವೋ ಅಂತ ಚೆಕ್ ಮಾಡಿದೆ. ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್. ಹೇಳಿ ಹೇಳಿ, ಬರ್ಬೇಕು ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ. ಹ್ಮ್ ಇಲ್ಲ ನೀವು ಹ್ಮ್ ಓಕೆ, ಕೇಳಿ ಹೇಳ್ಬಿಡಿ ಸಾಹೇಬ್ರಿಗೆ. ಇಷ್ಟ ಇಲ್ಲೆಲ್ಲೂ ಇದೆ. ಅದು ಸರ್ವಿಸ್ ಕೊಟ್ಟಿದಾರಂತೆ. ಕೊಡ್ತೀನಿ, ಸರ್ವಿಸ್ ಕೊಟ್ಟಿದಾರಂತೆ ಅದು ಪ್ರಿಂಟರ್. ಅದಕ್ಕೆ ಇದಲ್ಲ. ಯಾವುದು? ಅದೇ ಸರ್ವಿಸ್ ಕೊಟ್ಟಿದೀನಿ, ಅದನ್ನ ನಿನ್ನೆ ಬಂದ್ರೆ ಹಾಕ್ತೀನಿ ಅಂದ್ರು. ನಿನ್ನೆ ಬಂದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಹೇಳ್ದೆ ತಕ್ಷಣ ಅದು ತಗೊಂಡೋಗ್ ತುಂಬಾ ದಿನ ಆಗಿರ್ಬೇಕು. ಅದು ತಗೊಂಡೋಗ್ ತುಂಬಾ ದಿನ ಆಯ್ತು ಅನ್ಸುತ್ತೆ. ಆ ಕೋರ್ಟ್ ಇದ್ದಾಗ್ಲೇನೆ ತಗೊಂಡೋಗಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಎಲ್ಲ ಕೋರ್ಟ್ ಕೊಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ. ಇವರೆಲ್ಲ ಸರ್ವಿಸ್ ಅಷ್ಟು ಬೇಗ ಮಾಡಿಸ್ತೀವಿ. ಹಾಫ್ ಡೇ ಅಷ್ಟೇ, ಹಾಫ್ ಡೇ ಅಷ್ಟೇ ನಾನು. ಬಂದಿಲ್ವ ಇನ್ನ ಕೊಟ್ಟಿಲ್ಲ. ಏನು
2022 ಫೈಲ್ 2000 ಲಿಸ್ಟ್ ಆಗಿತ್ತು ರೀಚ್ ಆಯ್ತು ಅಡ್ಮಿಷನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮೇಲೆ
3 years of practice, not one RSS. It is pertaining to pension matter. Pension, exhibition. Therefore, date will be good. Kindly be dates.
2019 RSM not for admission.
Admission 24 my lord, fresh matter admission 24. ಅದು ಅವ್ರ ಏನಾಗಿದೆ ಅದನ್ನ ಸ್ಕೆಚ್ ಮತ್ತೆ ಬೌಂಡ್ರಿಗೆ ಹಾಕಿದ್ದಾರೆ. ಡೈವರ್ಜೆಂಟ್ ಫೈಟಿಂಗ್ 2023 ನೋಟಿಸ್
ಯಾವ ವರ್ಷದ ಅಪೀಲ್
23 appeal my lord. FTP has been filed my lord. This court notice has been issued because they were in
fresh matter for admission, 23. 23 this one. There is a trying to alienating the social properties.
steps.
Board admissions 2018.
Serial.
Page number cut. Mentioning from page number 11, 33 to 36, 37 to 42.
Lordship, serial number 36, Lordship, kindly, in case of respondent advocate Rakshit Joy's name kindly be deleted, Lordship, because K. Prasad 36, Lordship. In cost list, they are showing Rakshit Joyce as respondent advocate. Kindly his name might be deleted, Lordship. In respondent, Lordship. RSA 37.
Rakshit Joyce.
Rakshit Joyce.
Appellate.
Lordship, ಅವ್ರದ್ದು ಹೆಸರು delete ಮಾಡಿ, Lordship. He is not representing the case. K. Prasad Hegde, he is representing, Lordship. No, he was working in a senior office, Lordship, later, earlier. Hence, his name was carried forward. Right now, Prasad Hegde is taking up the case, Lordship. Much obliged, Lordship.
37 to 42, 43 to 49.
47 for appellate. 47. Devraj filed NOC Wakalat was not put up. Kind of thing. Filed by Devraj for appellate.
Yes, Raj.
So he given NOC to the Devraj. That Wakalat was not put up.
ಯಾವಾಗ ಹಾಕಿದ್ದಾರೆ ಗೊತ್ತಲ್ಲ, ಪೇಪರ್ಸ್ ಇರುತ್ತಲ್ಲ.
Before vacation.
For vacation. ಇವ್ರು ಹೆಸರಾಜನು ಎನ್ಒಸಿ ಕೊಟ್ಟಿದಾರಾ?
Yes, Raju and ಇನ್ನೊಂದು ಕೊಟ್ಟಿದ್ದಾರೆ.
24 ಗಂಟೆ ಬಂದಿದ್ರು. ಮತ್ ನಂತರದಲ್ಲಿ ಹೆಸರಾಜು ಅಂತ ಎನ್ಒಸಿ ಹಾಕಿದ್ದಾರೆ. ಮತ್ತೆ ಎನ್ಒಸಿ ಹೆಸರಾಜನು ಕೊಟ್ಟಿದಾರಾ?
ದೇವರಾಜ್ ಅವರು. ಇನ್ನೊಂದು
ದೇವರಾಜ್ ಅಂತ
ದೇವರಾಜ್ ಈಗ present.
ಈ ಪ್ರಾಕ್ಸಿನ
Practice.
the proxy council submits that council see again Devaraj.
ದೇವರಾಜ್ present.
Initial ಎಲ್ಲ ಇದೆಯಾ?
ದೇವರಾಜ್ RV.
Devaraj
RV.
RV expelled Vakal. With NOC from S Raju during the vacation,
Before vacation.
before the vacation, and hence this is directed to sub the same and show the name of the council for appellant and discuss matter on 13/6.
Lordship, serial number 48, my lord. I appear for the appellant. Lord, I have informed my learned friend, Mr. Gopal's colleague, he's here. Lord, kindly have it next week, Lord, some difficulty with my file, Lord, today.
So the appellant council sees that and council respondent also says objection. This matter on 13/6.
Please.
Number 57.
My lord.
Sure.
50
Page.
to 53.
53, my lord, I am for the appellant. 1 week time may be granted.
Other side intimates ಮಾಡಿದಿರಾ?
I will inform.
ಮಾಡಿ first ಮಾಡಿದ್ಮೇಲೆ submission ಮಾಡಿ.
My lord, serial,
ಈಗ ಈಶ್ವರ್ ಭಟ್ ಅದು ಅಂತಾನೆ. Other side intimate ಮಾಡಿ then
My lord, serial number 52, my lord. My lord, I am for the appellant. I pray for 2 weeks time, my lord. I have informed the other side, my lord.
ಶೆಟ್ಟಿ ಅವರು
ಮಾಡಿದೆ.
council for R8 and this matter of 13/6. Already 2018 matters ನಾವೇ admission seat post ಮಾಡಿಸ್ಕೊಂಡು ನೀವು ಬಂದು after 6 years time
My lord,
ನಾವು ಓದ್ಕೊ ಬರ್ತೀವಿ ಫೈಲು ನೀವು ಬಂದು ಬೆಳಗ್ಗೆ ನಿಂತ್ಕೊಂಡು ನೀವು ಟೈಪ್ ಕೇಳೋದು ಬಿಟ್ರೆ ನಾಚಿಕೆ ಆಗಲ್ಲ 6 ವರ್ಷದ ಮೇಲೆ
next time, my lord, I will do it, my lord.
ಏನ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ರೀ ಅದಕ್ಕೆ ನಾನು ನಿನ್ನೆ ಮೊನ್ನೆ ಕೊಡ್ಲಿಲ್ಲ ಮತ್ ದಿನ ಬೆಳಗ್ಗೆ ಏನ್ ಬೈಯೋದು ಅಂತ ನಾನು ಅದಕ್ಕೆ ಈ ಮ್ಯಾಟ್ರಸ್ ನೋಡ್ ಮುಖನೇ ನೋಡಿಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ನಾವೇ ಹಾಕ್ಸ್ಕೊಂಡಿದೀವಿ 6 ವರ್ಷದ ಮೇಲೆ ಅಡ್ಮಿಷನ್ ನೀವು ಬಂದು ಬೆಳಗ್ಗೆ ನಿಂತ್ಕೊಂಡು ಟೈಮ್
54 to 61.
Serial number 55, my lord.
ನಂಬರ್
Serial number 55, my lord. My lord, I pray for a week's time, my lord. Today I am not feeling well, my lord. Serial number 55, my lord.
this matter
13/6.
serial number 57, my lord.
Much of it.
Next week, any day.
other side ಹೇಳಿದಿರಾ ರಮೇಶ್
ಅದೇ.
ನೀವೇ
ಇಲ್ಲ, I am for the appellant, my lord. Inform ಮಾಡ್ತಾ ಇದ್ದೀನಿ, inform. ಇದು ಕೇವೇಟರ್ ಮೇಲೆ. ಇನ್ನು ಹೇಳಿಲ್ಲ, ಅದು inform.
ಹೇಳಿದ್ಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡಿ
62 to 66.
Serial number 64, my lord. I am for the appellant. I have informed the other side, my lord. Call after 2 weeks, my lord. Some inconvenience.
2018
The senior counsel is assisting today, has got some inconvenience. ಇವತ್ತು ಬಂದಿಲ್ಲ ಅವ್ರಿಗೆ inconvenience. Other side, I have informed that.
also submitted, he has already informed council Ganesh Bhatt YH and he also says no objection. Hence, this matter.
13/6.
13/6, right.
67 to 69. 70 and 71.
That 70, serial number 70, appear for the appellant. I informed Mr. Chittappa also, my lord, your last may kindly call this any day after Monday. I have informed Mr. Chittappa also, who is appearing for the response. Your last may kindly call this any day after Monday. I am not keeping well today, my lords. Your last may kindly extend the interim order.
Well, and also submitted, he has already informed the council for R1. Hence, this matter on 13/6.
Lordship, serial number 71, my lord.
Interim order may kindly be extended, my lords. Interim order may kindly be extended in serial number 70.
Every time you comes and 6 live and 6 for an.
Lord, your lordship's microphone is not working properly. Your lordship is not audible. Off ಆಗಿರ್ಬೇಕು microphone.
Serial 71, my lord, I appear for a respondent. Prithvi Vadiyar,
Vadiyar.
mother is passed away last week, my lord. He is in native, my lord.
ಈ GM ನಟರಾಜ್ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ?
Inform, my lord.
ಮಾಡಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಆಮೇಲೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
May I make a request, my lords?
Already given time council 13/6.
Yeah, so 70, my lords, 70.
7th
70.
ಏನ್ 70?
ಅವರು ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ತಾರೆ.
Serial number 70.
70ನೇ ಕೊಟ್ಟಿದ್ದು ಡೇಟ್ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೆ 70ಗೆ.
ಅಲ್ಲ, ತಮ್ಮ ವಾಯ್ಸ್ ಕೇಳಲಿಲ್ಲ ನನಗೆ, ಅದಕ್ಕೆ ನಾನು ಸಬ್ಮಿಟೆಡ್. That microphone was switched off.
13/6 council.
Please, my lords. Your last may kindly extend the interior order also, which has been granted earlier.
Entry mod also extended.
Orders matter
Please.
serial number
Lord,
1.
I'm sorry, my lord, may I make a mention, my lord? Serial number 44, my lord, I am appearing for the response. I'm personal inconvenience today, my lord. I have informed.
44
Oh, sir.
ಕರ್ಸಿದ್ವಲ್ಲ ಪೇಜ್ ವೈಸ್.
I have informed the learned advocate for the appellant also.
ಶಿವರಾಮ್ ಭಟ್ಟಾರ ಇಲ್ಲೆಲ್ಲ ಇದ್ರಲ್ಲ.
Next week ಅಲ್ಲಿ ಹಾಕೊಂಡೆ sir. I have to
ಡಿಗ್ರಿ
move.
ಆಗಿದೆ, ಮಾಡಿಫೈ ಆಗಿದೆ, ರೀಫಂಡ್ ಮಾಡಿ ದುಡ್ಡು ವಿತ್ 12% ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ
ಹೌದು.
ಮಾಡಿದ್ದಾರೆ.
I am for the defense.
ವೈ ವಾಂಟ್ ಟೈಮ್?
Today, my lord, I am having some personal inconvenience. I have to move to native, my lord.
Respondent counsel seeks time and counsel for the appellant is also present and says no objection. List this matter on 13/6. ಮತ್ತೆ ನೀವು ಸುಮ್ಮನೆ ನಿಂತ್ಕೊಂಡ್ರೆ ನಾವು ಅದು ಅಂಡರ್ಸ್ಟುಡ್. You are also saying no objection ಅಂತ. ಹೌದಿಲ್ಲ? 13/6 ಆಯ್ತು. 13/6
Instead of
date ಕೊಟ್ಟಿದ್ದೀನಿ.
13/6, 10/6, 13/6.
ಜಾಸ್ತಿ ಹಾಕಿದೀವಿ ಅದಕ್ಕೆ.
ಅಲ್ಲ, ನಾನು I am on medical leave after 12th, my lord. 2
After
weeks.
12th ಆಯ್ತು 10/6.
10/6.
This matter serial number 1.
Saying for petitioner, my lord.
This, I appear for the,
Say 1 for 24 for impleading.
I am for the impleading applicants, my lords. In this matter, what has happened? Ancillary probate came to be granted by this honorable court. I claim that I have purchased these properties. Therefore, I have sought for cancellation of the ancillary probate, my lord. This honorable court pleased to grant that relief, and I was directed to be impleaded in these proceedings, my lord. This is the order of this honorable court. Without impleading me, though there was a suit pending,
ಈಗ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ನೀವಾ?
ಅವರೇ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ.
ಇವಾಗ ಡೈರೆಕ್ಷನ್, pursuant to direction of this honorable court. Page number 25, my lords.
ಅಲೋ ಮಾಡೋಣ.
ಅಲ್ಲೇ ಮಾಡ್ಬೋದು.
Just the appellant counsel, petitioner counsel and also the impleading ನೀವಾ?
ಹೌದು.
ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ರಿ ಈಗ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ ನಾವು ಆಕ್ಚುಲಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ ಬೇರೆದು. ಫ್ರೆಶ್ ವಕಾಲತ್ ವಿ ವಿಲ್ ಫೈಲ್, my lords.
ಅಲ್ಲ ರೀ, ಇದ್ರಲ್ಲಿ ನೀವು ಈಗ ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ನಮ್ದಲ್ಲ, ಅದು ಅವ್ರು ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್.
ಅವ್ರು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
ಈಗ ನೀವು ಈಗ ಪ್ರಪೋಸ್ಡ್ ಇವರಿಗೆ ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ರೆ
ಹಾಕ್ತೀವಿ ಸ್ವಾಮಿ, ನಾವು ಹಾಕಿಲ್ಲ.
Petitioner counsel has filed IA 1/24 for impleading in view of direction given in probate CP number 23 of 2019 connected with probate number 25 of 2019. And counsel for the proposed impleading respondent ಅಲ್ಲ ನೀವು ಕೇಳಿರೋದು? Impleading respondent. Impleading respondent. Mr. ಏನ್ ಹೆಸರು ನಿಮ್ದು?
ನಮ್ದು
ಗುಡ್ ನೇಮ್?
ಶ್ರೀಹರಿ AV, my lords.
ಶ್ರೀಹರಿ.
ಶ್ರೀಹರಿ AV
Undertakes to file wakalat for impleading respondent.
Yes, ma'am.
ಹೌದಲ್ಲ?
ಹೌದು.
Respondent. In view of already given direction to implead him as party in the above proceedings. And for the reason stated in the accompanying application, IA 1/24 is allowed. Petitioner counsel is directed to amend the cast title. And if wakalat is filed by the counsel Srihari, to show the name of the counsel in the cast list for respondent.
Respondents, 4 respondents.
ಎಷ್ಟು?
4 ಜನ ಇದೆ.
4 ಜನ
ನಾಲ್ಕು
ಇದ್ದಾರೆ
ಜನ.
for respondents.
Respondents.
Connected with ಅದರಲ್ಲೂ ಇದೆಯಾ?
ಅದರಲ್ಲೂ ಇದೆ.
ಎರಡು ಸೇಮ್ ಅಲ್ಲ?
Same.
ಆಯ್ತು. This matter on 13/6.
One more week, my lord, because we will file detailed objections. One more week ಕೊಡಿ.
ಆಯ್ತು, ಕೊಡಿ, ಡೇಟ್ ಕೊಡಿ. ಇನ್ನೊಂದು ಬೇರೆ ಮೇಡಮ್ ಡೇಟ್
18/6.
18/6.
Much obliged.
Serial number 2. Unmarried Greek.
I appeal for the petitioner in this case, my lord. This is a petition for letters of administration with the will annexed, and the petition was filed
Madam,
by.
verifying affidavit dated 27/10/23.
Your honor, the
Being
matter
not
was,
pressed by
it
counsel.
was allowed, the first verifying affidavit was filed.
You
by
are
the-
not pressing that.
That one, I
verified
have filed a second one on, in June, in January 24, my lord. Actually, the petition was allowed in 23 itself, and it was pending for judgment to be uploaded. At that time, they raised an objection that verifying affidavit was not filed. So subsequently, I had filed the verifying affidavit. In fact, all the compliance has been completed in this matter. It was allowed.
It was reserved in 23.
Yes, my lord.
Ah,
And because of verifying affidavit, it was called again by the.
once again called.
Yes, my lord.
Told.
I have filed the verifying affidavit of the.
Told.
GPA.
Petitioner counsel submits that verifying affidavit filed dated 27/10/23 is not pressed. The counsel also submits that the fresh verifying affidavit is filed on 2/1/24 and the same is taken on record.
Now it has to be proceeded for judgment. The petition has already been allowed. It was only for this verifying affidavit that it was put up again, my lord.
How could it be, madam?
Yes, my lord. It had.
The
it was-
petition is allowed.
Yes, my lord. In June, July of twenty
With a
twenty-three.
condition to file,
No, it was.
a condition
posted-
to file verifying
It was
affidavit.
allowed and it was posted for judgment. And prior to judgment, it was
How
called
can it
again.
be, madam, allowed and
My lord,
posted for
the order
judgment?
sheet may
I
be
don't
put-
understand your submission.
The order
Allowed
sheet-
and posted for judgment.
The order sheet may be looked at in June 21,
Yeah,
23, my lord.
23. On what date?
June, July 23, my lord, 2023.
2023 July.
Yes, my lord. June, July it was.
Hmm?
Subsequently, an affidavit has.
July
been-
23 and ನೋಡ್ರಿ. Huh? Being spoken stone ಹೆಂಗಾಗ್ತದೆ? Dispose ಆಗಿದೆಯಾ ನೋಡಿ ಹಿಂದೆ? Being spoken to ಮತ್ತೆ ಹೆಂಗಾಗ್ತದೆ? ಅದೇ ಹಿಂದಿನ ಆರ್ಡರ್ ಕೊಡಿ ಮೇಡಮ್. Petition is allowed ಅಂತ. ಹಾ. ಮತ್ತೆ ಪೋಸ್ಟ್ ಆಯ್ತು ನೋಡಿ ಇದು?
Verifying
Orders on being
affidavit, my lord.
spoken to ಅಂತಿದೆಯಾ? ಏನದು? ಮತ್ತೆ ಆರ್ಡರ್ಸ್ ಆನ್ ಐ ಅಂತಿದೆ.
Verifying affidavit. I will briefly run through the matter, my lord, for your.
Allowing of the order is recalled, madam.
Okay, madam.
Recalled.
Verifying affidavit has been
When the
filed
matter
now.
was posted for orders on for being spoken to, it was recalled. Now matter has to be heard.
Yes, my lord. The petition, if you are
Post the matter on 13/6.
much obliged.
Serial number 3, GR Mohan.
Non-compliance of office.
I will do it in the reports of the industry.
Counsel submits that in the course of the day would comply with office objection.
On Monday or because.
Post this matter on 13/6.
I'll do it to the.
Course of ಮಾಡ್ರಿ permitted.
Because amount deposit ಮಾಡಿದ್ದು already 3 lakh already I deposit before court.
Counsel, you have been permitted to comply with office objections. List this matter on 13/6.
Please. Okay.
4, Sandhya D.
They are D.
Steps for respondent, but steps are taken today, my lord. For respondent matter is written is not claimed.
Not claimed ಅಂತ ಯಾವಾಗ ಆಗಿದ್ದು? R9 ಗೆ. Intimation ಹೋಗಿದೆಯಾ ನೋಡಿ? ಹೋಯ್ತು. ಹ್ಮ್. 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 Subsequent ಆಗಿ. ಡೋರ್ ಲಾಕ್ಡ್ ಅಂತ ಬಂದಿದ್ದಾರೆ, ರಿಟರ್ನ್ ಆಗಿ ಬಂದಿದೆ. ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಫ್ರೆಶ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ.
Please,
ಆಗ ಡೋರ್ ಲಾಕ್ಡ್ ಅಂತ ಬಂದಿದೆ.
Please,
You have to take steps.
please 4 and 12, I took the steps, my lord.
Steps ತಗೋಬೇಕು. R4, 9 and 12.
Please, my lord. 4 and 12 ತಗೊಂಡೆ 9 ಗೆ I will take in and tomorrow, my lord.
4 and 12 ಗೆ ಇವತ್ತು ತಗೊಂಡಿದ್ದಾರೆ.
ತಗೊಂಡ್ಬಿಟ್ಟೆ because I have
Counsel
that.
submits that he has paid the pay of to issue notice against R4 and R12 and directed to pay the PF in respect of R9 also
Please.
today itself.
No, my
The
lord.
PF paid, issue notice against R4, R9 and R12. ಎಲ್ಲರಿಗೂ ಕೊಡಿ.
Please.
1 to 4. ಅದು 1 to 4 ಅದು ಬ್ರೇಕಪ್ ಡಾಟ್ ಹಾಕಿದ್ದಾರೆ 1 to 4 ಮೇಡಮ್. ಈಗ 1 to 4 ತಗೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಬರೀ 4-12 ತಗೊಂಡ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ
4 and 12 ಮಾತ್ರ ತಗೊಂಡಿದ್ದೀರಾ?
ತಗೊಂಡಿದ್ದೀವಿ ಹಾ ಸರ್.
ಆಗಲ್ಲ.
ಬೈ ಮಂಡೇ ಐ ವಿಲ್ ಪೇ
the PF to issue notice to R4 and 12. And the notice even not served against R1 to 3 also, and hence directed R1 to 3 as well as R9.
Please.
And hence directed to pay the PF within 2 days.
ಪ್ಲೀಸ್
If paid, issue notice against R1 to 4, R9 and R12.
ಪ್ಲೀಸ್ ಒಬ್ಲೇಶ್
5. Maitre Krishnan.
Issue notice to respondent regarding admission as per order dated 24 to, ಹೇಳ್ರಿ. PF ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲ as per order 24 to 24 ಪ್ರಕಾರ? ಕೊಟ್ಟಿಲ್ಲ. ಏಕೆ? ಮತ್ತೆ ಈಗಲೂ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಕೊಡಿ ಇವ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ, ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. 2018 notice was ordered in February 24. Even in spite of it, you have not paid the PF. Nagaraja RC R1, R4 and R5 ಇದೆ.
I am appearing for.
ಮತ್ತೆ ಇನ್ಯಾರಿಗಿದು?
Where is 2 and 3, 4 ಇದಾರೆ. 2, 3 ಇದಾರೆ.
Sir, 1 to 4, 2 and 3. Sir, 1, 4 and 5.
1, 4 and 5 ಆಲ್ರೆಡಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್.
2 and 3 ಹೋಗಿದೆ sir.
ಬಟ್ 2 and 3 ಇದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ ಮೇಡಮ್, ಯಾರಿಗೆ ಅಂತ ಇಲ್ಲಿ PF?
ಇದು ಹೇಳಿಲ್ಲ. 2 and 3 and 6 ಅಷ್ಟು ಜನನು ಇದ್ದಾರೆ. 2, 3 and 6.
ಈಗ 2, 3 and 6 ಆಗ್ಬೇಕಾ?
ಹೌದು.
ಇದನ್ನ ನೀವೇನ್ ಕೋರ್ಟ್ ಈ ಬೋರ್ಡ್ ಬ್ಯಾಂಚ್ನವ್ರೆ ನಾವೇ ಓದ್ಕೊಂಡು ಕೋರ್ಟ್ನವ್ರೆ ಮಾಡಿ ಅಂತಾನ? ಏನ್ ಜಾಸ್ತಿ ಮ್ಯಾಟ್ರ್ ಹಾಕ್ಸಿದಾರೆ ಸಾಹೇಬ್ರು ಈಗ ಅಂತ? ಯಾಕೆ ಹೇಳಿಲ್ಲ 2, 3, 6 ಅಂತ? ಇದು PF ಕೊಡ್ಬೇಕು ಅಂತ ಇದೆಯಲ್ಲ, ರಿಗಾರ್ಡಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಬರ್ದ್ಬಿಟ್ರಿ ಇಲ್ಲಿ. ಈಗ ನಾನು ರೈಟ್ ಸೈಡ್ ನೋಡಿಲ್ಲ ಅಂದ್ರೆ ಈಗ ಎಲ್ಲರಿಗೂ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ನೋಡಿ ಯಾಕೆ PF ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ರೀ? 24 to 24 ಲೇನಾ? ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಅಡ್ಮಿಷನ್ ಅಂತಿದೆ. The council undertakes to pay the PF today itself in the office and hence issue if PF paid during the course of the day, issue notice against 2, 3, 6. Entry matter extend ಮಾಡೋದಿಲ್ಲ. Why you are not paid the PF after obtaining the entry matter? ಮೋಸ್ಟ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್. R1, R4 and R5 ಮತ್ತೆ ಅಪಿಯರ್ ಆದ್ರು
ಅವರು ವಕಾಲತ್
ಕೊಟ್ಟು ಮೋಸ್ಟ್ಲಿ ರಿಟರ್ನ್ PF ಕೊಟ್ಟೇ ಇಲ್ವಾ ಅಥವಾ ಏನು? ಬೇರೆಯವ್ರಿಗೂ ನೋಟಿಸ್ PF ಕೊಟ್ಟಿರ್ಬೇಕು ಅವರು. ಮತ್ತೆ ಇವ್ರು ಹೆಂಗ್ ಅಪಿಯರ್ ಆಗ್ತಾರೆ? R1, R4 and R5 ವಿತೌಟ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ವಾಲಂಟ್ರಿ ಹಾಕಿದಾರ. ವಾಲಂಟ್ರಿ ಹಾಕಿದ್ರೆ ಇಲ್ಲಿ ತೋರಿಸ್ಬೇಕಲ್ಲ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ವಕಾಲತ್ಗೆ. ಆಯ್ತು ಬಿಡಿ, ಎಲ್ಲ ನಮ್ಗೆ ಟೈಮ್ ವೇಸ್ಟ್ ಇಲ್ಲ, ಎಲ್ಲ ನೋಡ್ತಾ ಕೂತ್ಕೊಂಡ್ರ. 2, 3, 6 ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋದಿಲ್ಲ. ಇನ್ಮೇಲೆ ಯಾರ್ಯಾರು ಎಂಟ್ರಿ ಮಾಡ್ರು ತಗೊಂಡು PF ಕೊಟ್ಟಿರಲ್ಲ ಯಾವ್ದ್ರಲ್ಲೂ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಲ್ಲ. ಆಯ್ತು, ನೋ ಕಾನ್ಸೆಪ್ಟ್ ಕೊಡೋದಿಲ್ಲ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋದಿಲ್ಲ. 2018 ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಆಗಿದೆ ಯಾವಾಗ ನಿಮ್ಗೆ? 24 ಅಲ್ಲಿ. ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್.
Serial number 6.
I appear for the appellant madam.
ಏನ್ ಮೆಮೋ?
Memo of withdrawal.
Withdrawal. Appellant counsel files memo seeking permission of this court to withdraw the appeal on the ground that the appeal has been and dispute has been resolved between the parties and hence permitted to withdraw.
7. BM Shita.
Notice to R1, R4, R5, R7, R12 for third time ante. Third time ಏನ್ ಮಾಡಿದಿರಿ? Sufficiency of service of notice in respect of refused R14 ತೊಗೊಳ್ಳಿ. The council submits that he has paid the PF. ಇವತ್ತಾ in the office. ಈಗೆಲ್ಲ ಬರೀ ಬೆಳಗ್ಗೆ ಕೊಡಕ್ ಕಲ್ತ್ಕೊಬಿಟ್ರಿ ಎಲ್ಲೆಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ ಅಂತ. 2 ದಿವಸದಿಂದ ನೋಡ್ಬಿಟ್ಟು ಬೆಳಗ್ಗೆ PF ಕೊಡದ ಇಲ್ದರೂ ಇವತ್ತು ಹೋಗಿ ಬೆಳಗ್ಗೆ ಕೊಟ್ಟು ಬಂದ್ಬಿಡೋದು PF. Council submits that he has paid the PF and hence issue notice against R1, R4, R5, R7 and R12. notice issued against R14 was returned with an endorsement, he has refused and hence held sufficient against R14.
8. VK Chandrasekhara.
Notice to R2 and R3. First time, Again, first time nodi madam. Notice order ಆಗಿರೋದು ಯಾವಾಗ 22 ನಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಯ್ತು. PF ಕೊಟ್ರ ಇಲ್ಲ PF ಡಿಸ್ಮಿಸ್ಡ್ ತಗೊಳ್ಳಿ. ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ ಹೇಳಿ. ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ PF ಕೊಡ್ಬೇಕು. PF ಕೊಟ್ಟೇ ಇಲ್ಲ ನೀವು. Notice not issued to respond number 2 and 3 for want of PF cover acknowledgement and copies of appeal papers. Post RSA before the court for furnishing of PF. R1 ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ madam.
Sir.
R1 ಗೆ?
RB sir.
R1 is caveator.
ಹೌದು, Appellate.
ಹಾ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ 22ರಿಂದ PF? ಏನ್ ಟುಡೇ ಇಟ್ ಸೆಲ್ಫ್ ಅಡ್ಮಿಷನ್ ಮಾಡಿಸ್ಕೊಬಿಟ್ಟು 22ರಲ್ಲಿ ಇದುವರೆಗೂ PF ಕೊಡ್ತಾರೆ. ವೈ ವಿ ಹ್ಯಾವ್ ಟು ಕೀಪ್ ದಿ ಮ್ಯಾಟರ್ ಡಿಸ್ಮಿಸ್ಡ್. This matter is admitted on 25/3/22 and for a period of 2 years PF not paid to issue notice against the respond number 2 and 3. And hence 1 week time granted to pay the PF on cost of rupees 1,000. If cost not paid and PF not paid, the appeal is dismissed without reference to the bench.
9. Government advocate.
For the appellant in this matter.
Issue
The Sambar Court has,
notice to the R1 for third time.
so your hand summons has been taken on my lad.
No, 10 regarding refusal of receiving the hand summons by respondent as per order dated 15/9/2018. Memo ಹಾಕ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, affidavit ಹಾಕ್ಬೇಕು ನೀವು.
Active.
ರಿಫ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅಂತ affidavit ಹಾಕಿ. ಯಾರದು?
ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ನನ್ನ ಅಡ್ರೆಸ್ ಇಲ್ಲ, ನನ್ನ ನೇಮ್ ಇಲ್ಲ ಅಂತೇಳಿ ಅವರು ತಗೊಳಕ್ಕೆ ರಿಫ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇದು ನೀವು ಅಡ್ವೊಕೇಟ್ ರಿಫ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅಂತ.
ಅಡ್ವೊಕೇಟ್ ರಿಫ್ಯೂಸ್ ಮಾಡಿರೋದು. executing court.
ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ, ನಾನು ತಗೊಂಡಿಲ್ಲ ಅಂತಾರೆ. ಆಮೇಲೆ 19 ಫರ್ನಿಶಿಂಗ್ ದಿ ಡೀಟೇಲ್ಸ್ ಆಫ್ ದಿ ಕೌನ್ಸಿಲ್ ಬಿಫೋರ್ ದಿ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಆಫೀಸ್. ಏನ್ ಹಾಕಿದಿರಿ?
ಹೌದು, ಅವ್ರ ಅಡ್ರೆಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಯಾರ ಅಡ್ರೆಸ್?
ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪೇರಿಂಗ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಹಿಯರಿಂಗ್.
ಪಾರ್ಟಿಗೆ ಸರ್ವ್ ಮಾಡ್ರಿ. ಈಗ ಅಡ್ವೊಕೇಟ್ ರಿಫ್ಯೂಸ್ ಮಾಡಿದ್ಮೇಲೆ ವೈ ಯು ಆರ್ ಇನ್ಸಿಸ್ಟಿಂಗ್ ಫಾರ್ ಇದು ಯು ಟೇಕ್ ದಿ ಸ್ಟೆಪ್ಸ್ ಎಗೇನ್ಸ್ಟ್ R1.
ವೀಕ್ಸ್ ಟೈಮ್ ಮೇ ಬಿ ಕರೆಕ್ಟ್.
ತೋಳಿ AGA na ನೀವು?
Yes ma'am.
AGA seeks 1 week time to furnish the correct address of R1. And if correct address is furnished within 1 week, issue notice against R1. If PF and correct address not paid, list this matter for dismissal on
In addition to my lord, I mean,
10/6.
in addition to my lord, I may permitted to hand summons to the address given to the trial court advocate.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ರೆಸ್ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಹೊಸ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಅದಕ್ಕೆ ಮೆಮೊ ಹಾಕಿ ಕೊಟ್ಟಿದ್ದೀವಿ. ಆ ಅಡ್ರೆಸ್ ತಗೋತೀವಿ ಅವ್ರ ಹೆಸರಿಗೆ ತಗೊಂಡು.
ಮತ್ತೆ ಹಳೆ ಇದ್ದಾರೆ ಇವ್ರು ಬೇರೆಯವರು ರೆಫ್ಯೂಸ್ ಮಾಡಿರೋದು.
ಅಲ್ಲ, ಅವ್ರು ನಮ್ಮ ಹೆಸರಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ರು, ಇವಾಗ ಅವ್ರ ಹೆಸರು ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ವಿ ಮೆಮೊ ಹಾಕಿ.
ಈಗ ತೊಳಿ AGA also filed memo furnishing the details of the counsel who appears before the executing court on behalf of the R1 and hence permitted to take out the notice in respect of the counsel in terms of the memo dated 19/9/2018.
Public.
10. Basavaraj, yes.
My lord.
Non-furnishing of PF correct address issue notice to R8, A, D and R11. Yes, counsel.
My lord, along with that, 2, 6 and 7, they are deceased. They will ascertain the address of that and like pay along with it, my lord.
ಯಾವಾಗ ತೀರ್ಕೊಂಡಿದ್ದವ್ರು ಹೇಳಿ? ಯಾವಾಗ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಮೇಡಮ್ ನೋಡಿ? What about taking of steps against R8, A, D and E and R11?
By end of the day, I think.
My lord, I appear for R5, my lord.
R5.
Name of the council may be changed. He's been designated as the senior councilman.
GV Chandrasekhar ಅಂತ
DV Chandrasekhar, he's been,
Chandrasekhar ಅದು.
he's been designated as senior
ಹೆಸರು
council.
ತಿಂದ್ಬಿಟ್ಟವ್ರನ್ರಿ. ಚಂದ್ರಶೇಖರ್ ಅಂತ ಮಾಡಿಟ್ಟಿದ್ದಾರೆ. ಹಾ, ಜಿ ವಿ ಚಂದ್ರಶೇಖರ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಆದ್ರ
ಹೌದು.
ಈಗ ಯಾರು ಬೇರೆಯವ್ರು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, I'm already on
You-
record,
do-
my lord. My name is Apeksha.
Your name is
Apeksha,
Apeksha.
please, my lord.
Counsel for R5 submits that Counsel Sri G.V. Chandrasekhar appointed as senior counsel, and hence his name has been deleted, and she has already filed wakalat, and her name Apeksha has to be shown for R5. And then
Please.
registry is directed to show the name of Counsel Apeksha for R5. ಏನಾಗಿದೆ ಮೇಡಮ್, ಯಾವಾಗ ಡೆತ್ ಆಗಿರೋದು ರಿಪೋರ್ಟ್ ಮಾಡಿರೋದು ನೋಡಿ, R2, R6 and R7 ಏನು ಇಲ್ವಾ? ನೋಡಿ, council seeks 3 days time to pay the PF and to take steps against deceased R2, R6 and R7, and hence 2 weeks time granted. List this matter on 10/6,
Okay.
13/6.
11. Mahesha Rupin.
ಕೊಟ್ಟಿದ್ದೀರಾ fresh ಆಗಿ? Council submits that he has paid the fresh PF and hence issue notice against R4, R6 and R7. R3 ಗೆ ಯಾವಾಗ R3 ಸತ್ತೋಗಿರೋದು ಡೇಟ್ ಗೊತ್ತಿಲ್ಲ, ಅಬೇಟ್ ಆಗಿರುತ್ತೆ. ಮತ್ತೆ ಈಗ ಹೇಗೆ ಸ್ಟೆಪ್ಸ್ ಟು ಬಿ ಟೇಕನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R3 ಅಂತ ಹೇಗೆ ಬಂತು? 19 ಅಲ್ಲೇ ಬಂದಿದೆ ಅಂತ ನೋಡ್ರಿ. ವೈ ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್, ಅಬೇಟ್ ಆಯ್ತು, ರಿಪೋರ್ಟೆಡ್ ಆಸ್ ಡೆಡ್ ಅಂತನಾ? ಶರ ಬಂದಿದೆ, ಆಮೇಲೆ ಕೋರ್ಟ್ ಮುಂದೆ ಲಿಸ್ಟ್ ಆಯ್ತಾ ಕೇಸು? ಅವ್ರ ನಾಲೆಡ್ಜಿಗೆ ಬಂತ? ಹ? 2019 ಇಂದ ಅವ್ನು ಸತ್ತ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಫೈಲ್ ಹಂಗೆ ಇಟ್ಬಿಟ್ರ? ತೊಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪಲೆಂಟ್ seeks 2 weeks time to ascertain the correct address. ಎಷ್ಟ್ ಸರಿ ಅಂತ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಮಾಡಿದ್ರೆ ಇವ್ರಿಗೆ? ನೀವು ಯಾಕೆ ಲಿಸ್ಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಬರ್ಲೇ ಅಲ್ವ, ಕೇಳಲೇ ಅಲ್ವ ಹೋಗಿ? 2019 ಅವ್ನು ಸತ್ತೋಗೋನೆ ಅಂತ ಬಂದಿದೆ. 5 ವರ್ಷ ಫೈಲು ಕೋರ್ಟ್ ಮುಖ ನೋಡ್ಲಿಲ್ಲ, ನೀವು ಹೋಗಿ ನೋಡ್ಲಿಲ್ಲ, ಇನ್ನೊಂದು 5 ವರ್ಷ ಹಿಂಗೆ ನೋಟಿಸ್ RSA. 2 weeks time granted to take steps, and it is reported that R3 passed away in 2019 itself. ನಿಮ್ ಪಾರ್ಟೀಸ್ಗಳು ಬಂದು ಹೇಳಿಲ್ವಾ? ನೋಡಿ, if steps not taken, list this matter for dismissal on 13/6.
12. Venkatesh Somareddy.
Non-furnishing of PF correct address appeal IA papers issue notice to respondents for first time. Notice ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು ಮೇಡಮ್? Why you have not paid the PF counsel? Issue notice to respondents if the requisites are furnished within 1 week ಅಂತಿದೆ. This court wide order dated 6/2/24. Order to pay the, order to issue notice if PF paid within 1 week, even in spite of 3 months PF not paid, and hence 1 week time granted on cost of ₹1,000 to pay the PF, and if PF paid, issue notice against the respondents. If PF not paid and cost not paid within 1 week, appeal is dismissed without reference to the bench. ದಿನ ಬೆಳಗ್ಗೆ ಬರೀ 1.5 ಗಂಟೆ ಇದೆ ಕೆಲಸ. ಒಕ್ಕಲತ್ತ ಕೌನ್ಸಲ್ ಕೊಟ್ಬಿಟ್ರ? ಏನಾಗಿದೆ ಇವ್ರದ್ದು ಒಕ್ಕಲತ್ತು? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ವಕಾಲತ್ by Venkatesh Somareddy, advocate for appellant wide order dated 12/7/23. ಆಯ್ತು, ಬೇರೆಯವ್ರು ಸೈನ್ ಮಾಡಿರ್ಬೋದು ನೋಡಿ. PPA ಕಡೆ ಒಬ್ಬರೇ ಸೈನ್ ಮಾಡೋರ? ಅವ್ರೇನ್ ಜೂನಿಯರ್ಸ್ ಯಾರ್ದು ಸೈನ್ದೇ ಮಾಡ್ಸಲ್ವಾ? PPA ಕಡೆ ಹತ್ರ ಒಂದು 10-15 ಜನ ಜೂನಿಯರ್ಸ್ ಇರ್ಬೇಕ್ರಿ. ಯಾರ್ದು ವಕಾಲತ್ ಸೈನ್ ಅವ್ರ ಆಫೀಸಲ್ಲಿ ಏನ್ ಜೂನಿಯರ್ಸ್ ಯಾರು ಸೈನ್ ಮಾಡಂಗಿಲ್ವಾ? ಯಾವ ವರ್ಷ ಇದು ಹಾಕಿರೋದು? 2018. ಈಗ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಫೈಲ್ ಅನಾಥ, ಎಲ್ಲೋದ್ರು ಅವ್ರು ಜೂನಿಯರ್? ಆಯ್ತು ಬಿಡಿ, ನೋಡ್ ತಗೊಳ್ಳಿ. ದ ಕೌನ್ಸಿಲ್ ಇದೇನು ಹೆಸರನ್ನ ತೋರ್ಸೋರಲ್ಲ, ವೆಂಕಟೇಶ್ ಸೋಮರೆಡ್ಡಿ ಅಂತ. ಮತ್ತೆ ಆರ್ಡರ್ ಇದೆಯಾ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ ಅಂತ? Undertakes to file power on behalf of the appellant ಅಂತ ಇದೆ. Third, the counsel Sri Venkatesh Somareddy is directed to file ವಕಾಲತ್. ಈಗ ಎಷ್ಟು one week time ಕೊಟ್ವಾ ಏನ್ ಮಾಡಿದ್ವಿ ಮೇಡಮ್?
1 week.
Huh?
1 week.
1 week,
1000.
file ವಕಾಲತ್ within 1 week. If ವಕಾಲತ್ is not filed, the appeal will be dismissed.
30. Maruti Prasad, yes, yeah.
R4 and 5. ಈಗ ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದೀರಾ ಏನು? Sorry, the counsel for the appellant would submit that he has paid the PF to issue notice to R4 and 5 and also R9, R10, R11 and R13. And hence issue notice against them. Steps to be taken in respect of R8. Counsel seeks 2 weeks time to file necessary application to bring the LRs of R8. And hence 2 weeks time granted.
40.
Ravishankar Shastri G. R11, R12, R14. ಏನ್ರಿ PF ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದೀರಿ, ಕೊಟ್ಟಿದ್ದು ವಾಪಸ್ ಬಂದಿದೆಯಲ್ಲ, ಈಗೇನ್ ಹೇಳಿ? Counsel for the appellant seeks 2 weeks time to bring the LRs of R9 and also seeks 2 weeks time to pay the PF to R11, R12 and R14. Hence list this matter on 13/6. ಅಷ್ಟೊಳಗೆ PF steps ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ. 2018 matter.
50.
To notice to R1 and R2 third time. ಯಾರು ಇಲ್ವಾ? ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ? Sufficiency of service of notice in respect of R3 refused. The notice issued against R3 was refused. Hence held sufficient against R3. Memo filed for dispensation of notice to R7 and R10. And in terms of the memo dispensed notice against R7 and R10 at the risk of the appellant. Appellant counsel is absent and hence directed to pay the PF within 1 week to issue notice against R1 and R2. And if PF not paid within 1 week, appeal will be dismissed. Appeal is dismissed without reference to the bench.
60. K.R. Lingaraju.
R5 second time.
Respond number 1 in this case.
Weeks time granted as sought to issue to pay PF. And if PF paid within 1 week, issue notice against R5. ಇದೇನಂತ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ PB ಬೇರೆ ಏನಿದೆ ಹೇಳ್ರಿ? 8 weeks time was granted for filing of PB. ಆಮೇಲೆ ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಯ್ತು ನೋಡಿ ಮೇಡಮ್? ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ? 8 weeks ಆದ್ಮೇಲೆ ಎಷ್ಟು ದಿವಸ ಫೈಲ್ ಮಾಡ್ತೀರಿ? 2019. ಎಷ್ಟು ದಿವಸ ಬೇಕಂದೆ? 4 weeks. The appellant counsel seeks 4 weeks time to file paper book. And in spite of matter was admitted in 2019 and wait weeks time granted to file paper book. Not filed the paper book for a period of 5 years. And hence on cost of rupees 2,000, 4 weeks time granted to file paper book.
70. M. Shiva Prakash.
ಇಲ್ಲೇನ್ ಮಾಡಿದ್ವಲ್ಲ ಮೇಡಮ್? R5 ಗೆನ appeal will be dismissed without reference to the bench ಅಂತಿದೆಯಲ್ಲ, ಅದಾಗಲ್ಲ. ಯಾಕೆಂದ್ರೆ R1 ಇದಾರೆ, ಆಲ್ರೆಡಿ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ. It will be dismissed against R5 ಅಂತ ಮಾಡಿ ಅಷ್ಟೇ.
70.
R18. 4/14 ಯಾವಾಗ ತಗೊಂಡಿದ್ದೀರಾ? ಯಾವಾಗ? Morning. Appellant counsel submits that he has paid the PF in the office today and hence issue notice against R4, R14, R15 and R18. Correct address ಕೊಟ್ಟಿದ್ದೀರಾ? Next ಏನು? Non taking of steps in respect of deceased R2 and R11. 2 days sir. ಯಾವಾಗ ಅವ್ರು ರಿಪೋರ್ಟ್ ಆಗಿದ್ದು ಡೆತ್? Counsel seeks 2 days time to file necessary application to bring the LRs of R2 and R11. And time granted as sought.
80. Venkatreddy CM.
Then letter of Sri Ramachandraya received through secretary to the Honorable Chief Justice for dismissal of RSN. 17 ಅಲ್ಲಿ ಬಿಡೋದು ಹಂಗೆ ಇರ್ಲಿ, ಲೆಟರ್ ಬರಿತಾ ಇರ್ತಾರೆ ಪಾರ್ಟಿಗಳು.
ಬರ್ದಿದ್ದೀನಿ.
ಆಯ್ತು, R1
80,
ಫಸ್ಟ್ ಟೈಮ್ ಅಂತ ಇದೆ 2018 ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ್ರಿ? 23 ಅಲ್ಲ,
May 23.
ಆಮೇಲೆ PFA ಕೊಟ್ಟಿಲ್ವಾ? May 23 ತಗೊಳ್ಳಿ. This court issued notice in May 23 and PF not paid. And counsel submits that he has paid the PF today in the office. And hence issue notice against the respondent.
90,
Compliance of office objection raised on
Vinay
IA number
Kumar.
1/24 to 3/24, bringing LRs of deceased R1. So appellant counsel is absent, 1 week time granted to comply with office objection. And IA 1/24 to 3/24. If office objection not complied within 1 week, list this matter for dismissal of IAS. List this within on 13/6. ಮತ್ತೊಂದೇನ ಇದೆಯಲ್ಲ 3,601 days delay na.
In filing the appeal.
Filing the application na?
That's appeal.
Filing the appeal.
Appeal file ಮಾಡಿ.
ಓಹ್,
ಆಗಿರೋದಿಲ್ಲ.
ಈ IAS ಏನ್ ಮತ್ತೆ?
ಸರ್ ಅದು ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಸರ್ ಅದು.
ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್
ಆಫ್ R1 ಸತ್ತೋಗಿದ್ದಾರೆ. R1 ಸತ್ತೋಗಿದ್ದಾರೆ, ಅವರಿಗೆ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್
ಬೇಕೇ ಆಗಿಲ್ಲ. ಫಸ್ಟ್ ಡಿಲೇ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ ತಗೊಳ್ಳಿ. ಏನಾಯ್ತು ಮೇಡಮ್? 1 week time granted to comply with office objections on IAS. And also list this matter for consideration of IA 1/22. Since there is an inordinate delay of 3,601 days in filing the appeal. On 13/6.
B. Ramesh,
Notice to R10 and R12. ಏನಾಯ್ತು? ಮತ್ತಿನ್ನೇನು ಬೇರೆ ಪ್ರಪೋಸ್ಡ್ R4 ಏನು ಒಂದು ಇದೆ?
R4 is dead. Hence, even the percentage of the part of the card. Whereas in respect of R4, B to D has been served. Whereas R4A is the wife of R4.
Wife of
R4.
R4.
Yes.
Its
children are being served.
Served or represented?
Not represented.
Today I have filed a kalat for that.
ಹಾಕಿದಿರ?
ಇವತ್ತು ಹಾಕಿದ್ದೀನಿ.
ಅವ್ರಿಗೂ ತಗೋಬಿಡಿ.
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ಎಲ್ಲರಿಗೂ.
ಅಲ್ಲ, ಎಲ್ಲರಿಗೂ ಹಾಕಿದಿರಾ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 ಗೆ ಹಾಕಿದ್ದೀನಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 ಎಲ್ಲ ಸಬ್ತಿ ರೆಸ್ಪಾಂಡೆಂಟ್.
4A ಗೂ ಹಾಕಿದಿರಾ?
ಹೌದು ಸ್ವಾಮಿ ಹಾಕಿದ್ದೀನಿ.
ಹೌದು. The counsel Sri
SGL ಮೇಲೆ SG Lokesh.
Lokesh.
Yes.
Submits that he has filed the wakalat for LRs of R4. That is R4A to D.
Yes ma'am.
And hence registry is directed to show the name of the counsel SG Lokesh for R4A to D in the cause list. Appellant counsel is directed to pay the PF within 2 days. And if PF paid within 2 days, issue notice against R10 and 12.
Also a family member of the date for the trial.
No, I don't have any instructions about that.
Sections ಇಲ್ಲ ಅಂತ ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ ಬಿಡಿ. ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
Now that IA Manors, since bring the legal representations of respondent number 11 and 4. Service is complete. Maybe
11 ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ? A 1/24 ಸರ್ವಿಸ್ ಆಗಿದೆ ಮೇಡಮ್ ನೋಡಿ. 11 ಅವರಿಗೆ ಏನು ಸರ್ವಿಸ್ ಆಗಿದೆ? ಪ್ರಪೋಸ್ R11A.
ಹಾಕಿದ್ದಾರೆ.
11B.
A and B Manors, 7 call is completed. 11B.
ಪ್ರಪೋಸ್ R11A ಬಸವರಾಜ್. ಏನು ತೋರಿಸಿಲ್ಲ ಸರ್ವ್ ಅಂತ. ಬಸವರಾಜ್ ಸಿ ಇಸ್ ಸರ್ವ್ಡ್.
ಸರ್ ಇಬ್ರು ಸರ್ವ್ ಆಗಿದ್ದಾರೆ.
A and B ಮಾತ್ರ ಇರೋದಾ?
A and B ಮಾತ್ರ ಇರೋದು. ಸರ್ವ್ ಆಗಿದೆ.
ಇಬ್ರು ಸರ್ವಿಸ್ ಆಗಿದೆ ತಗೊಳ್ಳಿ. This court has issued notice against the LRs of R11 on IA number 1/24. And notice has been served and the LRs are unrepresented and hence for the reasons stated in the accompanying application and IA 1/24 is allowed. And the appellant is permitted to bring the LRs on record. The appellant counsel is directed to amend the cast title within 2 weeks and file amended cast title. ಅಷ್ಟೇ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದೇನು? R4 ಇನ್ನು ಅವ್ರು ಇದಾಗ್ಬೇಕಲ್ಲ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಾರು ಇದೆಯಾ? ನೋಡ್ತೀರಾ? ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ IA ನಂಬರ್. IA ನಂಬರ್ ಎಷ್ಟು ಮೇಡಮ್ ಅದು?
ಸರ್ IA 3
3 of 23 ನಾ?
23.
1, 2, and 3 of 26.
ಎಲ್ಲ ಇದೆ.
1, 2.
ಇಲ್ಲ.
ಇಲ್ಲ sir.
ಫಸ್ಟ್ ಅದೊಂದೇನೆ.
ಬರೀ
ಅಯ್ಯೇ 3 of 23.
ಸ್ಟೇಗೆ ಮತ್ತೆ ಡಿಲೇಗೆ.
ಅದ ಆಮೇಲೆ ನೋಡೋಣ. ಫಸ್ಟ್ ಎಲ್ಲಾರ್ಸ್ ಬರ್ಲಿ ರೆಕಾರ್ಡ್. ಏನ್ ಬ್ರಿಂಗಿಂಗ್ ಎಲ್ಲಾರ್ ಸರ್ ನೀವೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದೀರಾ ಎಲ್ಲಾರ್?
ಏನಿಲ್ಲ.
ಮತ್ ಮಾಡ್ಲಿ ಬಿಡಿ, ಅದನ್ನ ಅಲೋ ಮಾಡೋಣ,
ಆಗ್ಲಿ.
ಮಾಡೋಣ, ತಗೊಳ್ಳಿ. Heard the counsel appearing for the appellant and also the counsel appearing for the LRs of appellant, respond number 4, and for the reason stated in the accompanying application and affidavit, IN number 3 of 23 is allowed and abatement is set aside and delay is condoned and permitted to bring the LRs of R4 on record. Either the same, the appellant counsel is directed to amend the cast title and file amended appeal memo within 2 weeks.
Meanwhile, I'll try to get certain notice to respondent number 10 and 11.
ಫಸ್ಟ್ ನೀವು ಸರ್ವಿಸ್ ತಗೊಳ್ಳಿ, ಆಮೇಲೆ ನೋಡೋಣ. ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ ರೀ 10 and 12ಗೆ. ತಗೊಳ್ಳಿ ಹೋಗ್ಬರ್ಲಿ. ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ನೀವು PF ಇವತ್ತೇ ಕೊಡ್ತೀರಾ? ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವ ಕೊಟ್ರಿ ಮೇಡಮ್? ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ 28/9. 28/6.
21.
Non-compliance of office objections. Third time.
Exit court fees ಒಂದು ಕಟ್ಬೇಕಾಗ.
ಅಷ್ಟೇನಾ? ಕೊಟ್ಟಿದ್ದೀರಾ? The council submits that exit court fee of rupees 55 is paid. 255 is paid in the office. Post the matter for admission. On 13/6.
22.
Awaiting service of notice of R1, R8 and R16 to 22. ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರೋದು ನೋಡಿ ಮೇಡಮ್.
I represent the
Non-filing of affidavit of service of hand summons as per order dated 25/4/2023. Hand summons ಯಾರು affidavit ಹಾಕ್ಬೇಕು? ಆಯ್ತು, ನೀವ್ ಯಾರು ಅಪೇರ್ ಆಗ್ತೀರಾ?
I appear for the cavators, my lord.
Cater R9 to 15.
Are 8 to 14, my lord.
8 to 14 ಇಲ್ಲ 9 to 15 ಅಂತ ಇದೆ.
Sorry.
ರಾಮಚಂದ್ರ ಜಿ ಭಟ್.
Yes, my lord. I appear
9 to 15 ಅಂತ ಇದೆ ನೋಡಿ.
I verify, my lord.
I appear for R19. 19.
ನಿಮ್ಮ ಹೆಸರು ಇಲ್ಲ, ವಕಾಲತ್ ತೋರ್ಸ ಇಲ್ಲ. ಯಾವಾಗ ಹಾಕಿದ್ರಿ
My lords,
ವಕಾಲತ್?
I'll be filing Vakalatnama in the registered. I'll be filing my Vakalatnama on behalf of R19 registered.
Not yet filed.
Not yet filed.
Counsel ಹೇಳಿ ಏನ್ ಹೆಸರು?
My lord, Nisha Tiwari.
Huh?
Nisha Tiwari.
Nisha
Tiwari undertakes to file wakalat for R19.
Yes, ma'am.
And if wakalat is filed, show the name of the counsel for R19. Next 1 to 8. Await ಹೋಗಿದೆ ಅಲ್ಲ notice.
ಹೌದು sir, 1 to
Await
8.
notice of R1 to 8 and 16 to 22. List this matter. ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರೋದು ಮೇಡಮ್?
Sir, 28/5 ಗೆ sir.
28/5 ಗ. 5 ಅಂದ್ರೆ ನೆನ್ನೆ ಮೊನ್ನೆ. PF ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು?
Vacation.
ವೆಕೇಶನ್ ಅಲ್ಲ. 9th ಮೇ ಆದ್ರೆ ಯಾಕೆ ನೆನ್ನೆ ಮೊನ್ನೆ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಮೇಡಮ್?
Office objection. Exit 500 rupees ಕೊಡ್ಬೇಕು.
List this matter on 28/6. ಒಂದು ತಿಂಗಳಾಗ್ಲಿ ನೋಡೋಣ. 28/6. SV Prakash.
23.
Acceptance of acknowledgement in respect of R1D Syed Nazir Malik. Nazma Malik, signed by Nazma Malik, who is not a party in the appeal. ಏನ್ರಿ ಅವ್ರು ಯಾರ್ರಿ?
ಅದು R8 ಆಗ್ಬೇಕು ಸರ್. R8 ಆಗ್ಬೇಕು ಅದು. R18 ಗೆ ಆಲ್ರೆಡಿ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ವಕಾಲತ್.
R8 ಗೆ?
ಅದು R8 ಆಗ್ಬೇಕು. R18 ಆಗಿದೆ ಅದು.
1D ಅಲ್ವಾ?
1D ಅಲ್ಲ ಅದು. R8 ಆಗ್ಬೇಕು.
ಮತ್ತೆ ಯಾಕೆ ಇವ್ರು R1D ಅಂತ ತೋರ್ಸೋರು ಮೇಡಮ್?
ಆಫೀಸಲ್ಲಿ
ಅವರು
ನಜೀರ್ ಮಲಿಕ್ ಈಗ ನೀವು ವಕಾಲತ್ ಹಾಕಿದಿರಿ ಈಗ?
ಅಲ್ಲ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಅವ್ರ ಅದೇ ಎಕ್ಸೆಪ್ಟ್ ಆಗ್ಬೇಕು ಸರ್. R8 ಗೆ
ಇಲ್ಲ ಸರ್, ಅವ್ರು ಇರೋದು
ನಜೀರ್ ಮಲ್ಲಿಕ್ ಅನ್ನೋರಿಗೆ ನೀವು ವಕಾಲತ್ ಹಾಕಿದಿರಿ?
ಇಲ್ಲ.
ಇಲ್ಲಲ್ಲ, ಮತ್ತೆ ಯಾಕೆ ನೀವು ವೈ ಯು ಆರ್ ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್? ಈಗ R1D ಹೆಸರೇನಿದೆ?
ಅಲ್ಲ R1D ಗೆ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ವಕಾಲತ್.
ನೀವು ಹಾಕಿದಿರ ವಕಾಲತ್? ನೀವು ಒಂಡಿಗೆ ಹಾಕಿದಿರಿ
R1 to 8 ಹಾಕಿದ್ವಿ. R1
ಎ ಬಿ ಸಿ ಡಿ
EF.
ಸಿ ಡಿ ಹಾಕಿಲ್ಲ. ಹಿರೇಮಠದ್ ಮಹೇಶಯ್ಯ ರುದ್ರಯ್ಯ ನೀವು ವಕಾಲತ್ ಹಾಕಿರೋದು R1 A B C E F G H and
D
I.
ಹಾಕಿ.
ಡಿಗ್ ಹಾಕಿಲ್ಲ.
Sorry, sir.
ಡಿಗ್ ಹಾಕಿಲ್ಲ ಅಂದೆ.
ಹಾಕಿಲ್ಲ.
ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ, ನೀವ್ ಯಾಕೆ ವೈ ಯು ಆರ್ ಕನ್ಫ್ಯೂಸಿಂಗ್ ದಿ ಕೋರ್ಟ್? ನೋಡ್ರಿ, ನೀವು ವೆರಿಫೈ ಮಾಡ್ರಿ. ನಜ್ಮಾ ಮಲ್ಲಿಕ್ ಅನ್ನೋರು ಯಾರೋ ಸೈನ್ ತಗೊಂಡಿದ್ದಾರೆ. ಒಂಡಿ ಇಸ್ ಅಕ್ಬರ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಇಸ್ ಸೈನ್ಡ್ ಬೈ ನಜ್ಮಾ ಮಲ್ಲಿಕ್ ಅಂತ ಇದ್ದಾರೆ. ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ ಏನು ಅಂತ ನೋಡಿ, ವೆರಿಫೈ ಮಾಡಿ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ನೋಡಿ, ದಿ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ವೆರಿಫೈ ವೆದರ್ ನಜ್ಮಾ ಮಲ್ಲಿಕ್ ಇಸ್ ದಿ ಅಡಲ್ಟ್ ಮೆಂಬರ್ ಆಫ್ ದಿ ಫ್ಯಾಮಿಲಿ ಆಫ್ R1D. ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ ಏನಿದೆ, ಅಫಿಡವಿಟ್ ಡೇಟೆಡ್ 3/5 by the advocate for respondent. ಏನು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರಲ್ಲ? ಏನು
We have filed the affidavit
ಏನು ಅಫಿಡವಿಟ್ ಅದು?
not to claim equity.
ಓಕೆ,
What is this? Equity claim ಮಾಡಲ್ಲ ಅಂತೇಳಿ affidavit.
ಸೈಯದ್ ನಸೀರ್ ಮಲಿಕ್ ಅಂತ ಇದೆ. ಒಂಡಿಗ್ ಅಲ್ಲ ಹಾಕರದು. ಅವ್ರು ಹೇಳ್ತಿರೋದು ಕರೆಕ್ಟ್ ಹಂಗಾರೆ. R18 R1D ಅಲ್ಲ ಅದು, R8. ಅದನ್ನ ಹಾಗೆ ಮಾಡಿ ಮೇಡಮ್. R8 ತೊಳಿ ದ ನೋಟಿಸ್ ಇಶ್ಯೂಡ್ ಅಗೇನೆಸ್ಟ್ R8 Sri Sayyad Nasir Malik is not acknowledged by him, and the same is acknowledged by Najma Malik, and hence council is directed to verify whether Najma Malik is the adult member of the family. ಆಯ್ತು, ಒಂದಾಯ್ತು. ನೆಕ್ಸ್ಟ್ ಈಗ ಆಮೇಲೆ ನೀವು ಅಫಿಡವಿಟ್ ಏನಕ್ಕೆ ಹಾಕಿರೋದು?
Not to claim equity.
ನಾಟ್ ಟು
Claim equity.
ಅಂತ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
ನೋಡಿ, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಬೇರೆ ಇದೆ ಇದರಲ್ಲಿ. ಪೇಪರ್ ಬುಕ್ ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು? ಸರಿ, ಈಗ ಏನಾಗಿದೆ ಮೇಡಮ್? ಡಿಗೆ ಏನ್ ಸರ್ವಿಸ್ ಆಯ್ತಾ ಮೇಡಮ್? R1D ಗೆ
ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ ಹಾಕಿಲ್ಲ. R1D ಗೆ
ABC F ಹಾಕಿದ್ದಾರೆ ಮೇಡಮ್. R1D ಗೆನು ಮೋಸ್ಟ್ಲಿ R1D ನು ಸೈನ್ ಮಾಡಿರ್ಬೇಕು ಅವರೇ, ನಜ್ಮಾ ಮಲ್ಲಿಕ್. ನೋಡ್ಬಿಡಿ ಒಂದ್ಸರಿ.
ಅದನ್ನೇ ನೋಡಿದೆ ಸರ್, ಆಗಿರ್ಲಿಲ್ಲ.
ಇಲ್ವಾ ಅದು?
ಅದನ್ನೇ ನೋಡಿದೆ.
ನಜೀರ್ ಮಲ್ಲಿಕ್ ಅನ್ನೋರ್ಗೆ ಸೈನ್ ಆಗಿಲ್ವಾ? ವಾಪಸ್ ಬಂದಿದ್ಯಾ ಹೋಗ್ಲಿ?
ಇಲ್ಲ ಸರ್, ಅದನ್ನೇ ನೋಡಿದೆ ಈಗ.
The appellant counsel is directed to take fresh steps against R1D. ನೀವು ತಗೋಬೇಕಾಗ R1D ಪೇಪರ್ ಬುಕ್ ಏನು ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತಿದೆ? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಅಂತ ಇದೆ. ಏನಾದ್ರು ಟೈಮ್ ಸ್ಟಿಪ್ಯುಲೇಷನ್ ಇದೆಯಾ ಅಂದೆ ಅಡ್ಮಿಟ್
ಪೇಪರ್
ಮಾಡಿದಾಗ?
ಬುಕ್ ಏನು ಇಲ್ಲ ಸರ್. ಪೇಪರ್ ಬುಕ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಸರ್.
ಬೇಕಾಗಿಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ತರಿಸ್ಬಿಡೋಣ ಅಷ್ಟೇ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್?
ಇಲ್ಲ ಸರ್.
ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಗೆಟ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಆಫ್. ಬಟ್ ಇದು ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ, ಒಂದ್ ನಿಮಿಷ ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ.
ಆಗಿದೆ.
Get the records of both the courts. And no, there is no any order for filing of paper book, and hence filing of paper book is dispensed. ಅಲ್ಲೇ directed to take steps against fresh steps ಅಂತ ಆಯ್ತಲ್ಲ. And if steps taken within 1 week, issue notice against R1D. List this matter on 28/6.
24 kg
24 non-compliance of office objection first time. ಎಷ್ಟು sir? Days time sought for compliance, and hence granted the same as sought.
Hearing on IA 25 BM Siddappa
For impleading. ಯಾರನ್ನ impleading application ಹಾಕೋರ್ಲ ಇವರು? Appellant counsel is absent. ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹಾಕಿದ್ದಾರೆ?
Third parties, my lord. They are not parties to the FDP proceedings. The present appeal is filed against the order passed on the FDP, my lord.
FDP proceedings ಮೇಲೆ.
Also, preliminary decree has become final, my lord.
Pass over. Serious? ಆಯ್ತು. Why you have filed impleading?
He has not filed, my lord. Appellant has not filed.
ಇನ್ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ರು?
Applicants ಅವರೇ ಫೈಲ್ ಮಾಡಿರೋ ಸ್ವಾಮಿ.
MT Jagan Mohan for impleading applicants and counsel.
They were parties in the original suit, my lord. Suit was dismissed against them after contest.
ಮಾಡ್ಬೇಕು, ನಿಮ್ದಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಅದು. ನೋಡಿ, the impleading applicant counsel MT Jagan Mohan is absent. However, one more opportunity is given to make submission on IA number 1/21. If counsel doesn't appear in the next date of hearing, IA 1/21 will be dismissed. List this matter on 13/6.
Please.
26, Prasanna VR.
Prasanna, we are 94 days in filing the recalling application. Yen recalling? In dismiss, already dismiss ಆಗಿದೆಯಾ? ಯಾವಾಗ dismiss ಆಗಿದೆ ಹೇಳಿ? ಅಲ್ಲರಿ 2018 appeal. Dismiss ಆಗಿರೋ 223 ಅಲ್ಲಿ. Whatever it may be, counsel. ಆಯ್ತು, ಇದ್ರಲ್ಲಿ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ 5 ವರ್ಷ? No grounds. ಅದೇ ಬರ್ದಿರೋದು. Appeal was filed in the year 2018 and this court wide order dated 27/9/21 granted 3 weeks time to comply with office subsection, failing which list the matter for dismissal. In spite of the same, till date the office subsections are not complied with. In view of the preemptory order, the appeal is dismissed for non-purpose. That's all. Third. Heard on IA 1/23 for condemnation of delay of 94 days in filing the recalling application and also for recalling the order dated 25/1/23. That is IA number 2/23. And counsel would submit that the office has raised the objection for production of certified copy of the trial court judgment.
There are two separate appeals. One brought appeal number 1446 of 2018.
Yeah, ಅದೇನೇ
by
ಇದೆ.
the same appellate. Which was after hearing, after the court was issued notice. Which was
ಇಲ್ಲ ರೀ, ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು 1446 ಏನ?
1445 ಇದೆ ಇನ್ನು.
ಇನ್ನೊಂದಿದೆ. ಆಯ್ತು ಹೇಳಿ. ಹಾ
Same, connected judgments.
ಆಯ್ತು, ಅದನ್ನು ಕನೆಕ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡು ಹೇಳ್ಬೇಕಿತ್ತು. ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಅಟ್ಲೀಸ್ಟ್ ought to have sought for dispensation of production of document. You have not done anything. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? 5 ವರ್ಷದ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. And counsel also submits that connected RSA in RSA 1445 of 2018 already notice has been ordered. And having taken note of the said submission, even though no grounds are made out, since this appeal was dismissed in 23, though filed in 2018, and office objection is also only to produce the certified copy, and for a period of 5 years, certified copy is not produced. And in view of other appeal, notice has been ordered, granted. Two weeks time, ಏನ್ ಮಾಡ್ತೀರಿ ಈಗ ಇದರಲ್ಲಿ? ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಂದಿದ್ದೀರಾ? 2 weeks time granted to comply with office objections and cost of ₹2,000. And only after the compliance, these 2 IAs will be considered. List this matter on 13/6. ಅಷ್ಟೊಳಗೆ ಕಂಪ್ಲೈ ಮಾಡಿ ಅವತ್ತು ಮಾಡೋಣ. Cost is payable at registry.
27.
Dismiss for non-prosecution 407 ದಿವಸ ಡಿಲೇ. ಆಯ್ತು ಕೊಡಿ, ಯಾವಾಗ ನೋಡೋಣ. 22 ನಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಯಾವಾಗ? 23 ನಲ್ಲಿ. ಏನು ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ ಏನು? Comply with office. It is made clear that if the office objection are not complied with, this appeal shall stand automatically dismissed for non-compliance. ಆಯ್ತು. Papers are furnished to the council as and when they approach them without giving any cause of compliance. ಹೇಳಿ. ಅಲ್ಲ ರೀ, ಡಿಲೇನೇ ಇದೆಯಲ್ಲ 407 ದಿವಸ. ನೀವು ಅವತ್ತು ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಇಲ್ಲ, ಹೋಗ್ಲಿ ಕೋರ್ಟಲ್ಲಿ. ಸರಿ ರೀ, ಅವತ್ ನೀವು ಅಪಿಯರ್ ಆದ್ರೆ ಇಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ದಿವಸ. ಈ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡುವಾಗ ಇರ್ಲಿಲ್ಲೇನ್ರಿ ಕೋರ್ಟ್ ಮುಂದೆ ನೀವು? ಯಾಕೆ? ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಈ ಡಿಸ್ಮಿಸಲ್ಗಿಂತ ಮುಂಚೆ? 2019 ಅಲ್ಲಿ 22nd November 2019 ಮತ್ತೆ 22 again in the meanwhile office is directed to furnish the papers for compliance to the respective council. ಅವರೇ ಮಾಡಿದಾರಲ್ಲ. 3ನೇ ಸರಿ 4 ಸರಿ ಡೇಟ್ ಕೊಟ್ಟಿದಾರಲ್ರಿ. 24/2. ಹಾ ನೋಡಿ. IA 1 of 23 will be considered only on compliance and 2 weeks time granted to comply with office subsections on cost of rupees 2000. IA 1 and IA 2 ಅಂತ ಇದೆ, ಎರಡಿದೆ. Cost of rupees 2000. If cost not paid and office subsection not complied within 2 weeks, automatically IA number 1 of 23 and IA 2 of 23 are dismissed. ರಿಜಿಸ್ಟ್ರಿಗೆ ಇನ್ಯಾರಿಗೂ ಇಲ್ಲ. ಹಾ ಸರ್ಕಾರಕ್ಕೆ ಹೋಗ್ಲಿ.
28 GS ಶ್ರೀಕಂಠೇಗೌಡ.
Respondent number 2.
ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ? ಎಲ್ಲಾರ್ ಅಪಲೆಂಟ್
Appellant died ಡೆತ್ ಆಗಿದೆ ಅಂತ.
ಆಯ್ತು, ನಿಮ್ದೇನ್ ತಕರಾರು ಇದೆಯಾ? ಅವ್ರು ಎಲ್ಲಾರು
ಅದು
ಅಲ್ಲ ಅಂತ
ನನ್ಗೆ ಕಾಪಿ
ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ವಾ?
ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ.
ಕೊಡಿ ಕಾಪಿ.
ಅದು ಕಾಪಿ ಸಿಕ್ಕಿದ್ರೆ ಐ ವಿಲ್ ಮೇಕ್ ಸಬ್ಮಿಷನ್.
And his daughter-in-law, she wanted to come on record as the bill registered bill has been executed.
ಫಸ್ಟ್ ಕಾಪೀಸ್ ಕೊಡಿ. ಅವ್ರು ಏನ್ ತಕರಾರು ಹಾಕಂಗಿದ್ರೆ ಹಾಕ್ಲಿ ಅದರ್ ಸೈಡ್ಗೆ.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ಪಾರ್ಟಿಂಗ್ ಕರ್ಸಿ.
The counsel for the respondent submits that copies have not been served and hence the counsel is directed to furnish the copy of IA number 1 of 24, 2 of 24, 3 of 24. 3 ಕೊಟ್ಟಿದಾರಾ?
ಚೆಕ್ ಮಾಡಿ.
3 ಕೊಟ್ರಾ?
1 ಕೊಟ್ಟಿದ್ದಾರೆ.
And hence directed to furnish the same. And respondent also given 2 weeks time to file objections if any to the applications. List this matter on 13/6.
Obliged.
29 Dhananjay Kumar. Early
hearing filed by the counsel for appellants. R6 ಏನಾಯ್ತು? ಕೊಟ್ಟಿದ್ದೀರಿ. Counsel submits that he has paid the PF to issue notice against R6 and hence issue notice against R6.
R3 is died, madam.
R7 ಏನು? Unclaimed covers in respect of R2 and R7 ಅಂತ ಇದೆ ನೋಡಿ ಮೇಡಮ್. Intimation delivered ನೋಡಿ. ಡೆತ್ ಆಗಿದಾರಂತಲ್ಲ R3. Appellant counsel seeks 2 weeks time to bring the LRs of R3 since R3 is reported as dead, died. ನಾನ್ ಫೈಲಿಂಗ್ PP ಬೇರೆ ಇದೆ. ಏನ್ ಟೈಮ್ ಕೊಟ್ಟಿದಾರ? ಏನಂತಿದೆ ಮೇಡಮ್? INT intimation ಅದು ಡೆಲಿವರ್ಡ್ ಅಂತ ಇಲ್ಲ ಅಷ್ಟೇ. Intimation given ಅಂತ. On perusal of the cover, intimation was given and not claimed and hence held sufficient against R2 and R7. ನಾನ್ ಫೈಲಿಂಗ್ PP ಇದೆ ಹೇಳಿ. ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದೆ ಅನ್ನೋ ಟೈಮ್ ಕೊಟ್ಟಿದಾರಾ? ಅಲ್ಲ, ನೀವು ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ದಲ್ಲೇನೆ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹೆಂಗ್ರಿ ಹಾಕ್ತೀರಿ? On cost of rupees 1000. ಕೊಡಿ ನೋಡ್, ಆಮೇಲೆ ನೋಡೋಣ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್. ಫಸ್ಟ್ ನೀವು ಪೇಪರ್ ಬುಕ್ ಹಾಕಿ ಆಮೇಲೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋಣ. ಪೇಪರ್ ಬುಕ್ ಅಲ್ದೆಲ್ಲ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಅನ್ಬಿಡು.
30 Nagaraj Hegde.
Recalling the order dated 15/3/24.
Lord, it is the respondent who has filed this application. Lord, it's a suit for possession, Lord, which was concurrently decreed in my favor.
ಅದು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲ. ಒಂದು IA ಹಾಕಿದಾರೆ recalling the order.
Lord, it is a respondent.
ಯಾಕೆ why?
Lord, what has happened, Lord?
What is that order?
Lord, the order is the grant of interim order. Yeah, and the admission of the appeal. The appeal, Lord, was admitted on that day. And Lord, the interim order was granted. Lord, the reason why I have moved this application is, Lord, the appeal was filed on the 16th of November 2023. By which time the respondent had entered caveat. But through my predecessor. I was not the counsel on record, but through my predecessor. But I filed my wakalat on the 4th of January 2023.
4th of January
2024.
2024.
Please. Now, what the appellant does is, on the 15th of March.
Which month?
Sir, I had filed my wakalat on 4th of January 2024.
Oh, 4th of January.
Please. Which is much prior to this order. On the 15th of March 2024, without intimating us,
Intimation ಕೊಟ್ಟ ಬಗ್ಗೆ ಕೇವೇಟರ್ ಕೌನ್ಸಿಲ್ ಏನಿದೆ ದಾಖಲೆ ನಿಮ್ಮ ಹತ್ರ? But he has already given NOC and he had filed the wakalat. How? Wakalat ಅಲ್ಲಿ NOC ಇದೆಯಾ ಇಲ್ಲ ತಗೊಳ್ರಿ ಜನವರಿಯಲ್ಲಿ. Whatever it may be, wakalat already filed. ಅಜಿತ್ ಆನಂದ್ ಶೆಟ್ಟಿ.
Please.
ಹೌದಾ? ನೀವು ಅಜಿತ್ ಆನಂದ್ ಶೆಟ್ಟಿನಾ?
Please.
ನೀವು NOC ಎಲ್ಲಿದೆ ನಿಮ್ಗೆ? ಕುಸುಮಾ ಆರ್ ಶೆಟ್ಟಿ ಅಂತ ಏನೋ ಸೈನ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ ವಕಾಲತ್ತು.
ಹೌದು.
ಅರ್ಲಿಯರ್ ಕೇವೆಟ್ ಹಾಕಿದ್ರಲ್ವ ಕೌನ್ಸಿಲ್?
ಕೇವೆಟ್ ಹಾಕಿದ್ರು.
ಅವ್ರದ್ದು NOC ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
But he had entered appearance on behalf of certain other parties.
ನಿಮ್ ಪರವಾಗಲ್ವಾ? ನೀವ್ ಯಾರಿಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತಿದೆ?
The sole respondent.
ಒಬ್ಬರೇ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಹೌದು. Sole respondent.
ಮತ್ತೆ ನೀವು ಕೇವೆಟಾರ್ ವಕಾಲತ್ನಿಂದ NOC ತಗೋಬೇಕಲ್ಲ?
But he had issued an NOC to the client.
ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಇದೆ ವಕಾಲತ್ತಲ್ಲಿ I have not seen that.
ಮತ್ತೆ ಬೇಕಲ್ಲ? Then how they will come to know about that you have filed the wakalat?
By which time my name was reflected. My name was reflected. Yes, my name, my online, my lords, even online, my name was already there. It was already reflected as on that date. But
when the matter was listed in the afternoon, when they have moved the memo,
please,
whether your name is shown?
That, my lords, I am not aware because no list was issued that day.
Objections and then we'll consider this.
Very well.
The counsel for the appellant seeks time to file objections to A1 of 24. ಅವತ್ತಿಂದೊಳಗೆ ನೀವು ವೆರಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ ನೋಡಿ.
ನಾನು ಮಾಡ್ತೀನಿ. I'll do that. Their claim not before the
matter on 13/6.
Land tribunal has been rejected. They don't bring it to the court's notice.
ನೋಡ್. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಅಂತ ಇದೆ, ಅದು ಆರ್ಡರ್ ಇದೆಯಾ? ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಇದೆಯಾ ಮೇಡಮ್? ಎಷ್ಟು 8 weeks? Paper book order illala? There is no order as to file paper book and hence filing of paper book is dispensed.
Grateful.
This matter on 13/6.
Grateful.
Objections haki nod will consider.
31.
31. IA1 of 23 CD of 11 days in filing. Nanjunda Swami, ಹೇಳ್ರಿ counsel ಹೇಳಿ. ಏನ್ matter ಏನು? Then what is the error? Hmm.
Where contingent that credits are not to mention,
Hmm.
they have not to go.
Hmm. What happened that suit?
As abates.
As abated. Ah.
My father died,
ಆಯ್ತು in a case of suit for injunction, no need to bring the LRs also.
we have a denied there
ಆಯ್ತು.
they have a particular thing for the declaration and position. Without taking further position, what is the market?
Hmm. Hmm.
Another condition, both were not considered the
Hmm.
endorsement given by the deputy taskmaster.
Hmm.
What happened? The credit have filed in the application for transfer of the task.
Hmm.
Transfer of the task. The deputy taskmaster gave an endorsement that the respondent might fall in his position.
Hmm.
Position, so not there, rejected the task.
Hmm.
Very stated that my father can enter his position.
Hmm.
57.
Hmm.
That's the document that has been.
Hmm.
No, as the date of the proof, the credit was not correct.
Hmm. ಪಾಣಿಯಲ್ಲಿ ಹಾಕಿದಾರಲ್ಲ ನಿಶಾನೆ P3 and 4 MR 29 of 82-83. Again subsequent suit of the year 2008. MR is of the year 82-83. ಮರಣ ಇದು ಆರ್ಟಿಸಿಗಳಿದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಏನ್ರಿ D7 D7 ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಬಿಟ್ಬಿಡಿ. ಅವ್ನು ಡೆಪ್ಟಿ ತಹಸೀಲ್ದಾರ್ ಕೊಟ್ಟಿರೋದು ಅದ್ ಬಿಟ್ಬಿಡಿ. As on the date of filing of the suit, whether RTC stands in the name of the plaintiff or not. You show me the exhibit 3 and 4. Huh? Revenue record shows that they are in possession. They are in possession of the revenue records ತೋರಿಸ್ತದ್ರಿ. Counsel, as on the date of filing of the suit in a case for permanent injunction, to show that they are in possession or not. Now they have produced the exhibit P3 and P4. That shows that there is an entry. How can the deputy tahsildar can give an endorsement in terms of exhibit D7 as against exhibit P3 and P4? Task ಕೊಟ್ರೆಲ್ಲ ಬರ್ಕೊಡ್ತಾರ. Counsel MR number 29 of 82-83 ಯಾವ ವರ್ಷ ಯಾರ ಹೆಸರಲ್ಲಿದೆ? Exhibit P2. ಎಲ್ಲ ಟ್ಯಾಕ್ಸ್ ಪೇಡ್ ರೆಸಿಟ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, ಪ್ಲೇಂಟಿಫ್ ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂಟ್ರಿ ಇದು ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್. Counsel, there is a concurrent finding. Why they have to seek for declaration? Agar injunction suit file madange illa without seeking any relief of declaration, according to your argument. Even mere denial is not enough. There must be a cloud on the title. That's all. ನಿಮ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಒಂದೇನಾ ಎಕ್ಸಿಬಿಟ್ D7 ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ? Suit not filed the suit for the relief of declaration ಅಂತ. This matter is listed for considering IA number 1 of 23. Since there is a delay of 11 days in filing the appeal, this court heard the matter and on perusal of the judgment and decree of the trial court has granted the relief of permanent injunction considering particularly the document of exhibit P2 MR number 29 of 82-83 and also exhibit P3 and P4 Pani extracts which clearly discloses the name of the plaintiff. Survey number ಎಷ್ಟು? And admittedly, the property is also granted in favor of husband of first plaintiff. In KLR M 1982-74-75. And form number 10 also issued. And he passed away in the year 1998. Leaving behind the plaintiff. And thereafter, Kata has been changed in the name of the first plaintiff. And RTC also stands in the name of the plaintiffs. And only contention of the appellant counsel that exhibit D7 endorsement issued by the deputy Tahsildar discloses that defendant is in possession, but revenue records, particularly exhibit P1, P2, P3, P4, stands in the name of the plaintiff, husband and plaintiffs. And when suspending the case, the very contention of the appellant defendant cannot be accepted. Mere production of exhibit D7 endorsement is not enough as against the documents of exhibit P1 to P4. The other contention of the counsel appearing for the appellant is that suit is filed for the only for the bare injunction and not filed the suit for the relief of declaration and injunction, and no need to file the relief of declaration and injunction unless there is a cloud on the title. And trial court as well as the first appellate comes to the conclusion that plaintiffs have proved the very possession in respect of the suit shall property. And also comes to the conclusion that an attempt is made to interfere with possession of suit shall property of the plaintiff. And first appellate court also taken note of the case of the plaintiff and answered the point for consideration with regard to whether interference is required or not, in particularly in page number 19 discussed with regard to the RTC extracts for the year 92, 93 to 96, 97 as well as 96, 97, 98 marked as exhibit P3 and P5, which reveals the name of the said Madhe Gowda at column number 9 and 12. And so also the contents of the RTC extract for the year 1999, 2000 to 2003, 2004 reveals the name of said Madhe Gowda. And also the contents of exhibit P10 to 11 RTC extracts for the year 2005 and 2006. Reveals the name of said Madhe Gowda and also taken note of the tax paid receipts. And taking into note of the both oral and documentary evidence available on record. The first appellate court comes to a conclusion that reasoning given by the trial court is based on the records and dismiss the appeal. Really, where in D25. Hmm. 82, 83 ಅದು. ಹೌದು. As on the date of filing of the suit ಏನಿದೆ ಏನೋ ಇಲ್ವಲ್ಲ. ಮಾದೇಗೌಡ ಬಿನ್ ಚಿಕ್ಕೇಗೌಡ ಅಂತ ಇದೆಯಲ್ರಿ ಎಲ್ಲ ಕಡೆ 82, 80. ಯಾವಾಗಿದೆ? ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ ಯಾವ ವರ್ಷದಲ್ಲಿ? ಆಗ್ಲೇ ನೋಡ್ಬೇಕು ಕೋರ್ಟ್ನವ್ರು. And council also contend that in terms of exhibit D5, 25 and 26, RTC extracts the name of the father of the plaintiff found in column number 12. And these RTCs are in respect of the year 1982, 83 to 85, 86. 86, 87. Not produced any document as on the date of filing of the suit, defendants are in possession. And having taken note of material available on record, I do not find any error committed by the trial court as well as the first appellate court. And concurrent finding is based on the both oral and documentary evidence, and hence I do not find any ground to entertain the second appeal. In view of the discussions, madam, I pass the following order. Second appeal is dismissed.
32.
32. Irleno 395 days delay idea. Issue notice against the respondent on IA 1 of 24 and also on IA 2 of 24 and also on main against the respondents. The appellant counsel is directed to pay the PF forthwith.
Admission matter. Admission matter 33. Idishri BV. Why you have filed an application for dispensation of notice against the deputy commissioner? What is the subject matter, madam? Fathers? What is property? Now who has to assess the value of the property? No, that's why. Complete court fee. Who has to assess the value to pay the complete court fee? What do you, madam? Six B, my lord. Beyond 3 lakhs, there is a flat 4 fee payable of 30,000. Which I need to undertake to pay. And there is no necessity to valuate the property.
Five % or rupees 30,000, whichever is less. Have you paid the court fee? Issue of? While issuing.
Carry out newspaper publication.
Have you taken citation? Whether you have made an application? Address and particulars of the immovable property. You have to make an application in which paper the citation has to be made. Having considered the property where it is situated. Karnataka daily where the property is situated, because you have not read the respondents in the petition.
The daughter and the son, and there are no other class 1 elect.
Hmm.
Why has been seen that?
Hmm.
I stated for my petition.
Where the property is situated, madam? Bangalore? Ah. Then you have to take out the citation in the circulation of Bangalore, both urban as well as rural also. Hmm. 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 Good. Heard on IA 1/24 for dispensation of notice to the deputy commissioner, and council would submit that. The petitioner is ready to pay the maximum court fee of rupees 3 lakh. Sorry, 30,000 or 39,000?
The maximum court fee and willing to pay that.
What is the maximum, madam, now?
Yes. 30,000.
30,000. Maximum amount of rupees 30,000. And no need to issue notice to the deputy commissioner. The council also would submit that property is located within Bangalore district, urban district, and also the rural district. And for the region stated in the accompanying application and affidavit, IA 1/24 is allowed by dispensing the notice to the deputy commissioner. The petitioner is also permitted to take out the citation both in English and Kannada paper. And the same are in publication in Bangalore district and as well as Bangalore urban district and Bangalore rural district, since subject matter of the petition are located within the Bangalore urban and Bangalore rural district. The date is fixed for taking the citation on or before. Yavadaru date kodi madam?
15 days.
15 days.
10.
Hmm?
10.
10.
10,
Date 10/6 of 24 and date is fixed for appearance. Hmm? 15 July. Both are same? Yes. Same, both properties are in rural and both in both. Yes.
35.
35. Hmm.
SV Prakash. NG Sridhar.
SV Prakash. Sridhar. Hmm. Remove the mud on the channel. Hmm. Huh? Hmm. Mandatory? Hmm. Is it compulsory for seeking the relief of declaration while seeking for the relief of mandatory injunction? Huh? Hmm. 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 Remove the mud put on the channel within 2 months from the date of this order. Hmm. Channel belongs to whom? Hmm? Rainy season. Water flows through plaintiff and defendant's father by name Venkat Ramana Patta are the brothers. Oh, idu dispute between the cousins. Further, the plaintiff is the owner in possession and enjoyment of the social property situated in survey number 20 of Nagarhadli, Amcha of Hubli, Vasnagar Taluk, measuring 2 acres. Further, it is stated that in the year 1958, the plaintiff and defendant's father have jointly purchased the social property and other properties in survey number 21, and further, it is stated that 1971 been jointly cultivating the said lands. And thereafter started to cultivate the land separately. Further, it is stated that in the year 1999, the plaintiff and defendant father have executed a Jabra the Patra and an extent of 2 acres 21 in 7 has been fallen to the share of plaintiff and an extent of 2 acres fallen to the share of defendant's father. Further, it is stated that in the plaintiff's property, he has raised the areca garden, and on the northern side, he has raised paddy crops in the land. The plaintiff's land is totally described as ABCD in this rough sketch. Hmm. ಕೊಡಿ ಅದೇನ್ ನೋಡ. Water channel flows from south to north, measuring 3 feet width and 4 feet depth. Further, it is stated that the defendant's land is situated at a higher level than the land of the plaintiff. Further, it is stated that the defendant has taken up the work of leveling his property, and in the event he has enclosed the channel as well as plaintiff's property, raise a record of land covering mud over the water channel. ನೀವು ಬ್ಲಾಕ್ ಮಾಡಿದಿರಿ ಅಂತ ದೇ ಅಪ್ರೋಚ್ ದಿ ಕೋರ್ಟ್. Have you disputed with regard to the existence of channel is concerned? Earlier property was purchased jointly by both of them. Only 2 grounds. One is item number 4, one has not been proved. And not sought for the relief of declaration. I know nothing. Yes, concept. What do you say?
My lord, so far as whether there was a dispute as to the existence of the channel or not, it is quite clear from the evidence on record, both oral and as well documentary, my lord. Apart from the documentary evidence led by both the parties, the Honorable Court has taken the evidence from 2 commissioners, my lord, one from an advocate and one from the Taluk surveyor. And those reports have made it patently clear that there is a channel in between the plaintiff's land and defendant's land. And this aspect is also admitted And that has been extricated in para 21 of the judgment. By the defendant, it has been admitted.
In the trial court.
Yes, by the trial court's judgment. Paragraph 20. Further in the case, it is necessary to mention that this court has allowed IA number 2 filed for temporary injunction, and that has been allowed. And about this fact, DWN has clearly admitted in his cross-examination that he has leveled the middle place wherein water is collected. And further, he has deposed that he has leveled by using the hands. Further, he has deposed that the tube of Bananti Kere is situated on the eastern side of the plaintiff's property. Further, DWN has admitted that there is a water channel in between his and plaintiff's property constructed by stones. On the very moment, he has deposed that there is no water channel, and the very next moment he says illa water channel illa anta
After the admission.
after the admission, he says, and that has been rather considered by the honorable court, and the demeanor has been noted. And further, my lord, from paragraph 22 onwards, in the trial court's judgment, we find the consideration of the reports filed by 2 commissioners. And wherein the commission exhibit C4, my lord, makes it very clear as to the location of the plaintiff's property and of the defendant's property, and the channel running through in between these 2 properties from south to north. And as the channel is in between
Yeah, the commissioner report, even exhibit C9 also very clear. Channel is running from the property between the plaintiff and defendant's property. That is item number 1 is the item number 1 is the property of the defendant only. Okay. Nim obstruction ಬಗ್ಗೆ you only admitted in the cross examination. Oh, you are admitting the existence of a channel, but not admitting the flow of water in the said channel.
Even the commissioner's report, my lord, makes it very clear that the water flows only to a certain length of extent, and thereafter there is an obstruction, for which reason the water scatters.
In between the land of plaintiff
Yes,
and
madam.
defendant, they have blocked it.
Yes, madam.
That is the evidence.
Exactly. In fact, my lord, it has appealed to the conscience of the honorable trial court from the evidence, both oral and documentary, that there is indeed an encroachment upon the channel. And in fact, the decree what is given, my lord, it comprehends only a part of the prayer what has been asked. So far as plaintiff's property is concerned, it is not granted. So far as channel is granted, the honorable court has directed to remove it.
Partly decreed, that's all.
Yes, madam.
Good. So this matter is listed for admission and I heard the counsel for the appellant and also the respondent. The factual matters of case of plaintiff before the trial court while seeking the relief of mandatory and permanent injunction against the defendant. It is contended that plaintiff and the defendant's father by name Venkata Ramana Bhatta are the brothers. The plaintiff is the owner in possession and enjoyment of the suit scheduled property situated in survey number 20 of Nagarahalli within bracket Banantikere, Hamcha Hobli, Hosnagar Taluk, measuring 2 acres, 27 acres, 2.27 acres. Further, it is stated that in the year 1958, the plaintiff and defendant's father have jointly purchased the suit side property and other properties in survey number 20 and 21 of Nagarahalli village. It is further contended that till 1977 they have been jointly cultivating the said lands, and after 1977 they started to cultivate the land separately. In the year 1999, the plaintiff and defendant's father have executed a Jabani Hisa Patra and an extent of 22 acres, 2.27 acres in survey number 20 has been fallen to the share of the plaintiff, and an extent of 2 acres in the same survey number has been fallen to the share of defendant's father. It is also contended that the plaintiff has raised Areca garden, and on the northern side he has raised paddy crops in the wetland. The plaintiff land is totally described as ABCD in the rough sketch. ABEF is the wetland, and ABE and CDEF is the Areca garden, and open well in the plaintiff's property is described as GHEF. It is also contended that after the said partition, the revenue records are also got mutated in the name of the plaintiff. Defendant's Areca garden is also shown as RSTU. Wetland is shown as PQTU in the rough sketch annexed to the plaintiff. Further, it is contended that there is a main water channel in between the plaintiff and defendant property shown as ADSQ, and that runs from Banatikere, which is situated on the southern side of the lands of both the parties. Further, it is stated that the water channel flows from south to north, measuring 3 feet width and 4 to 5 feet depth. It is contended that defendant land is situated at the higher level than the land of the plaintiff. The defendant has taken up the work of leveling his property, and in that event, he has encroached the channel as well as plaintiff's property to raise Areca plant by covering mud over the water channel, plaintiff's wetland, including the open well situated adjacent to the water channel. It is further contended that defendant has put mud on the channel, which is described as OUMN, and the plaintiff has resisted the said act of the defendant. It is further contended that if the defendant continued his illegal act, the plaintiff will be put to great loss and inconvenience, and channel is closed, and excess water during the rainy season will flow over the land of the plaintiff, and then entire land of the plaintiff will be damaged and ruined, and hence sought for the relief of mandatory injunction and for also the permanent injunction against the defendants. In pursuance of the suit summons, defendant appeared and filed the written statement denying all averments made in the plaint, and even denied the very contention of the land of the defendant is in the higher level, as well as disputed the claim of the defendant. The trial court, having considered the pleadings of both the parties, formulated the point with regard to the whether the defendant had put the mud on the channel and plaintiff's land, to some extent, and whether there is any interference. And allowed the parties to lead evidence, and accordingly PW1 plaintiff has been examined and got marked exhibit P1 to 4. On the other hand, defendant examined himself as DW1 and got marked exhibit D1 to 4. The trial court also appointed the court commissioner, and commissioner report is also produced before the court. And the same is also marked through the court commissioner. That is one is KN Prasanna, who is the surveyor. The trial court, considering both oral and documentary evidence, particularly the evidence of PW1 as well as the evidence of DW1, and DW1 has categorically admitted with regard to the existence of a channel, and so also taken note of the commissioner report, particularly exhibit C9 and also the exhibit C4 sketch. Granted the relief of removing of the mud which was put in the channel, and suit is decreed only in part. And also defendant restrained by an order of permanent injunction from encroaching into the suit shell property or interfering in any manner with the peaceful possession and enjoyment of the water channel marked as ADSQ in the rough sketch, and the plaintiff's land shown as ABCD of suit sketch. Being agreed by the judgment and decree of the trial court, an appeal is filed in area number 54 of 2013. And having considered the grounds urged in the appeal memo, the first appellate court also formulated the point with regard to the whether the plaintiff has proved that defendant had put mud on the item number 1 of the plain scheduled property and to the portion of the item number 2 of the plain scheduled property. And also with regard to the lawful possession and enjoyment of the plaintiff and interference, and answered the points as affirmative. That is a point number 1 to 3. And also comes to the conclusion that it doesn't require any interference of the trial court. Being agreed by the concurrent finding, present second appeal is filed before this court. The main contention of the appellant counsel before this court is that very suit itself is not maintainable. When the suit is filed for the relief of a mandatory injunction and ought to have filed the suit for the relief of declaration when the very item number 1 property is disputed. The counsel also vehemently contend that both the courts have committed an error. Hence, this court has to frame the substantive question of law with regard to non-consideration of material on record, and also the question of law with regard to the filing of suit for declaration. And in the absence of declaration, there cannot be any order of mandatory injunction. Hence, it requires interference and has to frame the substantive question of law. Per contra, the counsel appearing for the respondent oblique plaintiff would vehemently contend that the trial court, having taken note of particularly admission on the part of DW1, wherein he categorically admitted with regard to the causing of obstruction, and also taken note of in paragraph number 21 that there is a water channel in between his property and also the plaintiff property, which is constructed by stones, and also taken note of the sketch which has been produced by the plaintiff while filing the suit, demarcating the existence of a channel, and also taken note of the report of the commissioner, particularly exhibit C9 and also exhibit C4 and exhibit C8, and 2 commissioners have been appointed. That is, one is an advocate and another is the Taluka surveyor, and both of them have identified the existence of a channel in the property belongs to the plaintiff as well as the defendant, and also the obstruction made by the defendant. In detail discussed the same, and reasons are given in paragraph number 29, considering the exhibit C4 sketch as well as the evidence of CW1 in paragraph number 30, and detailed discussion was made even with regard to the Hisa Patra between the parties in paragraph number 32, and rightly granted the relief of the mandatory injunction. The council also vehemently contend that the appellate court also considered the grounds urged in the appeal and formulated the point with regard to the proving of the obstruction caused by the defendant in free flow of water from the channel, and also the lawful possession as well as interference. And detailed discussion was made by the appellate court also, and elaborately considered the same and taken note of cross-examination part of the DW1, particularly in paragraph number 17 with regard to the existence of land of plaintiff and defendant, and also existence of channel. And also after giving the admission, immediately the DW1 in an ingenious method denied the very earlier admission, and the same has been discussed. And also in paragraph number 18, taken note of title deed of the suit survey numbers, and also the partition deed dated 2/6/1990 entered into between the plaintiff and the father of the defendant, and also existence of both the item number 1 and item number 2 of the property, and discussed in detail, and hence it doesn't require any interference. Having heard the appellant counsel and also the counsel appearing to the respondent, and also considering the material on record, the very specific case of the plaintiff before the trial court, that the defendant had blocked the channel which runs in the land of the plaintiff and defendant and caused obstruction. On the other hand, the defendant has denied total existence of even item number 1 of the property, and also the flowing of water in the said channel. And the trial court as well as the first appellate court taken note of the very pleadings and oral and documentary evidence placed before the court, and rightly pointed out by the counsel appearing for the respondent that the trial court taken note of the admission on the part of DW1, who has categorically admitted in the cross examination that he has leveled the middle place wherein water is collected, and also categorically admitted that he has leveled by using the hands antide ಏನದು hands ಅದು
ಅದಕ್ಕೆ ಕೈಯಲ್ಲೇ ಮಣ್ಣನ್ನು ತಳ್ಳಿ ಮಾಡಿದ್ದಾರೆ.
the mud. And also further he has admitted that there is a water channel in between his land and also the property of the plaintiff, and the channel is also constructed by stones, and also discussed with regard to the sketch of the plaintiff in respect of item number 2 in paragraph number 24, and also exhibit C8, exhibit C4, and commissioners were also appointed, and both of them have given the report. No. Again C4. No, really, paragraph number 29 of the trial court nodi, exhibit piece C4 list sketch produced and got marked by the Taluka surveyor Ken. In his report, he has clearly deposed that plaintiff is in possession of only 2 acres 17 kuntas. Quote no. Then why you have blocked the property channel? That is the only the relief is granted by the trial court. You have admitted leveling of your land and also the exhibit C4. ಏನಾಗಿದೆ ಇದರಲ್ಲಿ? ಸರಿ ರೀ, ನೀವು ಒತ್ತುವರಿ ಇರ್ಬೋದು, ಒತ್ತುವರಿಗೆ ನೀವೇನ್ ಮಾಡ್ಬೇಕು ಆಗ? ಇಫ್ ಎನಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಯು ಹ್ಯಾವ್ ಟು ಸೀಕ್ ಫಾರ್ ದಿ ಪೊಸೆಷನ್, ದಟ್ಸ್ ಆಲ್. Why ನೋಡ್ರಿ, the issue is only blocking of the channel. Why you have made not only that. Now the relief is only for preventing you from blocking of the channel. Suit is decree is granted partly only in respect of removal of this mud which you put in the channel. That's all. Don't try to.
My lord, in fact, para 22 of the trial court judgment, my lord, clarifies this issue, what my learned friend has just now posed. It says, rather the plaintiff runs shortage of 11 guntas. ಅದು ಇವರೇನೆ 11 ಗುಂಟೆ ಹೆಚ್ಚಿಗೆ ಇದ್ದಾರೆ ಅನ್ನೋದನ್ನ ಬಂದಿದೆ ಅದರಲ್ಲಿ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ. ಸೊ ಪ್ಲೇಂಟಿಫ್ ಮಾಡಿದ್ದಲ್ಲ ಎಂಕ್ರೋಚ್ಮೆಂಟ್, ಡಿಫೆಂಡೆಂಟ್.
Both the court commissioner also given the report, and particularly in exhibit C9 report is very clear with regard to the existence of channel as well as blocking of the channel, and detailed discussion was made particularly in respect of marking of ADSQ in exhibit C8 with regard to the item number 2 of the property, which is the property of the plaintiff. And when there is a clear admission on the part of DW1 with regard to steps he has taken, leveling of his property, and when there is a blockage, the trial court and also the appellate court rightly taken note of oral and documentary evidence and comes to the conclusion that the defendant had indulged in blocking of the channel. And though counsel would vehemently contend that even though channel is in existence and there is no any free flow of water and no explanation on the part of the defendant with regard to the blocking of the channel by putting the mud. And hence the trial court rightly comes to the conclusion that defendant has blocked the channel by putting the mud on the channel and hence directed to remove the same within 2 months. And also the other relief is granted, also granting a permanent injunction from encroaching into the suitable property or interfering in any manner with the peaceful possession and enjoyment of the water channel marked as ADSQ in the rough sketch which has been filed by the plaintiff, shown as ABCD of suit sketch. The first appellate court also not committed any error and in detail discussed in paragraph number 17, the admission given by the DW1 in causing interference and blocking of the channel which is in existence between the property of the plaintiff and defendant. And also even DW1 has categorically admitted the boundaries stated in the partition deed, and also no dispute that earlier property was purchased between the parties and they were in enjoyment, and subsequently they got it partitioned the property on 2/6/1990, and the same has taken place between the plaintiff and the father of the defendant. The same is also discussed in paragraph number 18 of the order of the appellate court, and having considered both oral and documentary evidence as well as the commissioner report, I do not find any error committed by both the trial court and appellate court to invoke the substantive question of law. The very contention of the counsel appearing by the appellant that ought to have sought of the relief of declaration cannot be accepted, and the existence of property and also earlier it was the joint cultivation is also not in dispute, and when such being the case and relief is only sought for removal of the blocking of the channel, under the circumstances no need to file any suit for the relief of declaration as contended by the appellant counsel, and hence on that ground also there cannot be any substantive question of law to be framed considering the material available on record. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
36. Rakshit Joyce.
Irlena, someone made submission belage.
Prakash.
Counsel. Okay. 370 connected. Idike connected. Same parties. The counsel appearing to the appellant would submit that this court listed the other connected appeal in RSA number 370 of 2018 on 12/6. 12/6 alla? Number ಗೊತ್ತಿದೆಯಾ? And also counsel submits that another RSA number 412 of 18. And one more RSA 413 of 18 also between the same parties arising out of different regular appeals. Howdalla? Regular between the different regular appeals, and hence this appeal is also posted to consider the same on 12/6 along with other appeals, and hence registry is directed to post all the appeals together on 12/6. So the council Rakshit Joyce submits that earlier he had filed wakalat along with his senior and his name has to be removed since K. Prasad Hegde represents for appellant, and hence registry is directed to remove the name of Rakshit Joyce.
37, B.S. Nagraj, N. Nanjunda Swami.
Miscellaneous was allowed.
I am of the opinion that it is just a proper to consider the results available on the record to arrive at the rate of rent or the aforesaid period as admitted by the respondents themselves. They have the authority sought to cover figure the total on monthly rate of. And this is one third argument.
Why it has to be apportioned?
Because one all 3%, the property is divided into 3 parts. He the traditional sentenced for 1/3 say. And 1/3 say the other 4%
Three mean profits allow ಮಾಡುವಾಗ admitted rent na consider ಮಾಡಿ 100 rupees ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ. ಮಾಡಿದ್ದಾರೆ. With 10% interest for every year. ಹೌದು. 1/3 ಅದು ಎಲ್ಲಾರ್ಗೂ 100 ಬರುತ್ತೆ, ಅದ್ರಲ್ಲಿ 1/3 ಈಚ್ ಅವರಿಗೆ ಬರುತ್ತೆ ಅಷ್ಟೇ.
That submission is incorrect. This is the reason, my lord. Earlier, my lord, the one Sheikh Hussain is the absolute owner of the property, my lord. After he demised, my lord, his 3 sons, Abdul Kader Saab and Muhammad Gausa, Pakir Saab and Muhammad Dastagir Saab, my lord, were partitioned this property in the year 1966. According to my lord, Schedule B, C, D was there, my lord. With Schedule B belongs to the petition number 1 to 4. Schedule C, C, my lord, belongs to 4 to 9, my lord, and the schedule another D, my lord, belongs to the appellants herein, my lord. This petition is filed in respect of the portion, my lord, allotted to the my share. And my lord, another share, my lord, respond number 4 to 6, respond number 4 to 9 again allot agide. Other share petition schedule matra now idu kelta irodu idralli. Not entire property. ಅವ್ರದ್ದು ಏನು ಅವ್ರ ಪೋರ್ಷನ್ಗೆ ಏನು ಅಲಾಟ್ ಆಗಿದೆ ಅದರಲ್ಲಿ ರೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಅದನ್ನ ನಾವೇನು ಕೇಳ್ತಾ ಇಲ್ಲ. ನಮ್ಮ ಪೋರ್ಷನ್ ಏನಿದೆ ಆಫ್ಟರ್ ದಿ ಪಾರ್ಟಿಷನ್ ಮ್ಲಾಟ್ ಏನಾಗಿದೆ ಎಲ್ಲ ಜಾಯಿಂಟ್ ಅಲ್ಲಿ ಇದ್ರು ಮಾರ್ಟ್ಗೇಜ್ ಮಾಡಿದ್ರು, ಮಾರ್ಟ್ಗೇಜ್ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದ್ವಿ. ಮಾರ್ಟ್ಗೇಜ್ ಡಿಸ್ಚಾರ್ಜ್ ಅಲ್ಲಿ ನಾವೇ ಎಲ್ಲ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಅದರಲ್ಲಿ ಅವರು 6,000 ಕೊಡಬೇಕಾಗಿತ್ತು, ಅದನ್ನು ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಇಟ್ಸ್ ಅ ಡಿಫರೆಂಟ್ ಇಶ್ಯೂ ಮ್ಲಾಟ್, ಅದರಲ್ಲಿ ಯಾವ್ದು ಇದಿಲ್ಲ. In respect of the means profit, ನಮ್ಮ ಪೋರ್ಷನ್ ಏನಿದೆ ಪಿಟಿಷನರ್ 1 and 2 9 ಏನ್ ಪೋರ್ಷನ್ ಇದೆ ಅದನ್ನ ಅವ್ರ ರೆಂಟ್ ಅವ್ರು ತಗೋತಾ ಇದ್ದಾರೆ. ಅದರಲ್ಲಿ ಒಂದರಲ್ಲಿ 100 ರೂಪಾಯಿ, ಇನ್ನೊಂದ್ರಲ್ಲಿ 30 ರೂಪಾಯಿ. ಆದ್ರೆ 130 ರೂಪಾಯಿ ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಮತ್ತೆ ಇದೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಏನಿಲ್ಲ. ದಿಸ್ ಎಂಟೈರ್ ಪ್ರಿಮೈಸಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್
ಪ್ರಾಪರ್ಟಿ ಅಲಾಟೆಡ್
to the my share, petitioner shares.
ಸರಿ ರೀ, ಈ ರೆಂಟ್ ಕೊಡ್ತಾ ಇರೋದು ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ವಿಚ್ ಪೋರ್ಷನ್? ದ ಪೋರ್ಷನ್ ವಿಚ್ ವಾಸ್ ಅಲಾಟೆಡ್ ಟು ದೆಮ್. ಆಯ್ತು, ಬಿಫೋರ್ ಪಾರ್ಟಿಷನ್ ಬಿಟ್ಬಿಡಿ, ಈಗ ಆಗಿದೆಯಲ್ಲ ಅದು. ಈಗ ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್ ಕೇಳಿರೋದೇ ಆಫ್ಟರ್ ಪಾರ್ಟಿಷನ್ ಓನ್ಲಿ.
ಹೌದು.
ಮತ್ತೆ ಹ್ಮ್
Para number 21 of the first appellate. First appellate court judgment. Para 21. May I read? The petition before this court below was filed seeking means profit in respect of said two portions of 20-33 feet, each allotted to the petition number 1 to 3 and petition number 4 to 9 from the date of suit 5/3/1996 till the date of they took over
possession of their respective shares. Handed over to them by the court. Commissioner on 22/2009. Paragraph number 21 allu kuda very clear agide.
Clear ಇದೆ. ಅಲ್ಲಲ್ಲ, ಪ್ಯಾರಾ 21 of first appellate court judgment.
ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ.
In the next para, insofar as portion of 20-33 feet allotted to petition number 1 to 3 is concerned, at page number 5 of cross-examination of PW1, it has been suggested that Hussain Khan was the tenant in the said portion, which has been admitted. It is further suggested that even now Hussain Khan remains.
28 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಕ್ಲಿಯರ್ ಆಗಿದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವೈಲ್ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ವೈಲ್ ಕಮಿಂಗ್ ಟು ದಿ ಕನ್ಕ್ಲೂಷನ್ ಹೇಳಿದಾರೆ ನೋಡಿ. Even in the objection statement filed to miscellaneous petition before the court below, the respondents have not pleaded that Hussain Khan stopped paying rent at any point of time. But at paragraph number 3 of the objection statement, it is pleaded as follows. The respondents have leased out only one shop in favor of Hussain Khan on a monthly rent of ₹100. Except the said ₹100 per month, the respondents have not received any rentals from the tenants in the scheduled property. The above admission is sufficient to show that respondents continue to receive the rent from Hussain Khan till petition number 1 to 3 took over the possession of the court commissioner. Therefore, the only conclusion that can be reached is that Hussain Khan, who was in possession as a tenant of a portion of petition scheduled property, which was ultimately allotted to the petition number 1 to 3, paid to the rent of so-and-so, the respondent from 1996 onwards, still possession was handed over to them by the commissioner. So, this matter is listed for admission and I heard the counsel for the appellant and also the counsel for the respondent. The second appeal is filed against the order passed by the trial court in miscellaneous number 97 of 2020, when the proceedings was initiated under order 20 rule 12 of CPC to award mean profits in respect of the suit shell property and also interest at the rate of 18% per annum from the rate of petition till realization and cost. The trial court, having considered the material on record, particularly the evidence of PW1 in paragraph number 14. And also the documents exhibit B 1 to 12. Discussed in paragraph number 16. And also the evidence of RW1 in paragraph number 17. And also considering document exhibit R1 to R24. In detail discussed in para 18 and 19 about the evidence of PWOs and also the DWO. And in paragraph number 21 taken note of the petitioners are entitled to get mean profits from the respondents in respect of the social property, that too for a period from 5/3/96 to 22/12/2009 till the date of handing over the possession of the properties in respect of petitioners are concerned. Comes to the conclusion that no material to show to establish the fact with regard to the rate of rent for the period spread over from 5/3/2016 to 22/12/2009. And considering in the absence of any such material, taken note of the admission for having let out the shops in favor of PW2 on monthly rent of ₹100. Considered the same and ordered to pay the mean profits at the 10% of the existing rent for every year and passed an order by allowing the petition. Being agreed by the same, an appeal is filed in RA number 202 of 2017. And appellate court also on reassessing the material available on record, and particularly in paragraph number 21 held that mean profit petition is filed in respect of two portions of 20 into 33 feet, each allotted to the petition number 1 to 3 and petition number 4 to 9 from the date of suit till the date they took over the possession of the respective shares. And also discussed in paragraph number 28. Objections filed in the miscellaneous proceedings and taken note of the admission in paragraph number 3 of the objection statement, and comes to the conclusion that the respondents continue to receive the rent from Hussain Khan till petition number 1 to 3 took over possession through the court commissioner. Hence, pass the order to directing to pay the mean profits till the date of handing over the possession to the petitioner 1 to 3 by the court commissioner. Both the courts, even the concurrent finding, the counsel appearing for the appellant would vehemently contend that even admitting that rate of rent is 1/3, ought to have been 1/3 out of 100 rupees. And not the entire 100 rupees as ordered by the trial court as well as confirmed by the appellate court, and hence it requires interference for the framing of substantive question of law. For counter, the counsel appearing for the respondent would vehemently contend that the order of the trial court is very clear with regard to the possession which was handed over to the petitioners in view of the commissioner report. Mean profits is considered and not committed any error, and made it clear in paragraph number 21 of the appellate court order also, and in paragraph number 28 also discussed in detail regarding the mean profits, since the petitioners are entitled only in respect of two portions of 20 into 33, which was allotted in favor of the petition of 1 to 3, and hence the very contention of the respondent cannot be accepted. Having heard the respective counsel and also on perusal of material available on record, the trial court as well as the appellate court taken note of the material available on record and particularly the rents which have been collected by the appellants herein in respect of the property which has been allotted in favor of petition of 123 and 429. And the same is also made it clear by the appellant court also while deciding the issue between the parties in respect of the mean profits is concerned. And trial court also in detail discussed in paragraph number 21 with regard to the entitlement of mean profits out of the rents which have been collected by the appellants herein. And in the absence of any material also comes to the conclusion that the existing rent of ₹100 which is admitted and taken note of the period from 1996 to 2009 and considered for an enhancement 10% for every year and passed an order. The first appellate court also not committed any error in reappreciating both oral and documentary evidence in fixing the mean profits, and the same is also based on the admitted material on record, that is ₹100 per month. That too in respect of portion which was allotted in favor of the petitioners who have filed the mean profits petition before the trial court and taken note of the period from the date of suit by, that is 5/3/1996 until the delivery of possession in terms of the court commissioner dated 12/22/2009. And hence I do not find any error committed by the trial court in considering the mean profits in respect of the petitioners is concerned, and first appellate court also not committed any error in dismissing the appeal, and hence I do not find any error committed by both the courts, and there is no any material to invoke section 100 of CPC. No grounds are made out to frame any substantive question of law. Invoke discussions made up, I pass the following order. Your interest. ನೀವು ತಗೊಂಡು ಎಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಎಂಜಾಯ್ ಮಾಡ್ಬಿಡಿ, ಈಗ ಇಂಟ್ರೆಸ್ಟ್ ವೈವ್ ಮಾಡಿ ಅಂತ. ನೋ ಗ್ರೌಂಡ್ಸ್ ರಿಜೆಕ್ಟೆಡ್.
38 Chandrakant Patil K.
Chandrakant Patil K.
Lord, I am for
not
the,
filing of Wakalat by Sri Manjunath K.
Lord, I am for the cross objector, my lord. Yes, my lord. By inadvertence, Wakalat has not been filed. I filed in cross objection, but not in RSA 1118 of 2018. I may be permitted to file in the next date. By inadvertence, I have not filed it. I am sorry.
Counsel Manjunath case. ಎಷ್ಟು ದಿವಸ ಆಗ್ತೀರಾ?
Next week I'll ಹಾಕ್ಬಿಡ್ತೀನಿ.
ಯಾವ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ?
ಇದೆ ಎರಡನೇದಲ್ಲಿ ಕನೆಕ್ಟೆಡ್.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ 1118.
ಅದ್ರಲ್ಲಿ ನಾನು ಹಾಕ್ಬೇಕು. ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಐ ಆಮ್ ಆನ್ ರೆಕಾರ್ಡ್.
ಎಷ್ಟು 1 week?
ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡ್ತೀನಿ.
1 week to file ವಕಾಲತ್ in RSA number 1118 of 2018. ಅದರಲ್ಲಿ ಅವ್ರದ್ದು ಇದೆ, ನಿಮ್ದು ಇದೆ ಈಗ. ಫಾರ್ಮ್ಯಾಲಿಟಿ ಅಂತನಾ? Formality only may be permitted to file wakalat and matter can be heard ಅಂತ ಅವ್ರ ಪ್ರಕಾರ.
I leave it to your lordship.
ಆಯ್ತು, ಹೇಳಿ ಏನ್ ಮೆರಿಟ್ಸ್. and hence permitted to file wakalat ಅಂತ ಹಾಕ್ಬಿಡಿ. ಏನ್ ವಾಟ್ ಇಸ್ ದ ಕೇಸ್?
But the right of the delaying the issue, saying that the offering is sanctioned that the consent will be sharply found. And we are considered the law to the end, 23 for the consent. He claims the consent will be for and the also to be sharply found. That said, not the housing. We want to use the area left by me. Treating it in the conservation for the next. The limit where it is the freedom of all this aspect, we are considered to say this intention is the person we are not going to pay for the power. Second is intention is that the conservation. It is the conservation is remedy before the Concurrent authority and remedy and there was section 8 all of the government is not a fair to municipality. Municipality is not a topic, therefore is not and against the different. In the appellate court, what the appellate court they confirm the
Judgment of the trial court only considered issue number 1.
issue number.
Suit lane is established. That scheduled property, that suit lane is established at the hands of the first appellate judge.
Documents were down the western side. The conservation there in each property can be not be conservation. Conservation is provided only for facilitating the parties to use this related therapy. Now, there is one anything like one of the documents. Will is document says that will is present. That will is treated as a conservation in the element they are always word will is there and it is a conservation. No doubt is not active for any because the corporation is not inside is not a part. However, it is a conservation. Nobody has sought declaration with the conservation law. And court cannot grant a delay beyond the delay with the prayer start. Unless there is a issue and not municipality in the party. Therefore, only that portion of the pending as that. Say that the pending given.
By the first appellate court with regard to the issue number 1 is concerned.
Yes.
What is his counter appeal?
His counter appeal
His rejection of the
other issues.
When the court has come to the conclusion
that there is a conservancy.
Then you should have directed them to demolish the court and service it.
Anyhow, now appeal and counter appeal is there. This court can admit and frame substantive question of law and the matter can be heard together.
How it can be said that without the proper necessary part, not only proper part, necessary part.
My lord, may make one submission, my lord.
Only the boundary shown in the.
My lord, insofar as the issue number 1 is concerned, I'm not asking, it is nobody's case that we are claiming ownership over that suit lane. We are claiming ingress and egress that is in existence since 1946. We have been using since time immemorial from my father time, and we are permitted to use the suit lane for our ingress and egress. I need to travel in that suit lane only towards my western side of my property. In fact, your lordship would be pleased to find the commissioner's report.
Court can grant the relief of declaration as sought by you.
My lord,
in respect of conservancy.
No. The existence of conservancy is to be established, my lord. Without that, I cannot seek for easemented right. Unless it is proved that there is a suit lane, I cannot ask for easemented right over the property. It's not my case that I own the property. It's the municipality, no doubt. My humble submission to your lordship is that since our forefather 1946, when we are making use of that suit lane for our ingress and egress, to reach to the western side of my property runs from east to west, 110 feet, all along with the suit line. And even there is a door fixed towards western side, facing the north. That means to say the.
My fundamental question is, when you have filed the suit for the relief of declaration, your prayer is
For easementary right.
relief of declaration that the plaintiff has easementary right over the suit schedule conservancy lane anta kelti.
Concerning ಅದ್ರ ಮೇಲೆ ನಾನು asking for easementary right. ಅದ್ರ ಮೇಲೆ ನಾನು ರೈಟ್ ಕೇಳ್ತಾ ಇರೋದು, ನಾಟ್ ಆನ್ ಓನರ್ಶಿಪ್. Presumption is that I have the dominion over the suit line.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಲ್ಲ ಮೇಡಮ್, ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಲ್ಲ. Easement of necessity.
Necessity, that is my case.
And first of all, for granted the live beyond the periods of.
ಅಲ್ಲ, relief, no relief is granted, only existence of the conservancy is concerned, it is modified. But no relief is granted in favor of him.
But however, my lord,
findings and remaining issues are confirmed accordingly, so also partly allowed.
My cross objection before your lordship.
Only with regard to the findings and issue number 1, that's all. No relief is also granted.
For that reason, cross objection is filed before your lordship. I am sorry.
Back side, front we are completely devoted to the shopping part, the shops, we are building the shop. From front, you want that you know that the passage came to the shop. That is the only reason why they are practicing. And 50 years they are using it, 50 years they are using it, but in 50 years, the records of the commission, they do not except that the marking of the door. No door is there, no anything is there on that side, completely
Exhibit Z1, my lord, Commissioner's report.
If you are not trying to access to the property, then you cannot spend
Exhibit D1, D2, D3.
ಅದು ಲಾಸ್ಟ್ ನಲ್ಲಿ C1 ಬರೋ ಬದಲು D1 ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ ರಿಪೋರ್ಟ್. Is a spelling mistake. It should be Commissioner's report C1, Court Commissioner.
Photographs ನೋಡ್ತಾ ಇದೆ.
But it is incorrect to submit that the license was issued to even encroach that suit line, my lord. Though the license was given to them, illegally they put up construction over the suit line. That is my case. Have I not? They have not. If they have not encroached that suit line under the guise of getting the license.
What is the boundary shown in your document with regard to the existence of conservancy is concerned? ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ? ಕನ್ಸರ್ವೆನ್ಸಿ ತೋರಿಸಿದೆಯಾ ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ?
ತೋರಿಸಿದೆ ಸರ್.
ಬೌಂಡರೀಸ್ ತೋರಿಸುವಾಗ
ತೋರಿಸಿದೆ.
ಎಲ್ಲಿದೆ ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಟೈಟಲ್ ಡೀಡ್?
110 feet by 4.5 feet ಅಂತಾನೆ ತೋರಿಸಿರೋದು. May I just request your lordship to turn to ink page 86. Ink page 80, I think. Ink page 80 ಅವ್ರದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ತೋರಿಸಿದೆ ಸ್ವಾಮಿ. ಅವರು ಇಂಕ್ ಪೇಜ್ ಅಪೀಲ್ ಹಾಕಿದಾರಲ್ಲ ಅದ್ರಲ್ಲಿ ಇಂಕ್ ಪೇಜ್ 80 ಶೆಡ್ಯೂಲ್ ತೋರಿಸಿದ್ದಾರೆ. ಆ ಮೆಮೊರನ್ ಆಫ್ ಇದ್ರ ಡಿಕ್ರಿ ನಲ್ಲಿ ಬರೆದಾಗ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇದೆ. ಮೇ ಜಸ್ಟ್ ರೀಡ್ ಮೈ ಲಾರ್ಡ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಂಕ್ ಪೇಜ್ 80. ಮೇ ರೀಡ್ ಮೈ ಲಾರ್ಡ್. Schedule conservancy lane within bracket vacant space, close the bracket, running from eastern side to western side, measuring east to west.
That is described in the plaint.
Please.
I am asking in this sale deed. Whether there is any reference of the existence of conservancy lane.
Please, my lord. I have placed on record exhibit P1 to P9 to establish the fact that towards northern side of my property, there exists conservancy lane. Apart from my property, even the property of defendants also discloses the existence of conservancy lane.
Both
It's
the
not
sides.
only my property. Honestly speaking, not only exhibit P1, P7 to 9, document speaks about the existence of suit lane towards northern side of my property and southern side of his property.
In the schedule you have shown in the west by conservancy lane anta.
Western ಬರಲ್ಲ ನಾರ್ತ್ ಸೈಡ್ ಬರೋದು.
ನೀವು ತೋರಿಸಿರೋ ಸೂಟ್ ಅಲ್ಲೇ ಇದೆಯಲ್ಲ ನಿಮ್ದೇ ಸೂಟ್ ತಾನೇ ಇದು.
ಒಂದ್ ನಿಮಿಷ ಅಲ್ಲಲ್ಲ ನಾನು ಡಿಗ್ರಿನಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಡಿಗ್ರಿ ನಾನು ನೋಡ್ತಾ ಇರೋದು.
ನೋಡಿ ಪೇಜ್ ನಂಬರ್ 81 ಅಲ್ಲಿ ವೆಸ್ಟ್ ತೋರಿಸಿದ್ರಿ ನೀವು. ವೆಸ್ಟಲ್ ಕನ್ಸರ್ವೆನ್ಸಿ ಲೇನ್ ಅಂತಿದೆ.
ಅಲ್ಲಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಹಿಂದೆ
ನಿಮ್ದೇ ಬೌಂಡ್ರಿ. West by conservancy lane ಅಂತಿದೆ.
that is wrongly shown. In fact, I have personally visited the spot. I've seen that towards north side of in document exhibit P1, P7 to 9 speaks about the existence of conservancy lane towards northern side. By inadvertently, the boundary shown as western side. It is not well. In fact, my learned friend also admits that it was his side, southern side ಬರ್ತಾ ನಮ್ ಕಡೆಯಿಂದ ನಾರ್ತ್ ಬರುತ್ತೆ. ಅಲ್ಲಿ by mistake it has been shown. ಇದು official pleading ಅಲ್ಲಿ ಸ್ವಲ್ಪ error ಇರುತ್ತೆ ಸ್ವಾಮಿ.
Any of records have received.
ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ. Kindly see the commissioner's report.
Substantive question of land and list
Please.
matter for final hearing. That's all.
Please.
Because there are two counter claim.
Please.
Heard the appellant counsel and also the counsel appearing for the respondent. ನಿಮ್ಮ appeal ಮೆಮೊದಲ್ಲಿ ಆಯ್ತು. The counsel appearing for the appellant in his argument vehemently contend that the first appellate court committed an error in modifying the findings of issue number 1 of the trial court. And committed an error in holding that scheduled property belongs to municipality despite there being no issue framed for the same. The counsel also vehemently contend that trial court, having considered both oral and documentary evidence available on record, answered all the issues as negative and rightly dismissed the suit filed by the plaintiff. And matter requires reconsideration. Per contra, counsel appearing for the respondent who have also filed the CRAB 5 of 22 vehemently contend that when the first appellate court comes to the conclusion that their existence of conservancy lane committed an error in rejecting the relief of declaration that the same cannot be granted relating to the suit lane, since the plaintiff is not the owner and someone else, that is the municipality, though no relief is claimed against the municipality. And the very approach of the first appellate court is also erroneous, and the trial court also not justified in holding that plaintiff is not proved his title to the property adjacent to the suit lane. Having heard the appellant counsel and also the counsel appearing for the respondent, and also considering the material and record, suit is filed for the relief of declaration to declare that plaintiff has easementary right over the suit schedule conservancy lane and for consequential relief of permanent injunction. And trial court comes to the conclusion that without arraying the municipality, who is the owner in respect of the conservancy lane, there cannot be any order of declaration and dismiss the suit. The first appellate court also confirmed the judgment of the trial court but modified the findings in respect of issue number 1. an observation is made with regard to the existence of the conservancy lane. It comes to the conclusion that relief of declaration of easement rate cannot be granted. The dispute is with regard to the not granting the relief of declaration as contended by the cross objector. And also the dispute by the appellant is that the appellate court ought not to have made an observation with regard to the existence of conservancy lane without any material placed on record. Having considered the grounds which have been urged in the second appeal as well as in the cross crop, matter requires reconsideration. Admit. The following substantive question of law is framed in RSA number 1118 of 2018. Whether the first appellate court justified in holding that the scheduled property belongs to municipality, which is not within the scope of the suit, since suit is filed only for the relief of declaration of easementary right in respect of conservancy lane as
Please.
claimed by the plaintiff. The following substantive question of law is framed in RSA crop 5 of 2022. When the appellate court, whether the appellate court committed an error in declining to grant the relief of declaration once they modified the findings of issue number 1 of the trial court. That's all. Records are already received and filing of paper book is dispensed, and hence list this matter for final hearing on 27th of June, 27/6.
Oblige me.
39,
39.
Gurraj.
ಅದಕ್ಕೆ ವಿತೌಟ್ ಇದ್ರಲ್ಲಿ ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ಬರುತ್ತದೆ ಅಪೀಲ್ ಅಲ್ಲಿ ನೋಡಿ, ಫಸ್ಟ್ ಅಪೀಲ್ ಇದೆಯಲ್ಲ ಅದ್ರಲ್ಲಿ ತಗೊಳ್ಳಿ. ವೆದರ್ ದಿ ಫಸ್ಟ್ ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ. ಈಗ ಇವನ್ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ. ಡಿಕ್ಲರೇಷನ್ ಕೆನಾಟ್ ಬಿ ಗ್ರಾಂಟೆಡ್ ಅಂತ ಹೇಳ್ತಾರೆ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ನವರು. ಯಾವ್ದು ಮುನ್ಸಿಪಾಲಿಟಿ? ಆ ಪ್ರಾಪರ್ಟಿ ನೀವು ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದೀರಿ ಅಂತ.
It is not our case that suit line belongs to us. It is the municipality property only. There is no dispute at all.
His contention is what you are contending that there is an existence of conservancy lane, but appellate court while considering the case of you, but made declaration that belongs to the corporation, that cannot be done nanta. That is correct also. How a court can give such a finding when the suit is filed only for the relief of easementary right? ಆ ಫೈಂಡಿಂಗ್ ಇದೆಯಾ ಆ ರೀತಿ? ಎಲ್ಲಿದೆ ಅದು ಕೊಡಿ. ಫಸ್ಟ್ ಇದ್ರಲ್ಲಿ ತಗೊಳ್ಳಿ RSA 1118 of 2018 ಅಲ್ಲಿ ಆರ್ಯನಲ್ಲಿ suit property owned by someone else, that is city municipality, Channapatna. A suit for declaration filed against individual. Therefore, the relief against whether the first appellate court committed an error in coming to the conclusion that suit scheduled property owned by city municipality who is not a party to the in a original suit filed by the plaintiff, whether such finding can be given in the absence of municipality as party to the proceedings.
Gurraj R.
Gurraj R, 1/4 share. Partition.
For respond number 5 and 6.
2, 4, 3, 5 to 7, modified as 1/12. One to
submission.
3 only, 4 to 7 dismissed. ಯಾವ್ದ್ರಲ್ಲಿ?
On short accommodation, this matter.
ಈ
I
case
for respond number 5 and 6. Short accommodation.
We want time, partition suit ಅಲ್ಲಿ.
Partition suit ಅಲ್ಲಿ ಅದು we are the contesting respondents. ಸ್ವಲ್ಪ ಇದು one week's time. That can be disposed, my lord, on that.
Shares have been, my lord, granted by the trial court, except item number 4.
1, 2, 3 and 5 to 7.
Yes, ma'am.
Appellate court modified only.
Modified, my lord, based on the judgment of.
And also modified as 1/12 instead of 1/4.
But in view of the judgment of the Vinutya Sharma's case, daughter gets share.
Equal.
Item number 5, 6 and 7, my lord, which is purchased by defendant number 5 and 6, the respond number 5 and 6 hearing.
So ನೀವು
From
purchase
defendant number
ಮಾಡಿರಬಹುದು, if property belongs to the joint family, then it is not binding on you.
That is the reason.
We'll consider it. Sorry, counsel for R5 and R6, 1 week time, and counsel for the appellant is present. The issue involved between the parties is with regard to the proportionate share as well as their entitled for share in respect of remaining property also. Odala? Remaining property also. And hence list this matter on 13/6.
13,
In the
14.
call for, in the meantime, call for the records.
ಕಾಲ್ ಫಾರ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ಯಾಕೆ ಬೇಕಿರೋ? ಬಂದಿದೆ ಅಂತಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ ಅಂತಲ್ಲ ಆಲ್ರೆಡಿ.
14th.
14 ಬೇಕಾ? 14. ಆಯ್ತು 14.
May I make one submission? Morning in one of our matter, it has been adjourned. 13th ಕೊಟ್ಟಿದ್ದಾರೆ. ಬೇರೆ ಯಾವ್ದು?
13 ನೀವು ಇರಲ್ವಾ?
ಸ್ವಲ್ಪ ತೊಂದರೆ.
ಅದರ್ ಸೈಡ್ ಯಾರು?
ಅಜಿತ್ ಖಾನ್ ಅವರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ನೀವು.
ಮಾಡ್ತೇವೆ.
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು?
52.
52 52 ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ತಗೊಂಡ್ರ? ಯಾರು ಅವ್ರ ತಗೊಂಡಿದ್ದು ಇವ್ರ?
ಇಲ್ಲ, ನಾವೇ ತಗೊಂಡಿದ್ವಿ.
ನೀವೇ ತಗೊಂಡು?
ನಮ್ ಕಲೀಗ್ ತಗೊಂಡು.
ಮತ್ ನೀವೇ ಹೇಳ್ಬೇಕಿತ್ತಲ್ಲ ಅವಾಗ?
ಅಲ್ಲ, ಅದೇ ನಮ್ ಕಲೀಗ್ ಇದ್ರು.
ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಇರೋದನ್ನ
ಅದನ್ನ ಒಂದು 15
ಒಬ್ರು ಅಜಿತ್ ಶೆಟ್ಟಿ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. 14 ಬದಲು 14.
ಒಂದೇ ದಿವಸ ಎರಡು ಬೇಡ, ಬೇರೆ ಬೇರೆ ದಿವಸ ಬೇಡ.
ಅದ್ ಪಾರ್ಟಿಷನ್ ರೀ, ಅದೇನ್ ಜಾಸ್ತಿ ಇರಲ್ಲ. ಇದೇನು ಇಶ್ಯೂ?
ಇದು
ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್.
Specific performance. Occupancy rights have been granted by the.
Dismiss ಆಗಿದೆ, ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. Order 41 rule 27 also.
Application is dismissed. ಸ್ವಲ್ಪ question of law ಇದೆ. I will try.
I think 14 ಬೇಕಾ ಬೇಡ?
14 ಕಿಂತ ನೆಕ್ಸ್ಟ್ ಯಾವಾಗ ಅದು?
ಯಾವತ್ ಮೇಡಮ್? 18th ಹಾಕಿ, ಬಟ್ ನೀವು ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಅವರಿಗೆ.
ಅವರಿಗೆ ಇಂಟಿಮೇಟ್. ಪ್ಲೀಸ್.
ಅವ್ರು ಬಂದ್ ಮತ್ ನನ್ನ ಅಬ್ಸೆನ್ಸ್
ಇಲ್ಲ, ಊಟಕ್ಕೆ
ಬೇರೆ ಆಗಿದೆ ಅನ್ಬಾರ್ದು.
ಈಗ ಸಿಗ್ತಾರ.
40. ರಾಘವೇಂದ್ರಕ್ಕೆ.
ರಾಘವೇಂದ್ರ. ಇಲ್ವಾ ರಾಘವೇಂದ್ರ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ ನೋಡಿ, ಡಿಸ್ಮಿಸ್ಡ್, ರಿವರ್ಸ್ಡ್. None appears. ತಗೊಳ್ಳಿ. The appellant counsel is absent and order sheet of the previous date dated 6/2/24 also says none appears when the matter is called on the second occasion, and it appears the appellant counsel is not pursuing the matter diligently, even though this is the appeal of the year 2018. However, in the ends of justice, one more opportunity is given. If appellant counsel doesn't appear in the next date of hearing, appeal will be dismissed for non-prosecution. List this matter on 13/6.
41. Irtida Kolar.
Second respondent. For R2. Dismissed, confirmed. Today. Ilva ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ ನೋಡಿ, ಆಮೇಲೆ ಬಂದೇ ಅಲ್ವಾ? ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದೆ. ಆಯ್ತು. Appellant counsel is absent and counsel for R2 is present. However, in the ends of justice, one more opportunity is given to the appellant counsel, and if appellant counsel doesn't appear in the next date of hearing, since this is the matter of the year 2018, appeal will be dismissed for non-prosecution. This matter on 13/6.
42.
Mahesh, CM.
My lord, appearing for the appellant, my lord. I already informed the respondent. Some inconvenience today. Kindly have grant 1 week.
ನೀವೇ ಅರೇಂಜ್ ಮಾಡ್ಕೊಬಿಟ್ರೆ ಹೆಂಗ್ರಿ?
I just informed the senior counsel who is waiting for.
How many times court has to read the papers? Decreed as absolute owner in respect of A scheduled property, in respect
Please,
of
my lord. There is a suit
direction is given to B scheduled property to hand over the possession.
weeks time may be granted.
ಏನ್ ನಿಮ್ಗೇನ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಏನ್ ಹೇಳಿ?
ನಂಗೆ ಸ್ವಲ್ಪ ಥ್ರೋಟ್ ಇನ್ಫೆಕ್ಷನ್ ಆಗಿ ನಂಗೆ
ಚೆನ್ನಾಗಿ ಮಾತಾಡ್ತಾ ಇದ್ರೆ ನನಗೆ ಚೆನ್ನಾಗಿ.
It is not my voice.
Appellant counsel seeks time on the ground that he is suffering from throat infection and already intimated counsel for respondent and hence list this matter on 13/6.
Please, ma'am.
ಒಳ್ಳೆ ಔಷಧಿ ತಗೊಳ್ಳಿ ಅಷ್ಟೊಳಗೆ.
43. Prakash Hegde.
ಪ್ರಕಾಶ್ ಹೆಗಡೆ, ಕೆ ಮೋಹನ್ ಕುಮಾರ್, others are all served ಅಲ್ಲ?
Yes, sir.
ಹೇಳಿ counsel.
D.
Suit
Father
for
of the
partition.
Partition.
1/4 share
Yes, sir. The property was
in respect of 1/2 share. ಈಗ ನಾವು modified as 1/8 share
1/8 share.
in item number 1 and 2.
Yes.
Yes,
Fellowship,
what is the
originally the property was granted in favor of the father of the plaintiff. It was a
It appears a daughter suit.
daughter suit.
ಹಾ
Daughter suit.
ಹೌದು
ಅಲ್ಲ ಇಲ್ಲಿ ಏನು see there is no partition effected between the party.
ಆಯ್ತು.
ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದರೆ the royal court has held the land is granted for the benefit of the entire family for the purpose of cultivation cannot be considered as self-acquired property. This is the consideration they have taken. In fact, the land was granted for the purpose of in favor of the
Granted in favor of the father.
father.
ಹೌದು, ಆಯ್ತು
It is a self-acquired property of the father.
ಆಯ್ತು. ಈಗೇನ್ ಶೇರ್ ಅಂಡ್ ಡಿಫರೆನ್ಸ್ ಹಾಕಲ್ವಲ್ಲ ಈಗ?
ಅಲ್ಲ ಆಗುತ್ತೆ ಈಗ.
ಹೇಗೆ?
ಈಗೇನಾಗಿದೆ ದಿ ಫಾದರ್ ಅನ್ನಯ್ಯ ಪೂಜಾರಿ
ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ?
ಅಪೀಲ್ ಅಲ್ಲಿ 1/8 half of 1/4 in half ಅಂತ ಮಾಡಿ 1/8 ಅಂತ ಮಾಡಿದ್ವಿ, ಅಲ್ಲಿ 1/4 ಅಂತ ಮಾಡಿದ್ರು, ಹಾಫ್ ಅಲ್ಲಿ 1/4 ಅಂದ್ರೆ ಇವರು ಸ್ಟ್ರೈಟ್ ಆಗಿ 1/8 ಅಂತ ಹೇಳಿ.
ಅಪೀಲ್ ಅಲ್ಲಿ 1/8 ಆಗಿರೋ ತಪ್ಪು 1/4 ಆಗ್ಬೇಕು ಅಂತ ನಿಮ್ ಕೇಸ್ ಅಷ್ಟೇ ಅಲ್ವಾ ಈಗ?
ಹೌದು
ಹಾ
ಹೌದು.
ಹಾ
ಅಲ್ಲ ಅಲ್ಲೂ 1/4 ಮಾಡಿಲ್ಲ, ಹಾಫ್ ಅಲ್ಲಿ 1/4 ಮಾಡಿದ್ರು ಅಲ್ಲಿ.
ಹಾಫ್ ಯಾಕೆ ಮಾಡಿದ್ರು?
ಅದು
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಫ್
Trial-
ಶೇರ್ ಅಂತಾರೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಯಾವ್ದು ಹಾಫ್ ಶೇರ್? ಯಾವ್ದು ಯಾರ್ದು ಹಾಫ್ ಶೇರ್? Whether the plaintiff proves that suitable properties are on the Hindu undivided joint family properties of the plaintiff and defendants entitled for 1/4 share. 1/4 share ಆಯ್ತು. Whether the plaintiff is entitled for father ಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳಿದಾರ್ರಿ?
3 ಜನ.
3 ಜನ.
3 ಜನ.
ಹಾ 1/4 ಯಾಕೆ ಮಾಡಿದ್ರು? Father is alive or not?
ವೈಫ್.
Father is alive or not?
No, he is dead.
Huh?
He is dead.
He is dead.
Dead.
ಈ ವೈಫು 3
ವೈಫ್
ಜನ
3
ಮಕ್ಕಳಿದ್ದಾರೆ.
ಜನ ಮಕ್ಕಳು.
4 ಜನ ಇದ್ದಾರೆ.
4 ಜನ.
ಹಾ 1/4 ಮಾಡಿರೋದೇ
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಸರಿ, ಹಾಫ್ ಅಂತ ಮಾಡಿದ್ರೆ ತಪ್ಪಷ್ಟೇ
ಹೌದು
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೌದು.
ಈಗ ಇವ್ರೇನ್
ಇವ್ರು
ಮಾಡಿದ್ರು?
ಮಾಡಿದ್ರೆ 1/8 ಅಂತ.
1/8 in 1 and 2 items ಅಂತ ಮಾಡಿದ್ರು.
ಹೌದು. ಹಾಫ್ ಅಲ್ಲಿ
ಎರಡು ಪ್ರಾಪರ್ಟಿ ಗ್ರಾಂಟೆಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದಿ ಫಾದರ್.
Father.
ಐಟಮ್ ನಂಬರ್ 1 and 2.
One was father, it was a granted land. The second one was a site, a small house.
ಸೈಟ್
ಹೌದು.
ಯಾರ ಹೆಸರಲ್ಲಿ ಇದೆ ಅದು?
ಅದು ತಂದೆ ಹೆಸರಲ್ಲಿತ್ತು. ಈಗ
ತಂದೆ ಹೆಸರಲ್ಲೇ ಇದೆ.
ಹೌದು.
ತಂದೆ
There's no dispute. There's no dispute.
father has not made any
No.
testamentary
No,
document.
no.
And then it has
Admitted.
been modified, that's all.
Yes, sir.
ನೋಡು, ನೀವು ಅಪೀಲ್ ನೀವೇ ಹಾಕಿರೋದ ಅಥವಾ
ಹೌದು. ನಾವ್ ಹಾಕಿದ್ವಿ.
ಅಪೀಲ್ ಅಲ್ಲಿ 1/4 ಕೊಟ್ಟಿರೋದು ಹಾಫ್ ಶೇರ್ ಅಂತ ಮಾಡಿರೋ ತಪ್ಪು ಅಂತನಾ?
ತಪ್ಪು ಅಂತ ಹೇಳಿದ್ವಿ. ಇಲ್ಲಿ ಅದನ್ನ ಬಂದು ಹಾಫ್ ಅಲ್ಲಿ 1/4 ಅಂತ ಅಲ್ಲಿ ಹೇಳಿದ್ರು, ಇಲ್ಲಿ ಬಂದು 1/8 ಅಂತ ಹೇಳಿದ್ರು. ಅಪೀಲ್ ಅಲ್ಲಿ ಬಂದ್ರೆ
1/8 ಯಾಕೆ ಮಾಡಿದ್ರು? ರೀಸನ್ ಏನು?
ಅವರದ್ದು ರೀಸನ್ ಏನಂದ್ರೆ the land was granted for the benefit of the entire family for the purpose of cultivation. So it cannot be considered as self-acquired property of the father, though it was granted in the individual name ಅಂತ ಹೇಳ್ಕೊಂಡು he takes the
ಏನಿದೆ ಅದು? ಆ reason.
page number 35 ಅಲ್ಲ, internal page number 9.
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 2 ಮಾತ್ರ ಕಂಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸ್. ಹೌದಾ?
ಹೌದು.
ಕಂಟೆಸ್ಟೆಡ್
ಉಳಿದವರೆಲ್ಲ considered for the purpose. Fellowship, internal page number 9 of the appellate court judgment. Hence, the property has been granted as per the land rules and has been given for the benefit of the entire family for the purpose of cultivation. Hence, it cannot be considered as self-acquired property, but it is a joint family property which will ensure the benefit of the entire family, though it is granted in the individual name of Annaya Pujari. Hence, the
ಯಾವ ಪ್ಯಾರಾದಲ್ಲಿ ಇದೆ?
para number 17 of the appellate. 17. Page number 9.
Joint name of defendant number 1, Lakshmamma and Rafnesh, who is husband of defendant number 2.
Yes. After the death of the
father,
yes,
it was mutated in
the name of the son, and
that suit property were acquired by Annaya Pujari is not in dispute.
John dispute.
The only contention is the defendant number two acted as the karta of the family and spent considerable amount and plaintiff had agreed to give 1/12 share to Ramesh. Is there any averment in the grant order that it is in favor of entire family in the?
Your lordship, it is not your lordship. The land was granted in favor of the.
Grant order ಆ ರೀತಿ ಏನಾದ್ರು ಇದೆಯಾ?
ಇಲ್ಲ,
ಇಲ್ಲ.
ಇಲ್ಲ. Having the grant order.
ಇವ್ರು ನೋಷನಲ್ ಪಾರ್ಟಿಷನ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿ.
Heard the appellant counsel. This matter is listed for admission and I heard the appellant counsel. The suit is filed by the appellant, public plaintiff before the trial court seeking 1/4 share. In respect of social properties, contending that social properties are Hindu undivided joint family properties of the plaintiff and defendants and hence entitled for 1/4 share. Only the second defendant, who is the wife of
Deceased.
Ramesh, contested the matter. Yen defense and ಅವ್ರದ್ದು?
Defense in the, during the lifetime of Ramesh, it was agreed that he will take half portion of the.
That her husband was managing the family affairs and he was acting as karta and admitted the relationship between the parties. It is contended that earlier house was dilapidated house and he constructed new house situated at present in the suitable property, investing all the funds. He also converted the wetland, a scheduled property into garden land with his hard-earned money, as he was a contractor and skilled man. He also borne the expenses of marriage of his sisters, that is plaintiff and defendant number 5, by borrowing loans from the firms. And it is contended that her husband, Ramesh, is having half share in A and B scheduled properties. Therefore, Kata was changed in the joint names of Lakshmamma and Ramesh, and subsequently Kata was changed to the names of defendant number 1 to 4. And hence not entitled for any relief. The trial court, having considered both oral and documentary evidence, comes to the conclusion that land was granted in favor of the father Annaya Pujari. And also comes to the conclusion that social properties are Hindu undivided joint family properties of the plaintiff and defendants. And answered the issue number 1 as affirmative. However, answered issue number 2 as partly affirmative. In coming to the conclusion that the plaintiff is entitled for 1/4 share over the suit scheduled properties.
ಇಲ್ಲ.
Or
1/4 share.
1/4 share.
In the half share.
In the half.
Share allotted to the deceased father.
share allotted to the in the half share of the total properties.
1/4 share in half of the 1/8.
And hence being agreed by the said judgment and decree, an appeal is filed by the plaintiff in RA. The appellate court also allowed the appeal in part and comes to the conclusion that the grant made in favor of the father is in favor of the family for the purpose of the cultivation. And only the daughter is entitled for a notional partition and hence entitled for 1 share in the social property. And defendant number 2, who is the wife of Ramesh, is entitled for 5/8 share in the social properties along with defendant number 3 and 4 by effecting partition by meets and bounds. And modified same as 1/8 share being agreed by the said judgment of the trial court as well as the first appellate court. The present second appeal is filed before this court. This court has issued notice against the respondents and being served, and none of them have represented before this court. Having heard the appellant counsel and also on perusal of material, when the trial court comes to the conclusion that the suit settled properties are Hindu undivided joint family properties, and answered the issue number 1 as affirmative, and committed an error in granting 1/4 share in the half of the suit settled properties. And the very approach of the trial court is erroneous, and appellate court also committed an error in coming to the conclusion that grant made in favor of the father is in favor of the entire family for the purpose of cultivation. And admittedly, when the grant is made in favor of the father, and when there is no any testamentary document, and when the father left his wife and 3 children, ought to have invoked section 8 of Hindu Succession Act. The trial court as well as the first appellate court committed an error. Even assuming that if the property is granted in favor of the family also, and when there was no any partition among the members of the family, and records also discloses that after the death of the father, only Khata has been changed in the name of the second, in the husband of the second defendant, and also the mother. And there was no any partition in the family. And when such being the factual aspects of the case, ought to have invoked section 8 of Hindu Succession Act and granted relief of 1/4 share, and appellate court also committed an error in granting 1/8 share. And also invoking of principles of notional partition is also erroneous on the part of the first appellate court, and hence matter requires the reconsideration, and accordingly the judgment and decree of the trial court as well as the appellate court is modified, granting 1/4 share in favor of the plaintiff appellant in the suit settled properties. Remaining matters at 2:30.
Kind permission. My lord, kind permission. Serial number 51, my lord.
Serial number?
51, my lord. My day's accommodation, my lord. Afternoon, I have to take my mother to the hospital. 51. ಕಣ್ಣು ಟೆಸ್ಟ್ ಮಾಡ್ಸಕ್ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ನಾಳೆ ಹಾಕೊಂಡ್ರೆ.
Apparent counsel seeks time on the ground that he is having some inconvenience and he has to take his mother to the hospital. Hence list this matter on 13/6.
57 my lord. Morning I moved.
57. ಹೇಳಿ ಏನಾಗ್ತದೆ?
I informed my lord.
ರವಿಶಂಕರ್ ರೆಡ್ಡಿಗೆ ಹೇಳಿದಿರಾ?
ಹೇಳಿದ್ದೀನಿ ಅವರೇನು ಬರ್ತಿಲ್ವಂತೆ. ಇವನ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ದಿ ಲಿಸ್ಟಿಂಗ್ ಅಂತ.
ಮತ್ತೆ ಯಾರಿಗೆ ಹೇಳಿದಿರಾ? ಅವ್ರ ಕೊಲೀಗ್
ರವಿಶಂಕರ್ ರೆಡ್ಡಿಗೆ ಹೇಳಿದೆ. ಇಸ್ ಕೇವಿಯೇಟರ್.
ರವಿಶಂಕರ್ ರೆಡ್ಡಿಗೆ ಹೇಳಿದಿರಾ?
ಪ್ಲೀಸ್ ಹೇಳಿದ್ದೀನಿ.
ಸರಿ. ನೀವು ಅಪ್ಲೆಂಟ್ ಅಲ್ಲ?
ಪ್ಲೀಸ್ ಐ ಆಮ್.
Appellant counsel seeks time and also counsel submits that he has already intimated counsel for the caveator for R4 and R5. And hence this matter on 13/6.
My lord, serial number 63, my lords. I'm for the appellant, my lord.
ಎಲ್ಲಾರು ಟೈಮ್ ಕೇಳ್ರಿ ಏನ್ ಮಾಡಿದ್ರಿ ಕೆಲಸ ಮಾಡ್ಬೇಡ
My lord, some personal inquiry. Senior is not feeling.
63.
I appear for the respondents 1 and
63, my lords.
63. Why you want time? Final hearing ಅಲ್ವಾ?
Final hearing, my lords.
2018.
In next week, any date, my lord. Senior is not well, my lord. He is some has throat infection.
Appellant counsel, the third junior counsel seeks time on the ground that senior counsel is not feeling well. Counsel for R1 and R2 is also present. List this matter on 13/6.
Please.
ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ಬೇಡಿ.
Oh.
ಇವಾಗ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಮುಂದಿನ ಸರಿ ಡೇಟ್ ಕೊಡಲ್ಲ.
Please, sir.
Serial number 50.
ಸೀರಿಯಲ್ ನಂಬರ್
50.
50 ಏನಾಗ್ಬೇಕು ಕೇಳಿ.
Weeks time.
ಹಾಫ್ ಸೆಂಚುರಿ ಹೊಡೆಯೋದ್ಬಿಟ್ಟು ಏನ್ರಿ ಇದು ಟೈಮ್ ನೀವು? ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಇದೆಯಲ್ಲ, ಹಾಫ್ ಸೆಂಚುರಿ ಹೊಡೀರಿ ಮತ್ತೇನು? ನೀವ್ಯಾರಿಗೆ? ಅಪಲೆಂಟ್ ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ಅವ್ರಿಗೆ ಹೇಳಿದೀರಾ?
ಫಾರ್ ರೆಸ್ಪಾಂಡ್
ಹಾ
R1.
ಟೈಮ್ ಕೇಳ್ತಾರಲ್ಲ.
ನಾವು ರೆಡಿ ಇದೀವಿ ಅವ್ರು.
ನೀವು ರೆಡಿ ಇದೀರಿ, ಕೊಡ್ಬೋದಾ ಇಲ್ವಾ ಅಷ್ಟೇ ಹೇಳಿ.
ಕೊಡ್ಬೋದು.
ಇದೇನೋ ಇಲ್ಲೊಂದು ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಏನಾಗಿದೆ ಅಲ್ರಿ, ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಸ್ಟೆಪ್ಸ್ ಬೈ ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪಲೆಂಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಅನ್ಸರ್ವ್ಡ್ R3 ಸಿನ್ಸ್ 3 times ನೋಟಿಸ್ ಇಶ್ಯೂಡ್ ಅಂತಿದೆ. R3 ಸರ್ವಿಸ್ ಆಗಿಲ್ವಲ್ಲ? ಡಿಲೇ ಬೇರೆ 1754 ದಿವಸ ಇದೆ. ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಅಲ್ಲೂನ ಎರಡರಲ್ಲೂ ಡಿಲೇ ಇದೆಯಲ್ರಿ. ಮೊದ್ಲಿಂದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ? ಇವರೇ ನೀವು ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ವಾರಂಟರಿ ಆಗಿ ಬಂದ್ರ ಅಥವಾ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿತ್ತು?
ನೋಟಿಸ್ ಆಗಿತ್ತು. ವಿ ಫೈಲ್ಡ್ ಅ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ವಿತ್ ಡಿಲೇ.
ಅದ್ರಲ್ಲಿ ಸರ್ವ್ಡ್ ಆಗಿದೆ, ಫಸ್ಟ್ ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ. ನೀವು R3 ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ. ತಗೊಳ್ಳಿ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿ ಫಸ್ಟ್. ದ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ಸ್ ಟೈಮ್ and council is also directed to take steps against R3 in RSA 2226 of 2018 within 3 days. If PF paid, issue notice against R3. List this matter on. Yadar date kodi madam. 13/6 ಒಳಗೆ ಹೋಗಿ ಬರಲ್ಲ, ಹೋಗುತ್ತಾ? 24/6 PF ಕೊಡ್ಬೇಕ್ರಿ 3 ದಿವಸದಲ್ಲಿ. ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಂತ ಅಲ್ಲೇ ಹಾಕ್ಬಿಡಿ. PF not paid, list this matter on 10/6.
ಹೌದೌದು. ಕೇಳ್ತೀನಿ. ಸರ್ ಅದೇ ನಿಮ್ದು ಫೈನಲ್ ಆರ್ಡರ್ ಆದಂಗಲ್ವಾ? ನಿಮ್ದು ಫೈನಲ್ ಆದಂಗ ತಾನೆ ಅದು? ನಿಮ್ದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತಲ್ವಾ? ಹಾ ಏನಾಗಿದೆ? ಮಾಡಿಫೈ ಮಾಡಿದ್ರಲ್ವಾ? ಅಷ್ಟೇನಾ? ಅಂದ್ರೆ ಇಲ್ಲೇ ಡಿಸೈಡ್ ಆದಂಗೆ ಅಷ್ಟೇ. ಅಂದ್ರೆ ಅದು ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಂತ ತೋರಿಸ್ಕೊಂಡ್ಬರಲ್ವಾ? ಅಂದ್ರೆ ಅದು
ಮಾಡಿ
Sorry, ಯಾವ್ದು ಇಲ್ವಾ?
45. Srihari K. Kumar Jain.
Lord, suit is for recovery of money and this is defendant's appeal on
Yes, sir.
divergent finding.
Same was dismissed in the appellate court is what reverse.
ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು, ಫಸ್ಟ್ ಅಪೆಲೇಟ್
Appellate court ಅಲ್ಲಿ reverse ಮಾಡಿದ್ದಾರೆ.
ಡಿಕ್ರಿ ಆಯ್ತು. ಹೌ
1,47,446 with 9%
How?
interest.
ಹೌ ಮೆಲೋಡ್ some dates are necessary, ಮೆಲೋಡ್ may mention, ಮೆಲೋಡ್, because limitation issue is there. So on 23/11/2000, ಮೆಲೋಡ್ಸ್
23/11.
23/11/2000, ಮೆಲೋಡ್ಸ್ loan was disbursed. On the very same day, hypothecation agreement was also entered into. But on 19/11/2003, they claimed that there is acknowledgement of debt as per Exhibit P6. But on 4/11/2006, demand notice was issued. 4/11/2006. Although reply was given, it is stated in the plaint that it was received without demur, and reply dated 25/11/2006. Mallots on 31/3/2003, movables of the defendant was attached. So the prima facie contention of the plaintiff that there is acknowledgement of debt dated 19/11/2003 is impossible, because even before that there was a tussle between the parties. But now I draw the attention of the court to the issues framed by the trial court. May I draw the attention of the court to page number 43, my lords?
Yes.
My lord, issue number 1 and 2 and 3 were held affirmatively. And issue number 4 ಗೆ ಬಂದಾಗ, what the court had held is, in view of the fact that there is a issue of notice under section 13(1) of SURFACE Act, already process has begun based on the judgment of the Mumbai High Court, my lords. The court declined to grant the relief. Being aggrieved by that, my lords, Lord, the bank had filed the appeal. What the first appellate court has done is,
What happened in SURFACE Act proceedings?
ಅದು ಮಾಡ್ಲೇ ಇಲ್ಲ, ನೋಟಿಸ್ ಕೊಟ್ಟು ಬಿಟ್ಬಿಟ್ರು.
Notice ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
But they have not initiated.
ಏನು ಮಾಡ್ಲಿಲ್ಲ. But the judgment says, the judgment relied by the trial court says, once they initiate the proceedings by issuance of notice, where in future if they can proceed, the jurisdiction is barred. That is what the judgment says. My lord, that apart, now issue number 1 and 2, which were held against me, I have not challenged the same by filing the appeal. What the first appellate court has held is, my lord, I have not challenged those issues.
Issue number 1 and 2.
ಹೌದು. ಆ ಫೈಂಡಿಂಗ್ ಅನ್ನು ನಾನು ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ. Therefore, that need not be considered. May I draw the attention of the court to page number 20, my lords? Para 14, my lords.
Proves that the impute judgment and decree passed by social source is contrary to law and facts illegal and perverse and probabilities of the case, and as such the same is liable to be interpreted with.
ಅಲ್ಲ, ಅದು ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಇಶ್ಯೂ. ಅದೇ ಪೇಜ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ 14, para 14, my lords. But in this case, no cross appeal filed by defendant against finding on issue number 1 to 3. Thus, the findings given by the trial court relating issue number 3 is not at all challenged by the other side. However, order 41's rule 33 of CPC reads as follows. ಆಮೇಲೆ ಅದಕ್ಕೆ ಜಜ್ಮೆಂಟ್ ಗಳನ್ನೆಲ್ಲ ಕೋಟ್ ಮಾಡಿದ್ರು. My lord, I draw the attention of the court to page number 23, para 15. Thus, may I read it? Thus, even though
the respondent defendant has not filed the appeal or cross objection pertaining to the findings on issue 1 to 3 by the trial court, still discretionary power can exercise by this court under order 41 rule 33 CPC. Therefore, the findings given by the trial court on issue number 1 to 3 is correct or not can also be considered by this court. ಅಷ್ಟು ಹೇಳ್ತಾರಲ್ಲಿ. ಆಮೇಲೆ next paragraph ಗೆ ಬರುವಾಗ ಅದು ಹೇಳಿದ್ದು ಸರಿ ಅಂತ ಹೇಳ್ತಾರೆ. In this case, in para 7 of written statement, the first defendant has clearly stated that he has not in due of any amount to the bank, plaintiff bank, and the plaintiff bank has already recovered the entire due amount prior to filing the suit. Thus, the defendant number 1 has admitted the loan transaction. Further, the documentary evidence produced by the plaintiff bank, that is exhibit P1, loan application exhibit P2, demand promissory note exhibit P3, undertaking letter, clearly reveals that the defendant number 1 being the principal borrower and defendant number 2 being the co-obligant have availed loan of rupees 90,000 by executing loan papers and agreed to pay interest at 12.5% per annum compounded quarterly rests. ಇಷ್ಟೇ ಹೇಳಿ ಬಿಟ್ಬಿಡ್ತಾರೆ. Holding that issue number 1 and 2 need not be discussed.
Yes.
My lord, next is another ground which I am relying on. Para 17, my lords. Para 17, my lords, is with respect to acknowledgement of debt. My lord, that is exhibit P6. My lord, my submission to the same is, except marking, no further efforts have been made by the bank to prove the said document, especially when I have denied my signature found in the said document. My lord, the probative value of that document has not been considered. My lord, if the document is just marked, that would not be sufficient. I have specifically denied such execution of such a document, more particularly when there is already dispute between me and bank. My lord, I am signing a acknowledgement of debt, that too after 6-7 months of the seizure of my materials from my shop wouldn't arise. But specifically for that reason, in the written statement, I have specifically contended that I have not signed that document. Once there is a specific contention in the written statement, it was the duty of the bank, not just marking the document. My lords, it is the principles of law that mere marking of the document, my lord, would not suffice to prove the document. Marking is only for the purpose of identification of the document before the trial court. So probative value of that document was not considered. On the other hand, it was held to be proved.
Yes.
My lord, the next ground is, my lords.
Only two substantive question apply you have framed, that's all.
How?
One is with regard to the acknowledgement. Another is with regard to the invoking of Service Act.
How? Insofar as that is concerned, my lord.
Sukumar Jain are ilva, madam. Third. Heard the appellant counsel and counsel for the respondent is absent. This matter is listed for admission.
My lords, one day delays there, my lords, I have filed application.
ಇದೆಯಾ
ಒಂದು ದಿನ
ಇದನ್ನ ಮಾಡಿಲ್ವಾ
ಅಲ್ಲ ಇದೆ ಐಎ ಇದೆ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಿರಲ್ಲ ಅದರ
ಮಾಡಿದೆ
ಯಾಕಿಂತ ಮುಂಚೆ there is a delay of 1 day in filing the second appeal and for the reasons stated in the accompanying application and affidavit and also the respondents have not filed any objections, delay of 1 day is condoned. Next, this matter is listed for admission and I heard the counsel for the appellant and counsel for the respondent is absent. This second appeal is filed against the divergent finding and trial court dismissed the suit and first appellate court reversed the same. The main contention of the counsel appearing for the appellant that appellate court was not justified in holding that the acknowledgement of debt exhibit P6 is proved. And also suit itself is not maintainable once the proceedings under Surface Act has been initiated by the bank. without recalling the said initiation of the proceedings. The council also would vehemently contend that the very approach of the appellate court is erroneous in coming to the conclusion that the finding of the trial court in respect of issue number 1 to 3 have not been challenged. And hence matter requires reconsideration, and hence this court has to frame the substantive question of law. Having heard the appellant counsel and also on perusal of judgment of the trial court, and trial court dismissed the suit, and the same is reversed in the judgment of the appellate court. And moot question raised before this court is with regard to the proving of document exhibit P6, and also with regard to the maintainability of the very suit when the surface proceedings has been initiated by issuing the notice. In view of the grounds which have been urged in the second appeal, matter requires to be considered. And also there is a divergent finding with regard to the factual finding as well as question of law. Admit the following substantive question of law are framed for consideration of this second appeal. Whether the first appellate court is justified in coming to the conclusion that exhibit P6 acknowledgement of debt is proved. Whether the very initiation of whether the issuance of notice to invoke Surface Act itself bars the initiation of civil proceedings by filing a suit for recovery of money. Records bandillala? Bandidya? Filing of paper book is dispensed.
Please.
List this matter for final hearing in the first week of July.
But I have filed application for stay, my lord.
Heard on heard on IA number 1 of 19 for stay, and in view of concurrent finding, divergent finding, as well as this court comes to the conclusion that matter requires reconsideration, and also admitted this appeal and framed substantive question of law, it is appropriate to stay the judgment and decree of the first appellate court till the disposal of this appeal. Great.
46, Jitendra Kumar.
Heard the appellant counsel on IA 1 of 2019, and there is a delay of 1 day in filing the appeal, and delay of 1 day is condoned.
Please. This is plaintiff's appeal, my lord. Plaintiff filed a suit for declaration and permanent injunction in respect of land, new survey number 131, old survey number 63, my lord, measuring 4 acres. Contending that land was originally granted to his father in the year 5960, and Hakkupatra was issued on 39/1996. And afterwards, my lord, 4D work was done, a new survey number was assigned. And there was interference by the defendants. Present suit has been filed. Defendants contended that, my lord, survey number 63, my lord, it's a vast extent, contains vast extent of land. So they say they were in an unauthorized occupation, and there was regularization order, and there was a partition, and they have not interfered. And the land claimed by the plaintiff is not existing.
The finding of the first appellate court?
First appellate court says, the trial court says, my lord, the grant is admitted, entries, those things they admit. Therefore, my lord, decreed the suit. The first appellate court says, my lord, because plaintiff says he has in his deposition, cross-examination
regarding identification of the
on the one day ground mele, my lord, no suit has been dismissed. Though the plaintiff has established it.
So, this matter is listed for admission and heard the counsel appearing for the appellant. This second appeal is against the divergent finding, And first appellate, and the trial court has granted the relief of declaration, declaring that the plaintiff as the owner, based on particularly exhibit P1, grant certificate. And also other revenue documents, exhibit P2 to P5. And also council brought to notice of this court that the body work also done and new number has been assigned as survey number 131 instead of old survey number 63. Howda?
Please.
And the well-reasoned order has been passed by the trial court, but council would submit that the first appellate court committed an error in reversing the finding only on the ground that that there is no identification of the property. Since PW1 admitted that he was not present when the new number was assigned, and also he is not aware of the boundaries after the Durast. The council brought to notice of this court paragraph number 20 of the judgment of the appellate court and matter requires reconsideration. Having heard the appellant counsel and also the plaintiff claiming the relief of declaration to declare him as owner based on the revenue, based on the grant order as well as other revenue records. And trial court also accepted the same, and first appellate court reversed the same, particularly in discussing in paragraph number 20 with regard to the boundaries concerned. And also taken note of the admission on the part of PW1 with regard to the boundary after the Durast. Matter requires reconsideration since boundary will not change the way, and the very existence of the property will continue, and only the new number will be assigned after the body work. And when such discussion is made in paragraph number 20, matter requires reconsideration. Admit whether the following substantive question of law framed for the consideration of this second appeal. Whether the first appellate court committed an error in reversing the finding of the trial court only considering the admission on the part of DW1 with regard to the boundaries of boundaries has not been known to him after the Durast. That is the only main ground.
In the absence of any challenge to the grant.
And in the absence of any challenge with regard to the grant. Whether the first appellate court committed an error in ignoring the material on record, the same amounts to perversity. These are the two. Issue notice against the respondent. Filing of paper book is dispensed.
For
this matter for final hearing in the first week of July. 1 month vehicle. Records over notice jari agಬೇಕು.
Interim prayer ಕೇಳಿದನೆ. Interim prayer ಕೇಳಿದನೆ. Injunction ಕೇಳಿದನೆ.
ಮೊದಲೇನಾಗಿತ್ತು ಇಂಜಂಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು.
ಇಂಟ್ರಿಮ್ ಮಾಡಿರ್ತ
ಅಲ್ಲಿ ಅಪಲೇಟ್
ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಅಲ್ಲಿತ್ತ ಅಂದೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಂಜಂಕ್ಷನ್ ಡಿಕ್ರಿ ವಾಸ್ ಗ್ರಾಂಟ್.
ಅಲ್ಲ ಡಿಕ್ರಿ ಮೇನ್ ಡಿಕ್ರಿ ಇತ್ತು. ಬಟ್ ವೆದರ್ ಯು ಹ್ಯಾವ್ ಎಂಜಾಯ್ಡ್ ದಿ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್
ಅದು
ಇಲ್ಲ. ಆಯ್ತು ಬರ್ಲಿ ಬರ್ಲಿ ನೋಡೋಣ ನೋಟಿಸ್.
ಸ್ಟೇಟಸ್ ಕೋ ಟು ಬಿ ಮೇಂಟೈನ್ಡ್.
In the meanwhile, parties are directed to maintain status quo.
Please. Appellate.
47 adjourned, 48 adjourned, 49. Vinay Kirtiyam. CN Venugopal.
Appear for
Your Lordship. Injunction decreed, dismissed, and same is reversed in the appeal.
Your Lordship, the contention of that the plaintiff is that, Your Lordship, they are the owner of the 2 acres 24 guntas in survey number 40, 41, 40, 42, 43. So, and dig the bore well of the in their property. So they are the owners and purchased the same, being a Kaya Industries. Your Lordship, previously, the appellants herein filed the injunction suit in OS 156 of 2006 against the employees of the said industry. The same has been decreed. The said decree is not binding on them. That is their prayer. Your Lordship, against that, the defendant's contention is that they are the owner of the sites in site number 12. There is a converted land, the same allotted through their partitions. Then after Kata was, conversion order was effected by the Assistant Commissioner. After the conversion order, municipal Kata has been given. So they are in possession, all other things. Earlier, they tried to interfere. The very same party who is a manager, regional manager, and against the deputy manager, we prefer the suit for the injunction. The said suit has been decreed. There, the categorical findings is given by the court is that the specific on the basis of the sketch and assistant commissioners who prepared the survey, all other things, the appellants herein are in possession and enjoying the same. Now the trial court rightly appreciating that, Your Lordship, the only the bill submitted by the plaintiffs showing that they dig the borewell of the borewell lorry company's one bill. That is true. That bill is not standing in their name. That is, that finding is at page, Your Lordship, 13 page, para 18 of the trial court, where the trial court categorically findings is that on careful perusal of the receipt of the said borewell agency as issued Exhibit P8 in the name of one RM Tiptur, prima facie it shows the said Exhibit P8 is not at all related to the plaintiff corporation of the plaintiff unit situated at Ganchegatta Taluk. So, very on the basis of the very same exhibit, appellate courts reverses that. Your Lordship, kindly I rely on the cross-examination of the PW1. In his cross-examination, he categorically admitted that B schedule property belongs to the appellants. And
which schedule property?
That B schedule property belongs to the appellant, that survey the site numbers. And also, actually, after the A schedule property, in between one road comes, after the B schedule property comes. Only on the ground that we are digged that borewell for that reasons. Your Lordship, they themselves is admitted is that no point of time they conducted any survey of their land. The trial court rightly appreciating the same. And even though he is a party to the earlier suit, he denied that I'm not a party. They filed the suit against only Rangappa, but both the courts consider that also he is also the party to the said suit. The findings of the said suit is binding the trial court. However, the appellate court only on the basis of the Exhibit P8. Your Lordship, permit me to read the one paragraph of their cross-examination. ಈಗಿನ ಪ್ರತಿವಾದಿಯು ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನನ್ನ ಮತ್ತು ರಂಗಪ್ಪ ಇಬ್ಬರ ವಿರುದ್ಧ ಅಸಲು ದಾವಾ 158/2008 ಇದನ್ನು ಸಲ್ಲಿಸಿದ್ದರು ಎಂದು ಪ್ರಶ್ನೆ ಮಾಡಿದಾಗ ನನ್ನ ವಿರುದ್ಧ ದಾವಾ ಹಾಕಿರಲಿಲ್ಲ, ಅದನ್ನು ಕೇವಲ ರಂಗಪ್ಪರ ವಿರುದ್ಧ ಹಾಕಿದ್ದರು ಎಂದು ಉತ್ತರಿಸಿದರು. ನಮ್ಮ ಸಂಸ್ಥೆಯಲ್ಲಿ ಶಿವಣ್ಣ ಎಂಬ ಹೆಸರಿನ ವ್ಯಕ್ತಿ ಯಾರು ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ. ಈ ದಾವೆ ತೀರ್ಪಿನಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ. ಈ ಕೇಸಿನಲ್ಲಿ
ಎವಿಡೆನ್ಸ್ ಆಫ್ PW1.
PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಥರ್ಡ್ ಪ್ಯಾರಾ. ಈಗಿನ ಪ್ರತಿವಾದಿ ಇದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನನ್ನ ಮತ್ತು ರಂಗಪ್ಪನ ವಿರುದ್ಧ ಅಸಲು ದಾವಾ 158/2008 ಇದನ್ನು ಸಲ್ಲಿಸಿದ್ದರು ಎಂದು ಪ್ರಶ್ನೆ ಮಾಡಿದಾಗ ನನ್ನ ವಿರುದ್ಧ ದಾವಾ ಹಾಕಿರಲಿಲ್ಲ, ಅದನ್ನು ಕೇವಲ ರಂಗಪ್ಪ ಇವರ ವಿರುದ್ಧ ಹಾಕಿದ್ದರು ಎಂದು ಉತ್ತರಿಸುತ್ತಾರೆ. ನಮ್ಮ ಸಂಸ್ಥೆಯಲ್ಲಿ ಶಿವಣ್ಣ ಎಂಬ ಹೆಸರಿನ ವ್ಯಕ್ತಿ ಯಾರು ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ. ಈ ದಾವೆ ತೀರ್ಮಾನ ಗೊತ್ತಿಲ್ಲ. ಈ ಕೇಸಿನಲ್ಲಿ ನಾನು ಮತ್ತು ರಂಗಪ್ಪ ಶ್ರೀ ಉದಯಕುಮಾರ್ ಇವರನ್ನು ನೇಮಿಸಿದ್ದವು ಎಂದರೆ ರಂಗಪ್ಪ ಮಾತ್ರ ಈ ವಕೀಲರನ್ನು ನೇಮಿಸಿದ್ದರು ಎನ್ನುತ್ತಾನೆ. ಈ ಕೇಸಿನಲ್ಲಿ ಈ ಪ್ರತಿವಾದಿಯರು ಯಾವ ನಂಬರಿಗೆ ದಾವಾ ಹಾಕಿದ್ದರು ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಸೈಟ್ ಪ್ರಾಪರ್ಟಿ ಖಾತಾ ನಂಬರ್ ಸೋನ್ಸೋ ಈ ಸೊತ್ತಿಗೂ ನಮ್ಮ ಸೊತ್ತಿಗೂ ಏನು ಸಂಬಂಧವಿಲ್ಲ. ದಟ್ ಇಸ್ ದ ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ. ಪ್ರತಿವಾದಿಯರು ಜಮೀನು ನಮ್ಮ ಜಮೀನಿನ ದಕ್ಷಿಣಕ್ಕೆ ಬರುತ್ತದೆ, ನನ್ನ ಜಮೀನಿನ ದಕ್ಷಿಣಕ್ಕೆ ಷಡಾಕ್ಷರಿ ಮಠ ಬರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಷಡಾಕ್ಷರಿ ಮಠದಿಂದ ಉತ್ತರಕ್ಕೆ ತಿಪಟೂರು ಹೊನ್ನವಳ್ಳಿ ರಸ್ತೆ ಇದೆ ಎಂದರೆ ಸರಿ. ಈ ರಸ್ತೆಯ ಉತ್ತರಕ್ಕೆ ನಮ್ಮ ಸಂಸ್ಥೆಯ ಸೊತ್ತು ಇದೆ. ಪ್ರತಿವಾದಿಯು 2 ಜಮೀನು ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರಕ್ಕೆ ರಸ್ತೆ ಇದೆ ಎಂದರೆ ಸರಿ. ದಕ್ಷಿಣ ದಿಕ್ಕಿನಲ್ಲಿ ಪ್ರತಿವಾದಿಯರಿಗೆ ನಂಬರ್ 2 ಇವರಿಗೆ ಸೇರಿದ ಸೈಟುಗಳು ಇವೆ ಎಂದರೆ ಗೊತ್ತಿಲ್ಲ. ದಕ್ಷಿಣ ದಿಕ್ಕಿನಲ್ಲಿ ಖಾಲಿ ಜಾಗ ಇದ್ದು ಅದರಲ್ಲಿ ಬೋರ್ವೆಲ್ ಇದೆ. ತಾವ ಜಮೀನನ್ನು ನನಗೆ ಗೊತ್ತಿರುವ ಹಾಗೆ ಯಾವ ಕಾಲದಲ್ಲಿಯೂ ಅಳತೆ ಮಾಡಿಸಿಲ್ಲ.
Sorry, madam. Heard the appellant counsel. This matter is listed for admission and I heard the counsel for the appellant. The counsel appearing for the appellant would contend that the trial court having considered material on record dismissed the suit which was filed for the relief of declaration and permanent injunction. In coming to the conclusion that plaintiff has not proved his title as owner and in possession of B scheduled property. And there was no any interference. The same is challenged in the appeal. In RA number 21/2010. In first appellate court committed an error in reversing the said judgment. Ignoring the admission given by PW1 wherein he categorically admitted the property of this appellant which is adjacent to the property of the plaintiff. And committed an error in reversing the same. And hence it requires interference. Having heard the appellant counsel and also on perusal of material and record, suit is filed for the relief of declaration and permanent injunction by the plaintiff in respect of Schedule A property to the extent of 2 acres 24 guntas. And in the suit is also mentioned the Schedule B, a portion of A schedule property consisting of a borewell point. And trial court comes to a conclusion that the plaintiff has not proved the case. The same is reversed. There is a divergent finding with regard to the appreciation of material on record, and also suit is for the relief of declaration and permanent injunction. And first appellate court mainly taken note of the answer illustrated from the mouth of DW1. And the counsel appearing for the appellant brought to notice of this court the admission given by PW1 with regard to the identity of the property is concerned, and property of the appellant is located adjacent to the property of the plaintiff. And appellant is also not claiming title in respect of the suit schedule property. ನೀವೇನ್ claim ಮಾಡ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ.
ನಾವೇನ್ ಕ್ಲೈಮ್ ಮಾಡೋದಲ್ಲ, ಅವರು ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇರೋದು ನಮ್ ಸೈಟ್ಸು ಎ ಶೆಡ್ಯೂಲ್ ಒಳಗೆ ಬರುತ್ತೆ ಅಂತ ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಮಾಡಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
And the claim of the plaintiff is comes within the property of the defendant. And when there is a clear admission on the part of DW1 regarding topography of the land of the suit schedule property and also the property of the defendant, and matter requires reconsideration. Admit whether the first appellate court committed an error in ignoring the admission on the part of PW1 in reversing the finding of the trial court, and whether the same amounts to perversity. That is the only substantive question of
the second one. Earlier OS suit, there is a categorical finding is that so we are the owner and in possession. Your
in
possession
respect of which property? Not in respect of suit schedule property.
A schedule, B property, B schedule property.
ಅದೇ ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಶೆಡ್ಯೂಲ್ ಇದೆ ಅಷ್ಟೇ ಇದೆ. ಆಯ್ತು ಅಷ್ಟೇ ಸರ್. The filing of paperwork is dispensed. List this matter for final hearing in the first week of July ಅಂತ.
50 to 52 urgent 53. Pundika Ishwar Bhatt.
Today, is personal in the 2 days time.
ಯಾರು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ವಲ್ರಿ ಬೆಳಗ್ಗೆ.
ಬರ್ಲಿಲ್ಲ
Third appellant counsel seeks time, and counsel for the respondent is also absent, and hence list this matter on 13/6.
54 Pallav R. MN Umar Shankar.
Suit for declaration, possession and injunction. Plaintiff's appeal. Concurrent findings. The only ground on which the second appeal is filed is the manner in which the first appellate court, my lord, dealt with the order 4127 application filed by the plaintiff. My lord, in that 4127 application was taken on record along with order 6 rule 17. A point for determination was also framed in the judgment whether such application is deserved to be allowed. But no discussion is made. Appeal is dismissed, and the applications were kept pending.
The appellant proves that the trial court committed an error in not considering the oral and documentary evidence in a proper perspective, not in accordance with law. Whether the appellant has made out sufficient grounds to consider the additional documents produced by him in this appeal, and to remand the matter for fresh trial. All the issues were considered together.
All the issues were considered, but no reference is made to the applications.
Order ಏನು ಇಲ್ವೇ ಅಲ್ವಾ?
ಏನು ಇಲ್ಲ. The judgment, the appellate court judgment is at page number, my lord. 23. It starts from page number 23. Point for determination is at page 28, ink page 28, point number 3. And all the points were taken up together for consideration, but no single reference is made to the application. Ultimately, the appeal got dismissed without reference to the applications.
Heard the appellant counsel. ಯಾರೆಲ್ಲರೂ ಉಮಾಶಂಕರ್ R1 and R2?
ಬೆಳಿಗ್ಗೆ ಇದ್ರು.
ಇದಾತ್ ಲೈಕ್ ರಿಮೈಂಡ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಡ್ಮಿಟ್ ಮಾಡೋ ಬದಲು ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಅಡ್ಮಿಟಿಂಗ್.
ಅದೇ that is the only point.
Let the first appellate court give a finding
ಅಷ್ಟೇ.
with regard to the additional documents.
It may be had tomorrow or it may be passed over, my lord, I'll get him.
First over ಬರ್ತಾರಾ?
ಇಲ್ಲೇ ಇದ್ರು, ಬೆಳಿಗ್ಗೆ ಇದ್ರು ಸ್ವಾಮಿ. ನನ್ನ ಹತ್ರನೇ ಮಾತಾಡಿದ್ರು, ಬೆಳಿಗ್ಗೆ ಇದ್ರು.
ನೋಡ್ ಪಾಸ್ ಓವರ್ ಮಾಡೋದು. ಪಾಸ್ ಓವರ್.
55 urgent 56.
ನಂಜುಂಡ್ ಸ್ವಾಮಿ.
Suit for partition. And separate petition filed by the other three sisters, my lord. The appellant is decreed. In respect of item number 1 to
1 and 2 ಮಾತ್ರ decreed.
Decreed
3 to 5 dismissed.
dismiss ಮಾಡಿದ್ದಾರೆ.
ಹಾ.
ಮತ್ತೆ against that, my lord, appeal is filed by appellant. The came to be dismissed. Against this judgment, my lord, this appeal is filed.
Appeal is by the plaintiff only?
My lord,
This is an appeal is filed by the plaintiff or defendant?
appeal filed by the defendant.
Defendant.
Defendant number.
Plaintiffs have not filed any appeal with regard to the dismissal of suit in respect of item number 3 to 5.
ಮಾಡಿಲ್ಲ.
ಮಾಡ್ಲಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ಹಾ. What is your grievance?
Grievance, my lord.
Only item number 1 and 2.
1 and 2.
ಹಾ.
ಇದರಲ್ಲಿ ನಮ್ ಕಂಟೆನ್ಷನ್ ಏನಂದ್ರೆ, ಆಫ್ಟರ್ ಡೆತ್ ಆಫ್ ಮೈ ಫಾದರ್, I being a elder sister, I married and my husband look after the appellants, the plaintiffs, and perform their marriages. And to that, my lord, they have relinquished their right in respect of item number 1, 2 properties, my lord.
Given up their right on the
right.
social property by executing the panchayat document.
Panchayat document.
Panchayat document ಅಲ್ಲಿ ಏನ್ ರೈಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತದೆ?
ಅದು ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. ಅದೊಂದೇ
ಹೆಂಗ್ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರ್ತ್ರಿ? ಹಾ? ಪಂಚಾಯತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಅದ್ರ ಮೇಲೆ ಹೆಂಗ್ ಮಾಡಕ್ಕದ?
ಅದೊಂದೇ ಇರೋದು.
ಒಂದೇ ಗ್ರೌಂಡಾ?
ಒಂದೇ ಗ್ರೌಂಡ್.
ನೋಡಿ. Heard the appellant counsel. First, ಅದಕ್ಕಿಂತ ಮುಂಚೆ this matter is listed for admission and I heard the appellant counsel. The factual matters of the case of the plaintiff before the trial court that plaintiff number 1 to 3 and defendant number 1 and 2 are the children of late Timegowda and late Mallamma. The social properties were ancestral properties of the father of the plaintiffs. The father of the plaintiffs have no male issues. After the male issues and father was in possession and enjoyment of the social properties, and after his death, the plaintiffs and defendant number 1 and 2 are in possession and enjoyment of the social properties. Defendant number 1 by colluding with the revenue officials got mutated her name in the revenue records of item number 3 to 5 properties. Then she sold the said properties in favor of the defendant number 3 without consent of the plaintiffs through registered sale deed dated 24/5/2014. The sale deed is not binding on the plaintiff in respect of the social properties. The defendant number 3, in order to deprive the legitimate share of the plaintiff in the social property, is making efforts to sell the suit item number 3 to 5 properties. Hence filed the suit for the relief of partition, contending that social properties are ancestral and giant family properties. The defendant took the specific contention that plaintiffs have given up their right on social properties by executing the panchayat document. And in order to discharge the loan raised towards marriage of the plaintiff and to provide maintenance to plaintiffs, item number 3 to 5 are alienated. The trial court, having considered both oral and documentary evidence, answered the Point, issue number 1 as affirmative in partly granting the relief of partition in respect of item number 1 and 2 and dismissed the claim of the plaintiff in respect of issue, item number 3 to 5. The same is challenged by this appellant before the appellate court. The appellate court on reappreciation of both oral and documentary evidence available on record confirmed the judgment of the trial court and hence the second appeal is filed. The main contention of the counsel appearing for the appellant is that both the courts failed to consider the material on record with regard to the respondent plaintiff given up her right in respect of item number 1 and 2 also. And court has committed an error. The counsel also vehemently contend that there is a panchayat document with regard to giving up of right of plaintiff, and the same has not been considered. Having heard the appellant counsel and also on perusal of material, particularly with regard to the pleadings of the parties and also the defense, and the very defense of the defendant number 1 to 3 is that plaintiff has given up their right in respect of the suit and properties by executing the panchayat documents. And admittedly, the said document is not the registered document, and no dispute with regard to the relationship between the parties. And defendant only produced the document of exhibit D1 to 8 RTC extracts and certified copy of mutation register extract, that is exhibit D9, and mutation register extract as exhibit D10. And though took the specific defense that plaintiff has given up the right by executing the panchayat document, and the said panchayat document is not placed before the trial court. And apart from that, the same is not the registered document. And when there is no relation, when there is no dispute with regard to the relationship between the parties and the properties are belongs to the late Time Gowda. And for giving up of her right also no such document is placed, and it is not the case of the appellant that any share is given in respect of the social properties in favor of the plaintiff. And when such being the case, in the absence of any legal document to prove that plaintiff has given up her right, and I do not find any error committed by the trial court and first appellate court in granting the share in respect of item number 1 and 2 of the social properties. And hence there is no any substantive question of law to entertain the second appeal invoking section 100 of CPC. You have the discussions made up by Pastor Karangoda. Second appeal is dismissed.
57 adjourned, reporting settlement 58, Sampath A, KP Bhuvan.
No settlement, my lord. There is no proposal from the appellant side.
No, my lord.
I'm always ready and willing to perform, ready to settle the matter. Since trial court ಇಂದ ಪ್ರಪೋಸ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಅವ್ರು ಇಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ 3-4 ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ನಮ್ ಕ್ಲೈಂಟ್ ಹತ್ರನೂ ಮೀಟ್ ಮಾಡಿಲ್ಲ, ನನ್ನ ಹತ್ರನೂ ಹೇಳಿಲ್ಲ ಏನ್ ಕೊಡ್ತೀವಿ ಅಂತಾನು.
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
I'm sorry, my lord, but my client side, my lord, one my lord lady Manjula ಅಂತ ಇದಾರಂತೆ. My lord, settlement talks have gone, my lord. They also instruct ಅವರು ಒಂದೇ I'm the purchaser of suit for partition. I'm the purchaser. Certain portion has been purchased, full amount ಕೊಟ್ಟು settle ಮಾಡ್ಕೊಂಡ್ರೆ one of the party, my lord, is not accepting ಅಂತ ಹೇಳ್ತಾರೆ, and they are asking full amount at a time.
ಆಯ್ತು, ನಿಮ್ದು ಏನ್ ಪ್ರಪೋಸಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಹೇಳ್ರಿ ಅವರಿಗೆ, ಅವ್ರು ಏನು ನೀವು ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ, ನಮ್ ಕ್ಲೈಂಟ್ಸ್ ಅವ್ರು ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಜಾಸ್ತಿ ಕೇಳ್ತಿದ್ದಾರೆ.
ನಮ್ದು ಇದ್ರಲ್ಲಿ 2 ಎಕರೆ ಬರ್ಬೇಕು ಇಬ್ಬರಿಗೆ ಅಪಿಲೆಂಟ್ಸ್ಗೆ, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ 2 ಎಕರೆಯಲ್ಲಿ 30 ಗುಂಟಾಸ್ ಕೊಡಿ, ಆರ್ 80% ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ಕೊಡಿ. 80% ಆಫ್ 20% ಏನು ಕೊಡೋಕ್ ರೆಡಿ. 5 lakh ಕೊಡ್ತೀವಿ, 10 lakh ಕೊಡ್ತೀವಿ. 1 per acre is more than 1.5 crores. ನೆಲಮಂಗಲ
ಪ್ರಾಪರ್ಟಿ
ನೆಲಮಂಗಲ
ಏನ್ ಸೂಟ್ ಫಾರ್
ಪಾರ್ಟಿಷನ್.
ಪಾರ್ಟಿಷನ್
ಹೌದು.
I'm the purchasers, defend number 5.
ಆಯ್ತು ರೀ, ಪರ್ಚೇಸರ್ ಆದ್ರೂ ಏನ್ ಮಾಡೋದು, ಅವ್ರಿಗೆ
ಇಲ್ಲ,
right ಇದೆಯಲ್ಲ.
they got a right. But
ಹೇಳಿ, ಏನು ಹೇಳಿ.
please, ಅದಕ್ಕೆ ಅವರು finally one lady
Finding ಏನು?
Concurrent finding.
So one lady, ಶ್ರೀಮತಿ ಮಂಜುಳಾ ಮಲೋಡ್, she is not ಅವ್ರಿಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ನಿಮ್ ಕ್ಲೈಂಟ್ when he is not coming forward to settle the matter, why we have to keep this matter?
No, ಅವರು settlement
Share each in the social property. Binding on the GPA dated so and so and sale deed dated so and so is not binding on the plaintiffs. Plaintiffs and sisters are
ಹೌದು ಸರ್.
Mamata, wife of Gangadhar, Uma Abhishek, son of late H.S. Manjula. Sale ಮಾಡಿದವ್ರು ಯಾರು actually property na?
Brothers.
Brothers and ಮಲೋಡ್ ಡಿಫರೆಂಟ್ 1 and 2 executed.
GPA 13/7/2005 GPA ಮಾಡಿದ್ರು 17/8/2005 ಅಲ್ಲಿ ಸೇಲ್
ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ರೋದು.
ಸೊ ನಮ್ಮ ಬ್ರದರ್ಸ್ GPA ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಡಿ.
ಯಾರಿಗೆ?
ಒನ್ ಮೋರ್ ಇಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 7 ಗೆ
ಡಿಪೆಂಡೆಂಟ್ ಹೇಳ್ಬಿಡಿ ಒರಿಜಿನಲ್ ಇದ್ರಲ್ಲಿ.
ಎಸ್ ಮೈ ಲಾರ್ಡ್. ವಿಜಯ್ ಕುಮಾರ್ ರೆಡ್ಡಿಗೆ GPA ಬರ್ಕೊಟ್ರು ನಮ್ಮವರು. ಆ ವಿಜಯ್ ಕುಮಾರ್ ರೆಡ್ಡಿ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಎ ಸೇಲ್ ಡೀಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಅಪಿಲೆಂಟ್ ನಾವು.
ನೀವು ಎಷ್ಟನೇ ಡಿಪೆಂಡೆಂಟ್?
ನಮ್ಮ ಫ್ಯಾಮಿಲಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 5 ಮಲೋಡ್. ಡಿಫೆಂಡ್ ನಂಬರ್ 4 ಗೆ GPA
ರವಿ ಆಚಾರ್ಯ.
ಪ್ಲೀಸ್ ರವಿ ಆಚಾರ್ಯ. ಡಿಫೆಂಡ್ ನಂಬರ್ 4 ಗೆ ದಿ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ GPA as acting on the
ಮೆಂಬರ್ಸ್ ಅಂತಂದ್ರೆ ಓನ್ಲಿ ನೀಲಕಂಠ ಸನ್ ಆಫ್ ಲೇಟ್ M.H. ಶಿವಣ್ಣ
ಅಷ್ಟೇ ಇಬ್ರೆ.
ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿ 1 ಪಾಯಿಂಟ್ ಏನಂದ್ರೆ ಸ್ವಾಮಿ ಜಸ್ಟ್ ಫುಲ್ ಓದಿಲ್ಲ ಸ್ವಾಮಿ. ಐ ಡೋಂಟ್ ವಾಂಟ್ ವೇಸ್ಟ್ ದ ಟೈಮ್. ಸ್ವಲ್ಪ ಓದಿ ಬಿಕಾಸ್ ಸೆಟಲ್ಮೆಂಟ್ 1 ಪಾಯಿಂಟ್ ಏನಂದ್ರೆ ಸ್ವಾಮಿ 5 acres 11 ಗುಂಟಾಸ್ ಇಸ್ ಸಬ್ಜೆಕ್ಟ್ ಪ್ರಾಪರ್ಟಿ ದೇ ಸಾಟ್ ಮೇಲೆ ಪಾರ್ಟಿಷನ್. ಅದರಲ್ಲಿ 2 acres and odd ಮಲೋಡ್ has been granted to one Siddhananjam and Basappa and one personal land tribunal. But still my lord, it is alleged that my lord, one of the family member is film actors, my lord, the revenue interests are still continuing in the propositor's name. Based on that, my lord, the revenue interests our mele ide ante my lord, the sort of partition. They are not disputed. The certain portion of the land has been granted to by the land tribunal. The land tribunal order has not been challenged by the land family members. My lord, this 2 acres and odd guntas, my lord, has been our bandu joining along with the family members, my lord, the common GPA has been executed. So one certain portion of the property is
whether they were having exclusive right to execute a GPA in favor of defend number 4. That
please,
is the question.
My lord, so adralli out of 3 acres, my lord, I may not have case because my lord, their family, some family members not joined. 2 acres and odd guntas, my lord, it has been that land, it's their family members' property that is granted to the 3 persons. Our namge land grant tribunal in the on their strength, they executed the sale deed. Our portion they cannot claim another short point. But the mistake, my lord, is what has been done is they were it has not been pleaded. That's the one ground, my lord. The plead madila and my lord. Unfortunately, my clients are not led in evidence. They only confronted the document that has been admitted. And another thing is that, my lord, certain family members is also not been added is also one partition.
ಇನ್ನಾರು ಮಾಡ್ಬಿಡ್ಬೇಕು, ಎಲ್ಲ ಮಕ್ಕಳದ್ದು ಮಾಡಿದಾರೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವರು ಒನ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 and 2 ಅದು ಅಭಿನಯ ಶ್ರುತಿ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ದೇರ್ ಇಸ್ ಆಲ್ಸೋ ಅನದರ್ ಸನ್ ನವೀನ್ ಅಂತ ಇನ್ ದೇರ್ ಓನ್ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಬಟ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಮೇಡ್ ಪಾರ್ಟಿ ಮಲ್ ಅಂಡ್ ಸಮ್ ಅದರ್ ಪರ್ಸನ್ಸ್ ಲೆಫ್ಟ್ ಔಟ್. So finally, I will ask my client whether he wants to settle it or not, or else I will argue and it could be.
This is all first time taking a defense before this court, my lord. He has not entered into the box. There is no defense in the trial court.
ಏನು ಮಾಡೇ ಇಲ್ಲ.
ಏನು ಮಾಡಿಲ್ಲ.
ಕೇಸು ನಡೆಸಿಲ್ಲ.
ಕೇಸು ನಡೆಸಿಲ್ಲ. Only cross examination
ಎಲ್ಲ ಮಾಡಿದ್ವಿ.
They have cross examined PW1.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ.
PW1 ಅನ್ನ
ನಮ್ಮನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್
ವಿಟ್ನೆಸ್ ಎಂಟ್ರಿ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ದಟ್ಸ್ ಓನ್ಲಿ ಪ್ರಾಬ್ಲಮ್.
ಇವಾಗ ಏನು
ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಿದೆ ಡಿಸೈಡ್ ಮಾಡೋದು?
Please, my lord, that's why I will finally ask them, my lord, or settle ಮಾಡ್ಕೊಂಡು. I already told, my lord, some
counsel for the respondent to submit that even though matter is urgent on several occasions for settlement, no proposal is given by the counsel or by the parties, even not met the respondents and given any proposal, and there is no any arrangement of settlement. The counsel appearing for the appellant seeks 1 week time to settle or argue the matter on merits, and hence finally an opportunity is given to either to settle it or to argue the matter on merits and list this matter on 13/6. ಮತ್ತೆ ಏನು ಕೊಡೋದಿಲ್ಲ.
Please.
ಮಧುಸೂದನ್ ರಾವ್ ನರಸಿಂಹ ಪ್ರಸಾದ್.
I am for respondent number 1 to 3.
Plaintiff's appeal.
Defendants 1 to 3 were are the sisters of the plaintiff's father.
Sisters are?
Plaintiff's father, that is paternal aunts. What had happened was these plaintiffs 1 to 3, so they were defendants 1 to 3, along with their mother, had filed a suit for partition and separate possession against the father of the plaintiff, that is Narayanappa, for partition. And admittedly, according to the case put forth by the plaintiffs, the properties are joint family properties. And in that suit, plaintiff was not a party, he was a minor at that particular point. What happened was, during the pendency of the suit was not properly contested. And the father, that is Narayanappa, on whom these people had a lot of undue influence, they could exert undue influence on the father of the appellant. They entered into, the matter was referred to mediation. Some compromise petition was filed. And on the basis of that compromise petition, properties were divided. Immediately after coming to know of the same, this particular decree was passed in the year 2008 itself, 2007. And immediately in 2009, after attaining majority, the plaintiff has filed a suit for a partition and separate portion, also for a declaration that this particular compromise decree has been obtained fraudulently, and it is not in the interest of the minor. And because he is the only son of the defendant number late defendant number 4 in that suit. So he had a half share by right by birth, that is his case. And in that background, he filed a suit for partition and separate portion. But the defendants, they denied the case, and the trial court dismissed the suit. Both the first appellate court and trial court have dismissed the suit, mainly on the ground that the father was represented, he has taken the share, you have half share in it. So the various aspects which are the first appellate court takes another view saying that because the compromise is entered into before the Lok Adalat, suit is not maintained. That is applicable only in a
separate suit is not maintainable.
Suit is not made. That's principle.
Now the substantive question of law is framed by this court is when the plaintiff was not a party to the said compromise.
Yes.
There cannot be any bar to file a separate
suit. Apart from that Lok Adalat concept would apply only in a scenario where plaintiff would have been a party to the suit. And the first trial court also, the approach of the trial court also is patently illegal in the sense the trial court holds that since the father has already represented, he has taken the share. Our case was, even though apparently it looks that the properties are equally divided, the daughters have taken, the sisters that is paternal aunts, they have taken better lands and all that. This was a matter for trial. That should have been looked into. But the courts below don't look into this particular aspect, and both of them have dismissed the suit. The reasoning of the trial court, your lordship may kindly see. From 67 onwards, Millard, in the appeal papers, in page 67 onwards, the reasoning is there. And yes, the
paragraph number?
Paragraph 11 onwards. The plaintiff has specifically contended that the suit schedule properties are the ancestral properties of plaintiff and 4 defendants. Accordingly, defendants, the suit schedule properties are the ancestral properties of plaintiff and defendants, and there is no dispute about the suit schedule properties. The suit schedule properties are the ancestral of the plaintiffs and defendants. The burden of proving that the suit schedule properties are divided, joint family properties of plaintiff and defendant number 4 is on the plaintiff. In fact, another contention that was raised before the trial court was, there was already a partition in which the properties were allotted to the share of the father. In support of that, a document was also marked in the course of the evidence, mutation register extract of the year 86-87, which indicate that these properties have been allotted to the share of the father. If those properties are already allotted to the share of the father, his sisters could not have claimed any share unless and until they questioned that partition. The suit schedule, then the defendants 1 to 3 have instituted a suit against 4 defendants in OS number 91 of 2006, contending that the suit properties are ancestral and joint family properties of defendants. The said suit was ended in the compromise. As per the compromise, preliminary decree was drawn and also possession has been taken in the final decree. The properties allotted to the share of fourth dependent, which is shown in the written statement of fourth dependent, are only ancestral and joint family properties of the plaintiff and fourth dependent. That was our case. The properties are, the fourth dependent is died. The plaintiff is entitled to a share which is allotted to fourth dependent on one OS number 91 of 2006. But the plaintiff failed to prove that the entire suitable properties are the ancestral and joint family property. This is all the consideration of the material. The plaintiff specifically contended that the compromise petition dated 16/6/2007, preliminary decree 29/6/2007, and the final decree engrossed on the stamp paper on 9/6/2008 in OS number 91 of 2006 are null and void and are liable to be set aside. Admittedly, the dependent or the son, dependents are son and daughters of Nagappa. The daughters are entitled to equal share to that of the father and the brother as per the amendment to the Hindu Succession Act 2005. The said suit ended in a compromise. 1/4 share is allotted to the share of the plaintiff's father, and preliminary decree and final decree was also drawn. Defendants 1 to 3 have taken possession as per the respective shares. The plaintiff and his mother are entitled to the share in the fourth dependent's property as allotted in OS number 91 of 2006. Plaintiff has failed to prove that the sisters of the marriage of his father are not entitled to share after their marriage. There are no grounds to set aside the compromise decree and final decree. This is the approach. Absolutely no evidence is considered. Documents relating to the earlier partition which were produced were not considered. The fact that in the earlier suit there was no adjudication on merits was not considered. And in issue number 3, the plaintiff has, this is how the court has approached this. The plaintiff has instituted the suit for half share in the suit schedule properties by meets and bounds, but the fourth dependent took his 1/4 share in a compromise decree passed in OS number 91 of 2006. The entire suit schedule properties are not joint family properties of the plaintiff and fourth dependent. The fourth dependent is died. The suit of the fourth dependent is abated. The properties allotted to the fourth dependent in OS number 91 of 2006 goes to the share of the plaintiff and his mother. The plaintiff is not entitled for half share, and he and his mother are entitled to entire share allotted to the fourth dependent. This is how the trial court deals with the case. So the first appellate court, it para 29, Ink page number 58, Under section para 29, under section 21(2) of the Legal Service Authorities Act 1887, every award made by the Lok Adalat shall be final and binding on all parties to the dispute. Your Lordship got it, that relevant portion.
Yes.
All parties to dispute, and no appeal shall lie to any court against the award. Therefore, the compromise entered into between the parties before the Lok Adalat cannot be challenged before any court. In view of my above said observation regarding the facts, the plaintiff has failed to prove his case that his father has not properly represented his interest, as his branch was represented by his father, and consent of either the plaintiff or the plaintiff presently appellate number 4A is not at all necessary at the time of the complaint. This is how it has been done. This cannot be applicable in a scenario where the properties are the ancestral properties, and in a situation where the plaintiff has a right by birth in the joint family. So there is no delay on the part of the plaintiff within the period of limitation. On the day when he filed the suit, he was just 19 years. So under these circumstances, my respectful submission is the entire approach of the court below is patently incorrect. And of course, another aspect is who are among the daughters. If a daughter is already married prior to 1994, whether she would have been entitled to a share or not. And the earlier partition which we have referred to, which has been produced by means of a exhibit, kindly see among the exhibits which you have produced, there is a mutation register extract which has been produced, which indicates that in the year 86.
Originally property belongs to plaintiff
Nagappa, that is Nagappa and his brothers. Nagappa is the grandfather of the plaintiff and father of Narayanappa. And there was a partition between the brothers of Nagappa and Narayanappa. Oral partition.
Plaintiff grandfather is Nagappa.
And the properties were the joint family properties of Nagappa. I mean, some of these properties, some of the joint family properties of Nagappa and his brothers. There was a partition that was effected amongst the brothers of Nagappa, to which Narayanappa was a party. And the properties were allotted to Narayanappa, that is my father's share. See, if that is, as long as that partition is not challenged.
Plaintiff father name is Narayanappa.
Narayan. He was defendant number 4 in the present suit also. So in that background, madam, my respect is kindly see this exhibit, one document which I would like to draw your exhibit E16, madam. It is a mutation register extract which has come into existence at an undisputed point of time. This is pertaining to MR number MR number 5/8687. That mutation register.
What it reflects?
It reflects that certain the properties were allotted to the share of Narayanappa in a partition.
In a partition between whom?
Between the Narayanappa and his paternal uncles.
And his paternal
uncles. That is, by then Nagappa had died. That is father of
Nagappa died
Narayanappa.
and his brother.
He was given share. So MR was affected as long as in the year 86-87 itself. So all these issues were tribal issues. What would have happened had Narayanappa contested the suit and protected the interest of the minor son, that is the plaintiff before this court, is different altogether. Had there been an adjudication on merits of the case, it was different. There was no adjudication on merits of the case. A compromise was entered into, they divided the properties. And my specific case is Narayanappa was not taking care of the family of the plaintiff and he was not taking care of the wife also. And
how many children Narayanappa was having?
Only one son.
Only one son.
And his mother, his wife is there. She is respondent number 4 before you. Mother. I'm talking about the mother of.
Narayanappa is having wife also.
Narayanappa died in the pendency of
the
this.
wife is alive.
Wife is alive. That is respondent number 4 before you.
Respondent number 4.
My learned friend represents her. In this background, my respectful submission is the case where the approach of both the courts is patently incorrect, is my respect. And the suit ought to have been considered on merits and the entire questions ought to have been decided. And trial court goes on a tangent, it only comes to the conclusion that there is already a partition, father has taken the share, you are entitled to a share in that. That's all.
Sir, yes.
In this case, my lord, the Nagappa's brothers, the property was standing in the name of the Nagappa's father.
Nagappa's father.
Nagappa's father. Nagappa's heirs, Nagappa's and their brothers have been partitioned. Since Nagappa was there not alive, the properties were allotted to Narayanappa on behalf of Nagappa. Properties belongs to Nagappa. There is no dispute. The Nagappa's children are these Bhagyamma, Radhamma, Thayamma, 3 daughters, and Narayanappa. Narayanappa. These 3 sisters have filed a.
That means Nagappa died.
Please.
Leaving behind 4 daughters.
3 daughters.
3 daughters.
And a son. Respective shareholders have been put in possession of the property. At that stage, this plaintiff in this proceedings, that is the son of Narayanappa, he filed a suit, OS number 4/2009, declaring that this judgment of OS number 91/2006 is not binding on him on the ground that the valuable properties are all allotted to these daughters, their aunts.
That is his paternal aunts.
Paternal aunts, and a very one survey number is allotted to him. In fact, it is not so. As per the final decree proceedings, major share was allotted to Narayanappa only. Minor share shall be given to this paternal aunties. Bhadyamma, Radhamma, Tayamma. Have been allotted 10 guntas in survey number 100/P5, in which Narayanappa has allotted 20 guntas. And survey number 104/2, in which 2 acres 20 guntas was allotted to Bhagamma and 1 acre allotted to Radhamma. So far as Narayanappa is concerned, survey number 118/1P, 18 guntas, this already stated that 20 guntas has been allotted in 100/P5. Survey number 62, 18 guntas, 62/2EP, 37 guntas coconut tree garden land. Survey number 62/2AP, 3.08 guntas coconut trees. These are appeal has to be dismissed. Now Narayanappa has got 1/4 share. For 1/4 share, we have no objection. The courts has also held that so far as Narayanappa's share, his LRs will be entitled. Therefore, the suit has.
In reply to me too, I will not take more than 5 minutes. So far as the contention that Narayanappa was entitled to 1/4 share, the daughters are entitled to 1/4 share, etc. On these aspects, there is no adjudication in the earlier proceedings. What is that share to which these people are entitled to? What is the nature of the properties and all? Second thing is materials on record indicate that in 86, 87 itself, there has been a partition. No doubt it was not a registered partition, but still the partition.
That partition between whom?
Between Nagappa and others. Nagappa's son and Nagappa's brothers.
Yes.
Correct. I do agree. But what I am submitting is, question would be, what is the nature of the rights of these daughters? Whether they are entitled to equal share or not. What is the nature of the share to which they are entitled to? If there were to be an adjudication and evidence was recorded in the earlier proceedings, we had no case. Unless and until there was a proper adjudication of the rights of the parties, the courts cannot come to the conclusion that both the courts could not have come to the conclusion that no, they are entitled to 1/4 share.
This suit is of the year 91/2006.
Yes, but
subsequent to the amendment.
The suit is after 2000 amendment only. Correct. Question would be again after amendment also, if the daughters are already married prior to 1990, if any of the daughters are married, to what extent they are entitled to?
Even if they are married, if there was no any partition in the family,
again what
they are
happened?
entitled.
Under the Karnataka Act, under the Karnataka Amendment.
Karnataka Act 1994.
1994 Act, what was the position was, if as on the date on which the Act came into force, if the daughters are already married, they were not entitled to the share.
But what about subsequent, the
2005 amendment has come. What I am submitting again, there are several other judgments also. There is one judgment of this honorable court of His Lordship Justice Arun, wherein he has held that they cannot claim a share, even by virtue of subsequent 2005 amendment. There is one more judgment of the division bench of this honorable court, which prior to Vinita Sharma's case, wherein this honorable court has taken.
What now Supreme Court says?
Supreme Court has not
Supreme
really.
Court
My
judgment is the
respectful
ultimate
submission is
now.
this minute. Supreme Court, even in Vinita Sharma's case also, has not really dealt with this effect of the 2005 amendment on Karnataka amendment. And that too be in a scenario where this honorable court, His Lordship Justice Jagannathan's judgment also, he says it is overruled from the date on which the Act came into force, 2005 Act, implied repeal. So in that background, as on 2005, if they have already lost their rights, but whether they are entitled to honor. Well, my respectful submission, going back to all these things, we are arguing in a scenario where there is no evidence on record, no adjudication on record, on merits. So my respectful
Because
submission.
parties have agreed and compromised the matter, that is.
That
their
that
reason,
compromise,
their
I can always question that,
adjudication.
I can always.
How you
question-
can expect an adjudication with
binding on me is the question. Whatever may be the share that is allowed. First of all,
now the question is with regard to the entitlement is concerned.
entitlement and whether
I'm not disputing the fact that property is an ancestral property.
yes, there is no, they can't be any
The
dispute. I don't-
property originally belongs to the father of the Nagappa.
all that there is no
Only-
serious dispute because we ourselves have contended that there was a partition in 86, 87.
86, 87.
86, 87.
Between whom?
Between Narayanappa and his uncles.
Narayanappa and?
His uncles. That is there. What I am submitting is all these things we are, I mean, for that we not in the earlier suit, there should have been adjudication.
When the matter is compromised, how a court can?
So if there is no
adjudicate it?
adjudication, if there is no adjudication, and if the matter is compromised, and if the compromise is on account of an undue influence exerted by the sisters on him, whether the son, who was minor at that particular point of time, is he bound by, your lordships are aware. There are-
Maybe this is an error by the trial court that.
There are
suit-
several
suit
judgments.
itself is not maintainable because of plaintiff is not a party to the compromise. Sixty. From Shivamogga Mediation Center. Mediation Center ಏನಾಯ್ತು?
Mediation.
ನಿಮ್ ಪಾರ್ಟಿ
It is in progress ಅಂತ ಕೇಳಿದೆ. It is in progress.
ಇನ್ನು ರಿಟರ್ನ್ ಆಗಿ ಬಂದಿಲ್ವಾ? ಮೇಡಮ್
ಬರ್ಲಿಲ್ಲ.
ಬಂದಿಲ್ಲ? ಏನಾಯ್ತ್ರಿ ನಿಮ್ ಪಾರ್ಟಿ?
ಇಲ್ಲ ಮೀಡಿಯೇಷನ್ ಕರೆದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಮೀಡಿಯೇಷನ್
ರೆಫರ್ ಆಗಿದೆಯಲ್ಲ ಮೀಡಿಯೇಷನ್ ಶಿವಮೊಗ್ಗ ಸೆಕ್ಟರ್ಗೆನ? Date fix ಆಗಿದೆ.
kindly date may be fixed. And I will.
ಇಲ್ಲ.
Told.
Specific
Await
date was-
report from Shivamogga Mediation Center and registry is also directed to get the report from the Mediation Center of Shivamogga and list this matter. ಬಂದಿದೆಯಾ? ಅದಾಗಲೇ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ. Parties are directed to appear before the Shivamogga Mediation Center, Shivamogga on 28/6/23. ಒಂದು ವರ್ಷ ಆಗೋಯ್ತಲ್ಲ. ನೀವಿಬ್ರು ಹೋಗ್ಲಿಲ್ವಾ?
ನಮ್ಮವ್ರು
Instructions ಇಲ್ಲ.
ನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ನಿಮ್ಗೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ.
ಕೇಳಿದೆ
ಬಟ್ ಅವರು ರಿಪೋರ್ಟ್ ಕೊಡ್ಬೇಕಲ್ಲ ಮೇಡಮ್. Mediation Center.
ಫಿಕ್ಸ್ ಎ ಡೇಟ್ ಮಲ್ಲಡ್ ಐ ವಿಲ್
ಅವರು
ಇನ್ಫಾರ್ಮ್ ದ
ಕೊಟ್ಟಿಲ್ಲ.
ಪಾರ್ಟೀಸ್.
The registry is directed to get the report from Mediation Center Shivamogga and list this matter on 13/6.
ಲಕ್ಷ್ಮಿ ಕೈಂಡ್ 12th or 14th ಮಲ್ಲ 13th is.
ಆಯ್ತು 12th ಆಗ್ಬೋದಾ?
14th.
Please.
ಆಯ್ತು 14th. ಏನ್ ಮೇಡಮ್ ಏನ್ ಹೇಳಿದ್ರಿ? ಕೊಟ್ನಲ್ಲ ರಿಸರ್ವ್ ನೋಟ್ಸ್
61.
ಇಲ್ವಾ ಮೇಡಮ್ ಅಲ್ಲಿ ನೋಟ್ಸ್?
ಒಳಗಡೆ
ಅಲ್ಲೇ ಒಂದ್ ಬೇರೆ ಶೀಟ್ ಕೊಟ್ನಲ್ಲ ಮೇಡಮ್ ಅಲ್ವಾ ನೋಟ್ಸ್?
ಇಲ್ಲಿದೆ.
ಹಾ
61 PH ವಿರೂಪಾಕ್ಷ.
ವಿರೂಪಾಕ್ಷಯ್ಯ PH.
Like to appear for
ವಿಕಾಸ್ M.
I'm for the defense. Ready, my lord.
ಆಯ್ತು ಹೇಳಿ.
In this case, my lord, I pray for 2 weeks time, my lord. Reason is
my lord, by mistake, my lord, plaintiff's documents have not been included in the paper book. And those documents I am also not having. That's why I seek 2 weeks time.
ಪೇಪರ್ ಬುಕ್ ನೀವೇ ತಾನೆ ಫೈಲ್ ಮಾಡಿ.
ಹೌದು. By mistake, no, not even a single document of plaintiff is.
ಆಯ್ತು, ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ಅದ್ರ ಮೇಲೆ
ಇಲ್ಲ, ನಾನು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು.
I have it, man.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ, ಅವ್ರ ಹತ್ರ ಇದೆಯಾ ಅಂತ.
ಅದೇ ನನಗೆ
ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಿದವ್ರು ನೀವು.
ಹೌದು.
ಯು ಕೆನಾಟ್ ಫೈಂಡ್
ಬೈ ಮಿಸ್ಟೇಕ್.
ಈಗ ನಾವು ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ? ನೋಡಿ, the appellant counsel seeks time on the ground that he is not having exhibits. And also the same is not the part of paper book. And hence finally, give
2
him
weeks time.
2 weeks time, list this matter on 13/6. ಅಷ್ಟೊಳಗೆ ತರ್ಸ್ಕೋಬೇಕು ನೀವು.
ಹೌದು.
ಏನ್ ಸೂಟ್ ಫಾರ್ ಇಂಜೆಕ್ಷನ್ ಏನು?
Declaration injunction.
Divergent.
62.
62. GB Shastri, M. Shivaprakash.
M. Shivaprakash for R123. Yes, madam.
Seek time, my lord.
Okay.
Senior has some personal inconvenience.
Suit for partition, madam.
Yes, madam.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ನನಗೆ ನಿಮ್ ಸೀನಿಯರ್ ಬರ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್, ದಟ್ಸ್ ಆಲ್. ನನಗೇನಿಲ್ಲ, ನೆನ್ನೆ ಎನ್ರೋಲ್ ಆಗಿ ಬಂದು ನಿಂತ್ಕೊಂಡ್ರು ಐ ವಿಲ್ ಹಿಯರ್. ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ. ಪಾರ್ಟಿಷನ್ ಸುಟ್ಟು ಏನಿರುತ್ತೆ, ವಾಟ್ ಈಸ್ ಎರರ್ ಅನ್ನೋದು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿ. ನೀವು ಈಗ ಆಲ್ರೆಡಿ ಸಬ್ಸ್ಟ್ಯಾಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಆಗಿದೆ, RSA ಅಡ್ಮಿಟ್ ಆಗಿದೆ, ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ.
I'll prepare and come, my lord.
ಏನ್ ಪ್ರಿಪೇರ್ ಮತ್ತೇನ್ ಮಾಡಿರಿ? ಇವಾಗ ಸೀನಿಯರ್ ಇಲ್ದಾಗ ನೀವು ಮಾಡ್ಬೇಕು. ಯು ಹ್ಯಾವ್ ಟು ಗ್ರಾಬ್ ದಿ ಆಪರ್ಚುನಿಟಿ. ಸೀನಿಯರ್ಸ್ ಗಳು ಇದ್ದಾಗ ಜೂನಿಯರ್ಸ್ ಹ್ಯಾವ್ ಟು ಗ್ರಾಬ್ ದಿ ಆಪರ್ಚುನಿಟೀಸ್ ಅಲ್ವಾ? ಮತ್ತೆ not read the papers. ಎಲ್ಲಾನು ಸೀನಿಯರ್ ಮಾಡೋದಾದ್ರೆ ನೀವೇನ್ ಮಾಡ್ತೀರಿ? ನೀವ್ ಕಲ್ತ್ಕೊಳ್ಳೋದೇನು? ಏನ್ ಮೇಡಮ್, ಆರ್ ಯು ರೆಡಿ? Are you ready?
No, my. No, my.
You are also not ready.
Apologize.
I'm the different number.
ಡಿಪೆಂಡೆಂಟ್ ಆಯ್ತ್ರಿ, ನೀವು ರೆಡಿ ಇದ್ದೀರಾ ಅಂದೆ. ಸಬ್ಸ್ಟ್ಯಾಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಏನು ನೋಡಿದೀರಾ? ಬರ್ಕೊಂಡಿದ್ದೀರಾ? ಸಬ್ಸ್ಟ್ಯಾಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಅಂತ ಕೇಳಿದೆ ನಾನು. ಎಲ್ಲಿದೆ ಸಬ್ಸ್ಟ್ಯಾಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ? ನಿಮ್ಮ ಹತ್ರ ಫೈಲಲ್ಲಿ. ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಿರ್ರಿ?
Respondent number 1 and
1. What is the substantive question of law? Whether the suit for partition can be dismissed on the basis of unregistered partition. Exhibit D1 and D2, which prima facie are compulsorily registrable. ಅಷ್ಟೇ ಇರೋದು. That is the only issue, substantive question of law. Second one is whether the courts below have committed a legal error of great magnitude in not granting decree in respect of properties. This is substantive question of only substantive question of law, only one.
Exhibit D1 and D2.
ಅದೇ ಹೇಳಿ, ನೀವು ಹೇಳಿಲ್ಲ, ನಾನೇ ಓದ್ಬಿಟ್ಟು ಹೇಳಿ. ಕಂಟೆಸ್ಟಿಂಗ್ ಯಾರು ಇದ್ರಲ್ಲಿ? ಯಾರಿಲ್ವಾ? ನೀವು ಒರಿಜಿನಲಿ ಪ್ಲೇಂಟಿಫ್ಸ್
ಅಲ್ಲ, ಡಿಪೆಂಡೆಂಟ್ ಇದೆ.
ಡಿಪೆಂಡೆಂಟ್ ಗೆ ನೀವು ಡಿಪೆಂಡೆಂಟ್ ನೀವು
Dependent number 2A3, A23.
It's concurrent finding actually. So plaintiffs are the appellants.
plaintiffs appeal. ನೀವೇ ಹೇಳ್ಬೇಕು ಮೇಡಮ್. ದೆನ್ D1 and D2 document.
My lord, in the suit, what happens is the.
ಆಯ್ತು, 2 ದಿವಸ ಟೈಮ್ ಕೊಡ್ತೀನಿ, ನೀವೇ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
Yes.
ಮತ್ತೆ ನಿಮ್ ಸೀನಿಯರ್ ನಿಲ್ಸಂಗಿಲ್ಲ. ನೋಡಿ, appellant counsel seeks time and counsel for the respondents are also present, and even respondents counsels are also not ready, and hence opportunity is given to the respective counsels to assist the court. List this matter on 13/6.
My lord, interim order is to be.
Interim order ಏನು?
There is
Not to draw the final dismissal suit. ಅದ್ರೇನು interim order ಇದೆ?
My lord, on 7/9/23 there is.
ಇದೆಯಾ ಮೇಡಮ್? ಏನು interim order?
The respondent are restrained from alienating or encumbering or otherwise changing the nature of the suit property till next date of hearing.
ಇದೆಯಾ? ಆಯ್ತು, interim order granted is extended till next date of hearing.
Yes.
63 urgent, 64 urgent,
Urgent
65. Hmm?
Vishwanath Shetty V.
Regarding IFR sat for amendment.
ನೀವ್ ಯಾರಿಗೆ?
Appellate submission.
ಹಾ.
ಒಂದು
ಅಯ್ಯ 1/21 for amendment filed by
Amendment.
council for appellant. ನೀವೇ amendment application ಹಾಕಿದೀರಾ?
ಹೌದು ಸರ್,
ಹಾ. ಏನ್ amendment?
ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಂದ್ರೆ ಸಾಟ್ ಫಾರ್ ಡಿಲೀಟ್ ದ ಪ್ಯಾರಾ ನಂಬರ್ 32-51 my lord.
32 and 51 of?
51 ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್? ಪ್ಲೈಂಟ್ ಅಲ್ಲ?
ಹೌದು ಗ್ರೌಂಡ್ಸ್ ಹೌದು.
Whether admitted fact can be deleted?
ಡಿಲೀಟೆಡ್.
Whether admitted fact can be deleted ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ. ನೀವು ಅಲ್ಲಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಬಿಟ್ಟು ಈಗ ಡಿಲೀಟ್ ಮಾಡಿ ಅಂತಂದ್ರೆ?
ಡಿಲೀಟ್ ಮಾಡಿ, ಯಾಕಂದ್ರೆ ಇನ್ಅಡ್ವರ್ಟೆಂಟ್ಲಿ
ಯಾರು ಇವ್ರು ಯಾರು ನರೇಂದ್ರ ಗೌಡ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕೋರು ಹೇಗೆ?
ಇಲ್ಲ ಸರ್, ಅವ್ರು ಯಾರು ಯಾಕಂದ್ರೆ
ಇದಾರಲ್ಲ R1 ಗೆ
ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ.
ನೀವು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಿರ? ಅಯ್ಯ 1 of
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರು
ಮಾಡಿದಿರಿ?
ಮಾಡಿದ್ರು.
ಮೇಡಮ್ ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ. ಅಯ್ಯ 1 of 21.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ. ಆಮೇಲೆ ಏನ್ ಸರ್ವ್ ಮಾಡಿದೀರಾ?
ಅಲ್ಲ ಇದು ಪ್ರೆಸೆಂಟೇಶನ್ ಫಾರ್ಮ್ ಅಲ್ಲಿ ನೋಡಿ ಸರ್ವ್ ಮಾಡಿದಾರ ಇಲ್ಲ ಅಂತ.
ಇಲ್ಲ, ಅವರು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರೆ ಅದಕ್ಕೆ.
ಹಾ.
ಆಮೇಲೆ ಏನಾದ್ರು ಸರ್ವ್ ಮಾಡ್ತಿದ್ದಾರೆ? ಇಲ್ಲ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ. ಆಮೇಲೆ ಏನಾಯ್ತು ನೋಡಿ, ಅದು ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಆಮೇಲೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಅವರು ಅಪಿಯರ್ ಆಗಿದ್ರು
ಉಮಾಶಂಕರ್ ಆರ್ಡರ್ 41/27 ಮೇಲೆ though point for consideration is framed, no discussion, nothing, nothing.
Discussion ಇಲ್ಲ ಅಂತ. Question is, my lord, whether those documents are necessary for decision.
ಅದೇ ಅದು ನಾವು ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್.
ಅಲ್ಲ ಈಗ my lord, their contention is, my lord, properties were purchased benami in the name of wife ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. There is no evidence to show that he has paid the amount. And my lord, both the courts have held that.
ಸೆಕೆಂಡರಿ.
Please, my lord.
ಆಯ್ತಲ್ಲ, ಆರ್ಡರ್ 41/27 ಇನ್ವೋಕ್ ಮಾಡಿದ್ಮೇಲೆ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಪಾಯಿಂಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್
ಅವರು ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾಗಿತ್ತು, ಹೇಳಿಲ್ಲ.
ಹೋಗ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ಬೇಕೋ ಇಲ್ವೋ?
ಮಾಡ್ಬೇಕು.
ವೆದರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ನೆಸೆಸರಿ ಫಾರ್ ಕನ್ಸಿಡರಿಂಗ್ ಜರ್ಮಾನೆ ಇಶ್ಯೂಸ್ ಇನ್ವಾಲ್ವ್ ಬಿಟ್ವೀನ್ ದಿ ಪಾರ್ಟೀಸ್ ಆರ್ ನಾಟ್ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಫೈಂಡಿಂಗ್ ಕೊಡ್ಬೇಕೋ ಬೇಡ?
ಅದೇ
ಅದಿಲ್ಲಲ್ಲ.
ಅದೇ ಕರೆಕ್ಟ್ ಮೇಡಮ್. ಇವನ್ ನೀವು ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಯಾನ್ ಲುಕ್ ಇಂಟು ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ನೀವು ನೋಡಬಹುದು ಸರ್.
ಅಲ್ಲ ನಾನ್ ನೋಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಐ ಕ್ಯಾನಾಟ್ ಸಿಟ್ ಅಂಡ್ ಡಿಸೈಡ್ ಇನ್ ಎ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ವಿತೌಟ್ ದಿ ರೀಸನ್ಸ್ ಅಸೈನ್ಡ್ ಬೈ ದಿ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್. ಮ್ಯಾಟರ್ ರಿಕ್ವೈರ್ಸ್ ರಿಮ್ಯಾಂಡ್ ಓನ್ಲಿ.
ಅದೇ ಈಗ
ಟೈಮ್ ಬೌಂಡ್ ಮಾಡೋಣ, ರಿಮ್ಯಾಂಡ್ ಮಾಡೋಣ, ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ, ಒಪಿನಿಯನ್ ಮಾಡ್ಲಿ, ಅದ್ರ ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಬರಲಿಲ್ಲ ಅಷ್ಟೇ.
Even documents are not.
ಅದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಮ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಯಾವ್ದ್ರದ್ದು? ಇಲ್ಲಲ್ಲ, ಅಲ್ಲಿ ಹಾಕಿರೋದ್ರಿ. ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ 41/27 ಹಾಕಿದ್ರು. ಇಲ್ಲ ಇಲ್ಲಿ ಹಾಕಿರೋದಲ್ಲ. ಹಾ,
ಇಲ್ಲೂ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. ಇಲ್ಲ ಹಾಕಿರೋದು ನಾವೀಗ ಕನ್ಸಿಡರ್ ಮಾಡೋದಿಲ್ಲ. ರಿಮ್ಯಾಂಡ್ ಬೇಕಾದ್ರೆ ಅವ್ರಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಮತ್ತೊಂದ್ಸರಿ. ರಿಟರ್ನ್ ಕೊಡ್ತೀನಿ.
ದಟ್ ಇಸ್ ಕರೆಕ್ಟ್ ಮೇಡಮ್. 100% ಕರೆಕ್ಟ್. ಎಲ್ಲೂ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಿಲ್ಲ, ಹೇಳು ಇಲ್ಲ, ರೀಸನ್ಸ್ ಇಲ್ಲ.
ಅವ್ರು ಹೇಳಿದ್ಮೇಲೆ ನಾನು ಓದ್ದೆ.
ಇಲ್ಲ
ನೋ ವೇರ್ ಡಿಸ್ಕಷನ್ ಅಟ್ ಆಲ್.
ಇಲ್ಲ, ಆದ್ರೆ ಏನಿದೆ ಅಂತಂದ್ರೆ
ಆರ್ಡರ್ 41/27
ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಪ್ಯಾರಾ 21 ಅಲ್ಲಿ ಡಿಡ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್ ಆಫ್ ದಿ ಇಯರ್ 1991 ಅಂತ.
ನಾನು ಹೇಳೋದು ಏನಂದ್ರೆ, ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್, ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಒನ್ಸ್ ಟೇಕ್ ದಿ ಪಾಯಿಂಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್, ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಆನ್ಸರ್ ದಟ್.
ಆನ್ಸರ್ ಮೇಡಮ್.
ದೇ ಆರ್ ವೇಟಿಂಗ್ ಫಾರ್ ದಿ ಎಲಿವೇಶನ್ ಹೈಕೋರ್ಟ್ಗೆ. ಜಡ್ಜ್ ನೋಡ್ದೆ. ಎಲ್ಲರಿಗೂ ಎಲಿವೇಶನ್ ಬೇಕು, ಮತ್ತೆ ಕೆಲಸ ಮಾತ್ರ ನೆಟ್ಟ ಮಾಡಕ್ಕ.
ನಿಮ್ ಕಾಲಕ್ಕೆ ಹೋಯ್ತು. ಹಿಂಗಾಗಿದೆ ಈಗ.
ಹಂಗಾಗಿದೆ ಸ್ಥಿತಿ, ಹಂಗಾಗಿದೆ. ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ.
ಮಾಡ್ಬಿಡಿ ಹಂಗಾರೆ. ಈಗ
ಮಾಡ್ಬೇಕಷ್ಟೇ.
ಅದೇ 1 month ಟೈಮ್ ಕೊಟ್ಟು ಅಪಲೇಟ್ ಕೋರ್ಟ್ಗೆ
ಹಂಗೆ ಮಾಡೋಣ. ಶಾರ್ಟ್ ಟೈಮ್ ಕೊಟ್ಬಿಟ್ಟು ಅಪಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಕನ್ಸಿಡರ್ ಅಂಡ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಅಷ್ಟೇನೆ.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಮಾಡಿಬಿಡಿ.
ಅಷ್ಟೇ ಮಾಡ್ಬೇಕು, ಬೇರೆ ಏನಿಲ್ಲ.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ಗೆ
ರಿಟರ್ನ್ ಮಾಡ್ತೀನಿ. 1 second. ಏನ್ರಿ ಕೌನ್ಸಿಲ್ ನಿಮ್ದೇನು ಇರಲ್ಲ? ಏನಾಯ್ತು ಮೇಡಮ್?
ನಮ್ದೇನಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಬಿಡಿ.
ಮಾಡಿಲ್ವಾ? ಮಾಡಿದಾರ? ಕಾಪಿ ಸರ್ವ್ಡ್. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನ್ ಹಾಕಿಲ್ಲ. The appellant counsel is present and counsel for R1 is absent.
Only in respect of
absent. And the respondent number 1 has not filed any objections to A 1 of 21. And hence 2 weeks time granted to file objections if any. If objection is not filed, A 1 of 21 will be considered in the absence of the objections. And list this matter on 13/6. And if respondent counsel also doesn't appear in the next date of hearing, appeal will be considered in his absence. ಅಂತ ನಿಮ್ದು ಯಾವ್ದಾದ್ರು ನಂಬರು
54. 54.
ಅವ್ರದಾ ತೋಳ್
Number 62 madam.
ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿ
62 madam.
ಏನ್ 62?
2 ನಲ್ಲಿ present may be
ಹಾ?
R7 ಗೆ ತಿನ್ಸಿ.
62 ನಾ?
Yes.
13/6 ಗೆ ಆಯ್ತಲ್ಲ sir, ಅದು GB ಶಾಸ್ತ್ರಿ.
ಒಂದೇ
ಹಾ ಜಿ ಬಿ ಶಾಸ್ತ್ರಿ ಅವ್ರ ಡೇಟ್ ಹೋಯ್ತಲ್ಲ.
Then ಆಯ್ತು sir.
ಹಾ
By present.
ಹಾ
By present will be noted.
R7 ಗೆ ಹೋಗಿದ್ದಾರೆ.
ನೀವ್ ಇದ್ರ ಅವಾಗ
ಒಂದೇ sir.
ಬಂದಿಲ್ಲ ನೀವು ನಾನು ಡಿಕ್ಟೇಟ್ ಮಾಡೋವಾಗ ಇರ್ಲಿಲ್ಲ. ನೀವ್ ಇರ್ಲಿಲ್ಲ ಅವ್ರ 3 ಜನ ನಾನು ಕೇಳಿದೆ ನೀವೇನೋ ನೋಡಿದೀರಾ ಪೇಪರ್ ಓದಿದೀರಾ ಆಯ್ತು ಬಂದೆ. ಹಾ ಅಲ್ಲೊಂದ್ ಸೆಂಟೆನ್ಸ್ ಸೇರ್ಸ್ಕೊಂಡ್ರಿ.
Only 1 and 2.
ಕೌನ್ಸಿಲ್ 62 ನಲ್ಲೂ ಕೌನ್ಸಿಲ್ ಫಾರ್ R7 ಅಂತ ಅದೇ ನಾನು ಆ ರೀತಿ ಯಾರಿದ್ರು ಯಾರಿಲ್ಲ ಅಂತ ಏನ್ ಹೇಳಿಲ್ಲ. ನಾಟ್ ರೆಡಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ ಅಷ್ಟೇನೆ. ಅಷ್ಟೇ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. 13/6. ಹಾ
54. Please, madam.
RSA 664 of 22.
ಅದರಲ್ಲಿ only 2 documents, madam. My learned friend is referring 2 documents. Let there be a finding on the.
Third. Heard the appellant counsel and also the counsel appearing for the respondent.
In so far as the additional documents, my lord, here which is produced, Ilon 4127 ಹಾಕಿದೀನಿ. If another application is filed, my lord, because ಅದಾದ್ಮೇಲೆ subsequent to that, my lord, application which was filed before the trial court, there are another 14 documents which are produced for the first time before the high court.
Here.
ಅದನ್ನ ನಾನೇನಾದ್ರೂ that liberty may be reserved along with those 2 documents. These other 14 documents may also be considered.
ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಹಾಕೋಬೇಕು.
ಅದೇ ಅಲ್ಲಿಗೆ
ನಾವೇನ್ ಮಾಡಕ್ಕಲ್ಲ.
ಆಯ್ತು ಅಲ್ಲಿಗೆ ಹಾಕು.
ತಗೊಳ್ಳಿ ಏನಾಯ್ತು ಹೇಳಿ. Heard the appellant counsel and also the counsel appearing for the respondent. This matter is listed for admission and counsel appearing for the respondent brought to notice of this court that first appellate court, though framed the point for consideration of application filed under order 41 rule 27 of CPC as point number 3. And while considering the point for consideration 1 to 4 together, even not discussed anything about the provision of order 41 rule 27 as well as the additional documents which have been produced before the court.
Documents that is
ಮಾಡ್ಕೊಳ್ಳಿ ಬಿಡಿ.
And proceeded to pass the order on merits. The counsel also brought to notice of this court that in paragraph number 3 of the judgment of the appellate court, a reference is made with regard to the filing of an application under order 41 rule 27 of CPC. And having perused the entire judgment of the first appellate court also, even though point for consideration is framed as point number 3, nothing is discussed in the judgment. When the application is filed under order 41 rule 27, seeking permission of the court to permit them to produce the additional document, whether those additional documents are necessary for adjudication of the appeal or not. The first appellate court ought to have given the finding. And also it is settled law that the application filed under order 41 rule 27 has to be considered along with the main appeal. And when such discussion is not made, and counsel appearing for the respondent also not disputes the settled law that order 41 rule 27 has to be considered along with main appeal. And also admits that there is no any discussion in the judgment of the appellate court invoking of order 41 rule 27 as well as whether the appellant has made out the ground to invoke order 41 rule 27. And when such being the material and record and appellate court deciding the appeal without considering the point for consideration and proceeding is nothing but error apparent on record. And hence matter requires to be remanded to the first appellate court with a direction to consider the IA filed under order 41 rule 27 and decide the matter on merits, whether those documents are necessary for deciding the appeal on the Germany issues involved between the parties. And hence the impugned application or impugned judgment and decree of the trial court is liable to be set aside and matter has to be remanded.
Appellate court, my lord.
The trial court alna?
Appellate court.
Appellate court has to be set aside.
Appellate court. In view of the discussions made above, I pass the following order. The judgment and decree of the appellate court passed in and liberty is given to the appellant to seek the indulgence of the first appellate court, whether those documents are necessary or not for deciding the issues involved between the parties. ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎರಡು ಆರ್ಎಗಳನ್ನ ಒಟ್ಟಿಗೆ ಮಾಡಿದಾರ?
ಇಲ್ಲ ಮೇಲೋದ್ ಸಪರೇಟ್ ಮಾಡಿ, ಎರಡು ಸಪರೇಟ್ ಆಗಿ RF ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. OS ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದೆ. ದ ಫಸ್ಟ್
OS ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂದ್ರೆ ಎರಡು ಸೂಟ್ಸ್ ಇತ್ತಾ?
ಪ್ಲೀಸ್. It was clubbed together. One was for partition, my lords. The other was for declaration. ಎರಡನ್ನು ಕ್ಲಬ್ ಮಾಡ್ಬಿಟ್ಟು plaintiff ಅವರ wife and children filed a suit
that
for
common
partition.
judgment was questioned in
Please.
different appeals.
In two RAs, my lords.
And those two RAs are not considered together.
No, my lords. Separate ಆಗಿ consider ಮಾಡಿ separate RSS ಇದೆ. This is one RSA, the other RSA.
Same day judgment ಮಾಡಿದಾರ ಸೇಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಥವಾ ಬೇರೆ ಬೇರೆ ಡೇಟಾ? ನಿಮ್ನ ಹತ್ರ ಎರಡೂನು?
Please, my lords. Lords, RA 77, which is this, the present RSA, my lords, is decided on 23rd Feb 2018.
But same court.
Officer. Madam,